Can you raise your right hand? Do you swear affirm that the testimony you will give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Still in, have a seat. State and spell your name for the record.
Stacey, Stacy, David, David.
Good morning, Mr. David.
Morning.
How are you feeling?
Doing good, thank you.
You were on the stand yesterday and you were asked a few questions, and I'm going to be asking you a little bit more in detail. But one of the things that we didn't ask you yesterday was a little bit about yourself, just a quick elevator speech about who you are and where you come from, your work experience, and so on.
I am from South Georgia, Americus, Georgia. I grew up with my mom's a teacher. My dad was a salesman at the.
No, I'm sorry, respectfully, this is.
Sorry.
Kind of straight ahead.
Sorry. What part?
Actually, face the jersey if you want, but you need to be further back so you're closer to the microphone. I wouldn't, you're not gonna dictate which way you look, but
Yes.
you do need to be out.
Yes.
Okay.
Do I need to start over?
Oh, the teacher.
Okay. My mom was a teacher and my dad was a salesman at the local factory, for the local factory. The local factory. I was a school teacher until my daughter was born, and that was in 2006. And I am now a stay-at-home mother to 2 children.
And what school did you teach at?
I've taught at several schools. I taught at Elm Street Elementary in Noonan, Georgia, and I taught at at a private school in Noonan, Georgia, and then I also taught at Garden Hills Elementary here in Atlanta.
And what grades did you teach?
I've taught 3rd grade, I've taught kindergarten, I've taught gifted education.
And how old are your kids? Are they still kids, or are they, I guess they never stopped being kids?
Now, Lucy is 17 and Hopkins is 15 now.
And let's now focus on the house and your purchase of this house. In 2020, I understand that you bought this, what looks like a beautiful house on Habersham Road in Buckhead. Is that right?
This is right.
Can you walk us through the process from jumping from your last house to the decision to buy this house?
Yes. As newlyweds, we bought a tiny home that was tiny, a little 3-2 that was roughly 1,800 square feet. And we planned to live there 5 years. We lived there 17 years with both children. And as Lucy was getting older, we needed another bathroom. So we started looking. And we did look for quite some time. And we bought another house in the Garden Hills area. And quickly after living there, we just knew this is not for us. We needed more space in the yard. We needed more space. So my husband agreed, as long as you don't lose money, it's okay if we sell the house. But he was pretty strict to me about that. So my realtor and I got to work and we sold the house and started looking. And we found this house and fell in love with it.
It looks like a beautiful house, but do you agree it's not a tiny cracker box house, is it?
It's
Okay. How many bedrooms and bathrooms?
It has 4 bedrooms and it has 4.5 baths.
And it is on Habersham Road, is that right?
It is.
It faces on Habersham Road.
Yes.
How would you describe Habersham Road? Is it a pig trail or is it a highway or somewhere in between that?
It's a 2-lane road, but it's a very busy road. It's one of the main roads that comes into this part of town, into Buckhead. Heavy traffic from Roswell Road, coming from Roswell Road to take Habersham onto West Paces. It's lots of traffic.
I'm going to hand you an exhibit. It's defendant exhibit number 5 and ask you, you can take a look at this. Don't show it to anybody. I think that should be in our notebook.
It is. Looking at.
Mr. David, can you identify what that document is?
This is the easement agreement.
I'm looking at exhibit number 5, the document I just handed you. Right in front of you.
The easement agreement.
Is that an easement agreement?
This is the easement. This is the, what do you call this?
Is that,
Any words you want, but you need to call it something.
This is the black and white diagram of where the easements are. The black and white diagram of the house, what do you call this? The floor plan of the easements and the driveway.
does this?
Survey, this is the survey of the easements.
You're not on the witness stand every day, are you?
I am not.
Okay. Does this appear to be a survey that you had prepared that identifies the properties at issue in this case?
Yes, it is.
Your Honor, I would tender defendant's exhibit number 5.
Any objection to defense 5? Oh, amen.
Yes, Your Honor. There are colorings and markings and handwriting on this exhibit that we don't know whose they are. They
Why
don't-
don't we see, if you ask questions about that, but that's the concern.
I'm glad to ask her to describe what's on the face of this. Ms.
Just a
yeah,
second, Ms. Becker,
yeah.
I'm looking at what's written on there. Tell me what your concern
Right.
is. It doesn't seem like they're particularly problematic.
Certainly, however, I think that I would have a hard time believing that Mrs. David is gonna say that she created this survey. So, you know, where we're going with this, I'm not sure yet. And I don't know why it would need to be marked up this way because the survey would likely have marked it itself.
All right, I'm gonna allow it in. It's admitted.
You can pull up exhibit 5. Ms. David, before we spend half the day messing around with lines and drawings, why don't you come on down? So tell us what we're looking at here.
This is a survey of looking down at our house and our parking pad, easement 1, and here's easement 2. Here's Hattersham Road, here's West Andrews.
Okay. And now, so that the testimony is clear, the lot that is identified number 12, that's your lot, is that right?
Yes,
And the one with the number 11 on is the Anderson's lot, correct?
yes.
And there seems to be some color coding on this. What is the yellow or the ochre color? Is that the footprint of the house?
That's the footprint of our house, yes.
And now tell us what your understanding of if that's magenta, or what do you call that, red?
That is a parking pad
Yeah.
that matches our brick driveway and the brick wall around the parking pad. So when we pull into our driveway, it's narrow. This is where we park. This is where we back up. This is where visitors come in and park.
And was that part of the original house as you understood it?
It's the original brick that was actually brought in from England. And yes, it is the same and matches the house.
What's your understanding of the combination of these two lots, or the relationship historically of these two lots?
Objective form, Your Honor, or not objective form, objection, what's her understanding? I think we're gonna be getting into some hearsay territory.
Sure, so I understand the question, but I guess you might need to lay a foundation for
Sure.
how she would be able to talk about that so that Ms. Medwick can more precisely raise a concern.
Tell me what you understand was the history of the combination or separation of these two lots, if you have an understanding.
Objection, Your Honor.
Same issue. If her understanding, making this up, if her understanding came because the realtor said X, Y, and Z, then there may be a hearsay objection that Ms. Medwick wants to make, but she can't when you say, what's your understanding?
Okay.
So you can ask her, do you know how it came to be two lots? She can say yes, and then you can say, how do you know? And it may be that Ms. Medwick doesn't care if the answer is, the Andersons told me. Okay, great, I don't mind if that's what the Andersons told me. So
do you understand that these two lots were one lot at some point?
Objection, Your
and-
Honor.
Stop.
It's leading
So
and
two
it's,
things. It was leading, but we've already heard that it was once one lot and it's becoming two. So I can sustain it, but I just want you to be thoughtful about which things you're trying to do. So please don't ask leading questions and don't ask questions that could call for hearsay, but they're murky enough that Ms. Menwick doesn't know, and so she ought to object.
How have you come to understand that those two lots were at some point a single lot?
The original owner of the property.
objection, hearsay.
She hasn't
She hasn't
testified.
finished her answer. We're gonna be here through next month. Ms. David, without saying what people told you, how did you learn, how did you come to believe that this was once one lot rather than two?
I have the original property survey and deed from the original owner. His grandson brought it to our house shortly after we moved in.
Okay, stop.
Okay.
So with that explanation, will you be then answering Mr. Schneider's questions based on your review of that document or because of a conversation you had with a realtor or a surveyor?
I could do both.
I don't want you to do both. Mr. Schneider, you
Okay.
need to manage this.
Yes, Your Honor, I'll move on. I don't want to get sidetracked on
Please.
this
Can
issue.
you go back to the, or you need her in front?
I would like her in front because to me, it seems easier for her to manage unless that device is.
That's not, if you're still on this and you need her to point things out, then let's keep it right there.
Very good. So you've got the Andersons on the right under lot 11 and you on the lot 12, right?
Yes.
And you saw a photograph yesterday, I can't recall whether it was when you were on the stand or your husband was on the stand, of the beautiful brick parking area that had a very nice shed. You remember that? Is that this area that we're talking about?
Yes, the shed that he calls it, it's my garden house, is here.
Okay.
Right here.
And the maroon area right there, that was the area that your husband demarcated on that photograph or attempted to, is that right?
Yes.
Okay. And your understanding was all of that was part of the original
Objection,
construction?
Your Honor. These are very leading. I'm trying to be lenient
I
for the sake
appreciate
of
it.
time.
We're asking a ton of leading questions.
Yes, Your Honor, I'll move on and I'll not lead.
Okay.
Let's go back and you can have a seat so you're not, I know your knee is not well. So what were the other things while you're sitting down? What were the other things that were big considerations for you when you took a look at this house?
The yard, we loved the yard. It was like a secret garden in the backyard, literally, with overgrown trees that cascaded over. It was wooded on the side, so you could not see West Andrews. It was private. It gave us privacy away from other properties, which we had not had before. So we really enjoyed that. Both of our children play sports, so we looked forward to having them outside. We have dogs, so that was a big factor. We loved the style of the house. We loved looking out, and the living room has big floor to ceiling windows, and you can sit in the living room and feel like you're part of the backyard. And that was very enticing to us.
Stacey, I think we lost our. So when we were looking at that, at the house footprint, if you were talking about where you were looking out, you're looking out, that when you see the orientation here, you're looking south out of the back of the structure, right?
Yes,
The window wall there, right?
yes,
So.
to the right
these-
of the
Your
yellow.
question's in with right, question mark. You're probably asking a leading question. I don't want to make.
I know.
That would have to keep, this is your
Okay.
witness.
Agree, Your Honor, and I apologize, I'm trying to move too fast, so
Okay.
I'll add that. And can you describe for us what the landscape looks like in that back area?
It's like a secret garden. It now has a 6-foot plank fence running beside it. It had a brick wall came around and a brick patio that came around the back that is within the same decor and match of the house. It now is attached to a 6-foot fence, so we cannot see over that to see the wooded areas if there were any now. But a lot of old trees that hang over. They're overgrown and they're beautiful. It's all green back there.
Let me lead you back to exhibit number 5. The face of the house, the northern entrance to the house is directly on Habersham Road, correct?
Yes.
Were there any concerns that you had regarding having the drive being right on heavily trafficked road?
We were concerned. We didn't know how heavy the traffic was, and because we bought the house during COVID when there weren't many people on the roads. It is very heavy now, the traffic. And my concerns were the dogs getting in and out of the driveway is a concern, especially if you can't back up. If you have to back out of the driveway instead of turn around, it's hard.
And there were 2 colored areas on this map as well, maroon one and the blue one. What did you understand those areas to be?
The maroon is the parking pad of Easement 1, and that's the parking pad.
Yeah.
And the blue is Easement 2.
And so what did you understand those to signify? In other words, what did that mean to you?
These were the easements that came with agreements that we knew were on the property that were owned by our neighbors, but we had full exclusive perpetual rights to use them for any legal reason.
And how significant was that to you in making a decision to buy on this property?
It was big, very big. The realtor of the selling agents used it as you could build a driveway from West Andrews onto the easement, whether we used it for parking back there, whether we used it as another driveway so we could come into the back entrance. That was a big deal since Habersham was so busy. It was enticing since Habersham is busy and there are not many on the street that had that access to West Andrews. I don't think any that had the access to West Andrews and Habersham.
Let me hand you exhibit number 4 and you can ask you if you can identify this document. And this is the deed through which your husband purchased the property, correct?
He purchased.
And you understood that in this deed, it makes reference to the easement that you just discussed, correct?
Yes.
Do you remember any discussions? What discussions, if any, do you remember at the closing concerning any contest regarding the easement?
Objection, Your Honor, hearsay.
Let me restate it. Were you aware of any contest of the easement at the time of the purchase of this property?
No.
Do you remember being provided with any documents that indicated that it had been canceled?
No.
What, if any, signs were out on the property indicating that you could not trespass on the property, if any?
Objection, Your Honor. I don't think that we've established if she had been out there at that time.
Well, that could be her answer, that I've never been out there, but I'll allow the question.
I had been out there several times. We looked at the property many times before we decided to buy it, and we had been on the easement. There were no signs. There were no signs for no trespassing.
Do you have any understanding of whether the easement agreement provided you with a right to create a drive from East Andrews to the property, to your property?
From West Andrews
West
to the property, yes, it was in the selling point of the house. It said that we could, but not limited, build a driveway.
And you all have not done that at this
We have
point?
not.
Is there anything that's inhibited you from doing that?
This lawsuit.
All right, so you closed on the house on what day, do you recall?
We closed on the house March 27th, 2020.
And did you move in immediately?
We did not. We did not move in until April 30th.
And what was happening between the time of closing and April?
We were doing renovations in the house.
And what kind of renovations were going on?
We renovated the kitchen and did painting and did some renovations in the family room and the half bathroom.
Were you living at the house at that time?
We were not.
So, and you hired contractors to, I assume, come in the house and do that work? You and your husband weren't doing it yourself?
We were not.
Where were you living at that point?
We were living on Brookwood in Garden Hills.
Okay. And were you there at all times when the contractors were performing the work?
I was not.
And what, if any, direction did you give them in terms of how to access the property for purposes of doing the work?
We did not give them any directions. They had a boss and he would have told them where to park.
But what, if any, direction did you give them relating to their rights over the Andersons' property?
I did not give them any until it became an
Stop.
issue.
When you hear an objection, you need to say a little louder. You gotta stop your answer.
I'm sorry, I didn't hear her.
Objection, what is your objection?
Sounds like we're kind of getting into some legal territory with what your rights and conveying rights to workers and all that kind of stuff. There may be a question in there, but I don't think that that's the appropriate way to ask it.
Oh,
The question was, what did you tell the construction workers? So I'm gonna allow that. There may be argument that flows to a jury later, but you may be a few questions too soon. I'm not allowed to keep going for now. Please repeat your question, Mr. Schneider.
I'm glad to. What, if any, direction did you provide the contractors on any, well, let me ask it simply. Did you ever tell the contractors they could go over the Andersons' property to perform your work?
No, I did not.
Would you have wanted them to do that?
No, I would not.
Did it come a time where it was raised that there was some concern about that?
Yes.
And what did you do?
I spoke to our painters who I hired, and I spoke to our contractor and said, this is brought to my attention. And if you need to park on West Andrews, which it's hard if there's many contractors in the driveway to pull in because no one can get out, that they could park on the public street, West Andrews, and there's an easement. And I showed them where they could walk across the easement to come to our backyard, and specifically told them, do not cross their yard, cross through the easement.
And did you hear anything further about it after that?
I did not.
The Andersons, did they send you any form of a demand letter or any indication that the contractors had damaged the property?
No.
And what, if any, control did you have over where the contractors went?
I did not.
And have you been provided with any demand or invoice or pictures of necessary repairs?
I have not. No.
Do you remember roughly when you moved in? You may have already testified to that.
We moved in on April 30th, 2020.
And how old was your son at that point?
Hopkins was 12.
Now, let's move forward. You move into the house. When did you have any first interaction with your neighbors, the Andersons?
The dumpster was our first interaction, my husband's first interaction.
Tell me about that.
We had come over to, it was something we did. It was COVID. My husband was not working, so he was home. He was working, but working from home. So the children were at home during school. They were not allowed to go to school, so they were doing homeschool. So we would do a nightly drive. So we'd get in the car and go see the house. And this was fun for the whole family. And we went to the house, and the dumpster had been placed already into the driveway in front of our garage. Not in the parking pad, but it was in front of our garden shed, in front of our garage. And there was trash in it. And it was just kind of like, where'd this come from? It's the first time the dumpster's been here. And that was our first.
Okay. And you testified yesterday.
Yes.
I'm sure that nobody wants to hear the whole
Right.
story entirely, but if you can summarize the events that led to the interaction with the Andersons.
I took pictures so then I could zoom in without climbing into the garbage dumpster to see there was a name and an address so we could figure out where did this trash come from. So we zoomed in, got the address, went to Google, looked up the address, and found that it was Tracy Anderson, which was the name also on the box, and that he lived right next door. So Jean-Noel, my husband, picked up the box, not the heavy fireplace screen, but he picked up the box and carried it to the Andersons. He walked up Habersham, over to West Andrews, down West Andrews to their front door.
And what did you understand happened next?
He knocked on the door.
Your Honor, we've already heard this testimony from Mr. David about the conversation between him and Mr. Anderson.
Okay, we have, and I think Mr. Schneider acknowledged that and said he's given an abridged version. If it becomes too unabridged, I'll make sure we move along. So you don't need to worry about it, but I appreciate you flagging.
You're correct, Your Honor. I'm trying to summarize this. Let me move you forward a little
Okay.
bit. So your husband went next door. You just testified to that, right? And then when he came back, did he seem happy, unhappy, angry? Tell me what you remember.
He was upset, he was unhappy. We could kind of hear them having the conversation in the drive while we were in the driveway. I think I was on the phone at the time. And he was unhappy after coming back and speaking with Mr. Anderson.
Was it the trash or was it the way Mr. Anderson reacted to it?
It was the way Mr. Anderson reacted to him coming to the door.
And what did you understand that to be?
We can put the trash where we want. Your garage, your dumpster is on our driveway. It's on our property. So
And-
that was not, welcome to the neighborhood. I'm Tracy Anderson. We're glad to have you here. It was nothing of that sort. It was, we'll do what we want with our trash, whether it's on your property or not. How dare you come to our house saying this to us?
And that was your welcome to the neighborhood meeting with the Andersons.
And that was our muffins. Welcome, our bundt cake, yes. Our muffins or our bundt cake are welcome to the neighborhood.
And you heard Mr. Anderson talk about how the trash was, he has a particularly tall son.
Objection, Your Honor, we're getting back into the leading territory.
Well, I'm gonna overrule. We've shifted topics and Mr. Schneider setting the stage for whatever the next line of questions are. So
Right.
finish your question and let's keep moving.
Yes, Your Honor. Very briefly, you heard Mr. Anderson testify what feels like weeks ago, a couple days ago, that his very tall son-in-law was the one that put it in there. You remember that?
I did, yes, I heard him say that.
Does that ring true for you?
That is not true, because if he leaned over with his arms to put the trash into our dumpster, he would have had to have had 15-foot arms, because the dumpster was in front of our driveway and park, and it was parallel to our garage and to the garden shed, where the wall where he would have leaned over is 10, 15 feet from there.
You'd need mighty long arms.
He'd need mighty long arms.
Are you here today because someone put trash in your dumpster?
No,
When was the next interaction that you had with the Andersons?
on February 24th, 2021.
And describe what happened.
I was taking my children to school. It was a late school start, which we have on Wednesdays, and we would go, because of Habersham's traffic, we would pull out of our driveway, take a right on West Andrews, to have an easier way to get out onto West Paces. So as we were going down West Andrews, we see all the landscaping trucks and the sod and the tree that was in there. And they were sodding the easement. They were sodding his yard and parts of the easement. And I rolled down the window and asked to speak to a manager. And he told me the manager wasn't there, but he could barely speak English. I told him the situation, said, this property is not just Mr. Anderson's. This property has an easement that also gives us rights to use, and you should not be on here. Would you please speak to your boss? And he gave me a business card to call his boss, which I did.
And now bring us to your interaction with Mr. Anderson.
It will. I spoke to his boss, and his boss actually told me Mr. Anderson was not home.
Let me
Okay.
precede any objections. If you can just then bring us to your interaction with
okay.
Mr. Anderson.
So I took the children to school, came home, had an appointment to go back to school and pick up my daughter and take her to a doctor. So I came home to get ready and came back out, got in the car. And as I'm backing out of the parking pad to leave the driveway, I see Mr. Anderson standing there over the wall with his middle finger, shooting me a bird, asking me to roll down my window.
I think you testified yesterday as to what he said.
I did.
Right. I won't make you say that again.
Thank you.
During that testimony, though, you discussed the clearing or the sodding. Tell me about that, your discovery of what we're here today about the removal of the trees and the shrubs and the reconfiguration of the easement area.
About a week after moving in, we noticed that there were people coming and going, and we noticed that there were people coming, like survey people on the streets, and we noticed the clearing. And we came over to the property, and the entire property had been cleared, the entire easement. You could now see from our backyard, my back window from the living room, all the way clear to West Andrews. So you can now see traffic coming down West Andrews.
Right, if you can come down for just 1 minute and take a look at the exhibit number 5, which we looked at earlier. So using your finger, if you could just point where if you can point out where you saw them clearing during this episode.
Here.
In the blue area.
In the blue area.
What discussions did you have with the Andersons before they did that?
I had not had any discussions with the Andersons.
What communications did you get from them or their lawyer or anyone else about the fact that they were going to do this?
Nothing.
And if you were sitting in your living room and looking out the rear window, can you point to where it is that they were removing the trees or the understory or whatever it was
Here.
in that blue area? Okay. Did you consent to that?
I did not.
Did you? You can have a seat. Did they also begin to construct any form of a fence?
Not then, but later, yes.
Well, let's stop there. So when you saw them out there, and you saw them clearing, did you have any, and then the interaction you had with Mr. Anderson? After that, did you file a lawsuit to stop them from doing this?
I did not.
Did you know what they were doing at all?
I did not, other than removing the trees and any vegetation.
Do you have any sense about what their plan or intent was with regard to this obviously intended landscape redesign?
Don't answer yet. Yes, ma'am.
Speculation.
Ms. David, do you recall seeing this exhibit yesterday?
I saw that yesterday.
and I'm going to ask you to come down again. I know you already needed your replacement, but I'm going to help out. If you can identify the best you can, I understand you're not a surveyor, but using this, and this indicates, this appears to be a diagram of the Anderson property, correct?
Correct.
And based upon your knowledge of the landscape and the dimensions, can you identify where it was that the easement area is roughly on that plan? Easement 2.
I don't know exactly
Right.
how much, but it would have been the back parcel here.
So based upon that, what would your impression be in terms of what the Andersons were going to be doing in that area?
Objection, Your Honor. I think that's still speculative. The plan speaks for itself. She doesn't need to interpret it.
That's the, I think
It does.
you're right. So, it's in evidence, her answer is in evidence.
Yeah.
We'll move on.
Does it appear to you based upon, and you can sit down, does it appear to you that based upon the work that you saw being done, that they were implementing this plan?
Yes.
How did it, and you also heard testimony yesterday, and you may have testified as well, that at some point they stopped. Is that right?
They did.
And why did they stop? Well, did you ask them to stop?
I called the closing attorney and I called my realtor
And why did you call them?
to get more clarification on what I believed my rights and our rights were, and that we're being, we were being wrongly, word for it, to find out if this was okay for him to be doing this. I did not think it was, so I wanted legal clarification.
And what was the result of your investigation into that?
That we had exclusive perpetual rights and
Your Honor,
Okay.
So, yes, sir.
I think we need to approach on this issue.
We don't need to approach.
I'll be glad to say it in front of the jury.
You don't need to say anything in front of the jury. So, ladies and gentlemen, you should disregard, what, you just heard Ms. David say. The question of what the easement says and doesn't say is partly something I'll instruct you on and something you all will be navigating, when you have the, language of the easement before you during your deliberations. So, Mr. Schneider, it's important you not intentionally
Yeah.
ask. And I don't think that's precisely where you were heading, but I can see how we got there. The Andersons and the Davids may have their strong views as to what the easement entitles them to do or not, but their opinion as to those entitlements isn't what we ought to elicit here. Okay,
And I'll be careful on it, Your Honor.
okay.
So when you came across this, you or your husband asked them to stop. Is that right?
we did not ask them to stop.
But you had an well, let me move on. What would you describe was the landscape work that was done subsequent to your purchase? Landscape work that was done in the second easement area subsequent to your purchase of the property?
There was not landscape, it was wooded.
And what was done after you moved in?
It was cleared, everything.
Did they put any other improvements in the easement area?
They put a huge, almost stadium light in the trees. Stadium-like lights
In the trees?
in the tree.
And anything else?
They added a fence.
And tell me about the fence.
um, one day in the morning, about 15 contractors came out and started building a 6-foot fence from attached to our brick wall and walkway. And that was coming down the easement line. I mean, that was coming down between our properties, our boundary line.
Did they consult with you beforehand?
They did not.
And what happened when you saw them beginning to construct this fence?
I contacted Noel, who later in the afternoon went and told them, as he watched and saw where they were going, that they were going over in the easement line, and he went and asked them to stop.
We have a Tracy, a Stacy, and a Casey, so I may call you any one of those, but if you can put up exhibit number 33 again. And Mr. David, you can come down very quickly. Using exhibit number 33, can you tell us how far the fence went along the common boundary line between your property and the Anderson's property?
Just ask me again, say again.
Yes, tell me how far the fence was actually constructed before they stopped along the common boundary between your lot and their lot.
So it would have been from here to about here.
I don't want to reorient you, but your lot is up here, correct?
Oh, I'm sorry. Again, I didn't see this until yesterday.
Understood.
So about, where's the parking pad from here?
Just speak up so I get Mr.
Yeah, you're not near a microphone, so if you're saying words, say them loudly, please.
Okay, so here is our parking pad. Here is our brick wall that's right here. So they attached the fence to our brick walkway and brick wall here. And it came all the way down to about here. When my husband stopped him about here.
Did you see anything to indicate that they were going to continue with the fence?
Yes, they were continuing down. They were continuing.
And you can have a seat. Did they put any surveillance cameras out on the property that you're aware of?
They did.
Can you describe those?
There was surveillance cameras when we moved in. There was one on the ground right behind their garage that directly pointed just to our yard. So my kids had these hammocks that they would hang up, and there were cameras right there that just would see my kids in their hammock. And it even said surveillance cameras, and they pointed just to our backyard. That was one that was there. An electrician did come. One time I noticed to Mr. Anderson's garage while I was pulling down the road and stopped, and an electrician with cameras, and they put cameras on the garage. He also had cameras on his house. They moved cameras on his house.
Let's see, this is already in evidence. Defendant's exhibit number 26. Do you understand what this document is reflecting?
As I'm reading, I'm assuming this, I'm thinking that these are where the cameras are.
And based upon your inspection of the property and familiarity, is that jive with your understanding?
Yes.
And if we look at this survey with these marks on it, can you show us where your house is in relation to these, to the Anderson's property and your property?
From here or up there?
Up here. Sure.
I'm gonna bring this with me.
Yep. So show us where your house is in relation to these surveillance cameras.
Gather where my house is.
Mm-hmm.
I'm sorry, I have a hard time.
Sure. Well, if you look at, this is the parking data, right?
This is the parking lot.
Right, that's the parking.
Objection, Your Honor. If she doesn't know what she's looking at, I think we should move on.
Right? Don't suggest to her the answers.
No,
She's having trouble with these maps and if she doesn't know where something is, that's okay. She doesn't know where something is.
Ms. David, if you can't identify that, you can just have a seat up and move on to a couple other questions. You did get concerned at some point that some of these surveillance cameras were directed at your house.
They were.
Tell me
Yes.
what you remember about that.
There was a camera that was pointed directly to my daughter's bedroom. My daughter's bedroom has 2 windows here on the side of the house, and there was a camera that was facing that. Her bedroom is over the parking, over my kitchen, so it's over the driveway.
And were you able to identify that some of these cameras that are in that exhibit, you could see them from your house or from the side of your house?
Yes, you could.
And how did you all feel about having those cameras directed at your house?
Just violated, just feeling my daughter still will not open her shades, will not open her shutters. So she sits in her room without opening her windows. Just that we were being watched at all times, that he knew when I came, when I left. I still feel that way. I feel that way in my kitchen that has windows onto his house, that I'm constantly being monitored, being watched. It's very uncomfortable.
And tell me about the home life. Was he traveling during this time? Were you what was your home life looking like in that, as it relates to that?
He was back to work.
Okay. Let me restate the question. It was a terrible question. Was your husband traveling quite a bit during this period of time?
My husband travels for work. He travels out of Atlanta. So he was gone, and he was one of the workers that was essential because of what he does for work. So there wasn't much downtime for him during COVID staying home. He was essential. So he was gone, and is gone. Sometimes he comes home on the weekends. Sometimes he cannot. If he's overseas, he's gone for 2 weeks at a time. Sometimes 3.
And how does it, well, let me move on. The next, let's move on to discussing the use of easement 2.
Okay.
You had said that it made you uncomfortable that there was surveillance of these surveillance cameras aimed at the house. Are you aware of any other instances where Mr. Anderson may have been engaged in surveillance of you or your family or the property?
He would video.
Pardon me?
Mr. Anderson would video with his phone my children, anyone who came up on the property on the easement.
And what do you mean by that?
He would hold his phone out and stand there on the easement, or from his car, or from his driveway, or right upon the easement line, and video my children.
We'll look at a video in a moment, but you have a son that is now how old?
Hopkins is now 15.
Okay, and at the time these videos were going on, how young was he?
12.
And what was he being videotaped doing?
Playing lacrosse.
Is he a good lacrosse player?
He's real good. He just made varsity. He's one of 2 freshmen that made varsity this year, so we're very proud of him. He worked hard.
And after the clearing of this area, he used that area to practice, right?
After the clearing, he thought It's a great place to practice lacrosse. Yes,
Outside of mom and dad's eyes, right?
yes. And we had to make sure we got a net that would keep the balls from going to neighbors or,
Sure.
or losing 100 balls.
So did he practice once or twice?
No,
How many zeros come after that?
many. I mean, there were times he'd practice every day. There would be times he'd practice multiple times a day. There were some days he did not practice. But he used the easement for playing lacrosse, he and his sister, many times, many times, regularly.
And you're aware though that Mr. Anderson was videotaping him. How did you become aware of that?
Hopkins told me the first time he started doing it, he would tell me, he's videotaping me. And he would say, it's like, we asked him to stop. He said, I did ask him to
Your
stop.
Honor, I think we're gonna, if we're gonna hear from Hopkins, we don't need to be hearing those conversations right now.
Okay,
That's
so,
fine.
let's
move
not
on.
get into what Hopkins
Right.
may have said.
I'll move on. How did that make you feel?
Angry, violated, protective.
At any time up to the first time that your son told you he was being videotaped, did Mr. Anderson or Mrs. Anderson send you a notice saying that all bets are off on that easement? In other words, you didn't have any right to be there.
Yes.
Okay.
No,
No.
no, they did not send us a notice or tell us anything. You have no right to be on this easement.
Any signage that you remember?
No,
Similarly, was there attempts that you're aware of by Mr. Anderson to video your daughter?
he did. He videoed if she would go out there too, and she hid behind a tree. She was very uncomfortable and hid behind a tree.
Let's talk about some other things in the easement 2 area. Do you have any recollection of any disturbance of any of the nets that may have been left out there?
My husband put up a net. It's a big backdrop that will catch balls or prevent balls from getting through and going where they shouldn't go, maybe a neighbor's house or something. So, or we also had a bounce back, which is instead of using a wall, you can use this structure that you put when you play lacrosse. You throw the ball with your stick and it hits the structure and comes back to you. So he practices back and forth. It's a rebounder.
Let me hone let me narrow my question.
Okay.
Did any of those things you just testified about, were they ever thrown down repeatedly or thrown away
Objection, Your
repeatedly?
Honor.
Yes.
What's the objection?
He's leading her.
It's a yes or no question. It's not, isn't it true that? And her answer may be, no, it didn't happen. Yes, it did happen. Overruled.
Yes, he would most every time he would go out there and pick up his equipment, and this is big equipment. He would go down after we would leave and take it down. We had to replace the netting. Hopkins would have to replace the netting almost every time. He would remove
This
them.
sounds like Hopkins' testimony unless Ms. David was with him because she knows this because he told her.
Well, I would go out there. I would go out there and I would have to figure out what I had to purchase to fix it. Big nets would have to be taken down and
Yeah.
we'd have to reconstruct them.
You saw the famous red chair, right?
That was a soccer or a field chair for sitting in, yes.
And what became of that chair?
It was, Mr. Anderson moved it.
Did he ever give it back to
No,
you?
and I asked for it back in deposition and I was told no. Only if I didn't put it back again.
Objection, Judge.
And the objection is,
Well, we can cross her on this, on what was actually said during the deposition, but he's opened the door to it.
okay.
And how about anything else? Has there been any other personal property that's gone damaged or thrown around?
Yes, we have a solo fire pit that was given to me for Christmas. And my son and his friends used it on the easement one evening. And Mr. Anderson removed it. It didn't just remove it, he threw it into the woods and ruined it. Shortly after I was given that fire pit for Christmas. It's a portable fire pit.
Are we okay on the video? Okay. The
What you got?
hope springs eternal. Okay. So,
Yeah, so we don't use each other necessarily, there is a reverberation.
It just starts, you'll need to make sure our computers use it in all capacities.
Thank you.
You bet.
I'm glad it's not just me. And some of these instances, did any of them take place even while this lawsuit was pending?
Yes,
What? Which ones took place while this lawsuit was pending?
all of them.
Yeah.
All of them took place while the lawsuit was pending.
Can you describe how that, all of those actions that you've testified to this morning, how that impacts your use of easement 2?
It's exhausting. We can't use it. Anytime we try to use it, he makes sure we can't.
And despite all of that activity that you've testified to, did you ever sue him?
No.
You heard about the TPO, right?
Yes, I know about the TPO.
But you didn't file this lawsuit, did you?
No, I did not.
Did you hear Mr. Edwards at the beginning of his opening statement saying that somebody in my law firm that makes a demand on my client, we call them the defendant? Do you
I
remember
did.
him hearing that?
I did hear him say
Feel like
that.
you're kind of caught in that trap?
Yes.
Now, what are you seeking in this case?
Peace, freedom to legally have what's right for us. I want to be able to walk into my driveway and in my yard, which I have not in 4 years, without the fear of Mr. Anderson. I want my children to not be accosted. I want my children to be able to feel free to be on the property without Mr. Anderson videoing them, without Mr. Anderson standing guard over them. I want peace, and I want this to stop. I want the harassment. I don't want to be called. I don't want my friends, my children to worry that their friends are hearing this language when he's hollering at them. I want peace. This is not what we thought we were getting into when we bought our dream home.
You bring up an important point, and I'll ask you 2 questions about it. One was the racist statement that you heard him make. How often did that happen?
Twice.
Describe the first one.
We were getting into the car. It was a Sunday. We have club practice on Sunday. So we were getting in the car with
Who's we?
Hopkins and 2 of his friends. We were getting into the car to go to, these are at the time 14-year-old boys, getting into the car to get ready to go to Lacrosse. So we were getting in the car in the parking pad to go to Lacrosse when we heard Mr. Anderson, I know his voice, Hopkins knows his voice, loudly holler. We were just dumbfounded. I looked at the boys like they looked at me and they both repeated what he said. Like, this is what he said. Did you hear that? I'm like, I did hear that. So it was just, we were appalled. Why? First of all, we're not Algerian. My husband's Lebanese, from Africa.
Let me ask you about the second incident. Do you
Okay.
remember roughly when it was?
The first was in March. The second was in October
Of what year?
2023,
Even while this lawsuit's going on?
even while this lawsuit's
Okay,
going on.
proceed.
The second time, again, we were coming home from Lacrosse. Obviously, we do a lot of lacrosse. So we were coming home from Lacrosse and Hopkins and I were getting out of the car. And he knows when we come home, when we're leaving, that's when he does these things. because he knows, he's watching us. So he, again, was in his yard, and this time he had company with him. He had, I know who they were, but he had a man and a female with him. And he hollered again, and we could see him this time.
And your son was there.
And my son was there, and he's now very protective, and he's protective of me. He's a growing boy and growing into a man now, and he's said, let's hop in the car. And we hopped in the car to go over there. So we did, and we went over there, and they ran inside and shut the shutters. He and who I know now were his daughter, his stepdaughter, and her husband.
Those are all the questions I have of this witness, Your Honor.
All right. Ms. Menwood, do you have questions for Ms. Duddy?
I do, Your Honor.
Okay.
Good morning.
Good morning.
All right. So actually we'll just pick up where you left off. You said the first incident occurred on March of 2023?
Mhm.
Okay.
Hold on.
Yes, sorry.
Wait. Nope.
Yes, sorry.
All right. And you said that you did not see Mr. Anderson. Is that correct?
We did not see him.
Okay. And you've only spoken to him one time, correct? And that would have been February 24th, 2021?
Correct.
Okay. So just that one time.
That's the only time I've spoken to him.
Okay. And that he's spoken to you?
Spoken to me directly, yes.
Okay. All right. So did you call the police?
I did not call the police.
Did you file a temporary protective order?
I did not.
Okay. The next time was October 2023,
Correct.
and you said you saw him.
We saw him.
Okay. And you saw him physically speak,
We saw him in the yard.
but you didn't see him speak.
We saw him speak, yes.
Well, did you see him in the yard or did you see him speak? Are you sure?
Yes, I'm sure.
Okay. Did you call the police?
I did not.
Did you file a temporary protective
I did
order?
not.
Okay. You made an allegation just a minute ago that you believe that a surveillance camera was pointed at your daughter's window.
I do.
Okay. Did you take any pictures of those cameras?
I don't think I took pictures of his house, no.
Okay. Well, I mean, were you on his property looking at his cameras?
No, you can see his cameras from our windows.
But you didn't take a picture?
No, I did not.
Okay. Did you call the police?
No, I did not.
Did you file a temporary protective order?
I did file a temporary protective order. That camera was there then.
So, correct me if I'm wrong, I believe that your temporary protective order was about your belief that Mr. Anderson was stalking you based off of what interaction, right?
No,
No,
he was stalking us,
okay,
family.
but you were the petitioner in the protective order, right? Not your family?
I was the petitioner in the protective order, yes, but I was speaking for my family.
Okay, but they were not included, right? Were they petitioners?
No, they were not petitioners. I was.
Okay. And I don't believe that that was included in the temporary protective order, right?
What was not included? The camera?
Yeah. Well, no, the allegation with your daughter.
The camera would pick up much more than just my daughter's room. There was many cameras on the property.
Okay, and I asked you about a specific incident that you brought up.
Did I put the camera in the protective order that was facing my daughter's window? No, not specifically. I did say I was being watched.
Okay, that you were being watched.
Yes,
Okay, and you didn't call the police. When you believed that a camera was pointed at your daughter's window, you did not call the police.
I did not.
Okay, and you didn't go over there to talk to the Andersons even just, hey, this must be a mistake, right? Like,
I did not ever feel comfortable to go after the garbage incident,
mhm.
ever feel comfortable to approach the Andersons. I did send a message to Miss Anderson. The only way I could get a hold of her that I knew of was through an Instagram message that I found her. I did send her a message.
But didn't you just say on October 23rd, y'all ran over to the yard?
And we drove over,
You drove over?
drove over.
Okay,
I would not run onto his property ever.
okay. But you didn't drive over about the camera?
I did not drive over about the camera. I would be driving every day. There are cameras there every day facing our property. Every
Right,
day.
I mean, hey, the first instance that you were under the impression that a camera was pointed at your daughter's window, you didn't get in your car and drive over there?
I would be doing that every day.
What, did you do it once?
I did not go over to the Andersons. No.
Okay, all right. Let's shift a little bit. You have testified a few times, both yesterday and today, that you've walked easement to, I believe you said many times,
I have,
before you bought the property and after you bought the property.
correct.
And would that be including recent times?
I don't know how recent. I've been on the property, yes, at least through in December 2023.
Okay. And you gave a deposition on January 27th, 2022, correct?
I don't recall the exact date of when the deposition was. I did give a deposition.
Okay, you did give a deposition. And during that deposition, you were under oath, just like you are now, right?
Yes,
Okay, so in your deposition, didn't you state that you hadn't walked the property before you bought the house and didn't walk the easement?
I don't have the deposition in front of me. It was 4 years ago.
I gotcha.
Thank you. I did say that in the deposition, but I did.
Okay, so we're just not being honest in the deposition?
No, it was emotions. A lot has been going on, sitting there with the camera on me in the deposition and the person recording what I was saying. This has been a traumatic 4 years for us. So there were many things I've said, many things I haven't said, many emotions and omissions have been included because of the trauma.
Okay, so kind of sounds like what you're saying is if you're under stress and you have somebody taking down your words, that you might say things that aren't true.
Your Honor, I'm going to object.
Not so.
That's totally argumentative.
Right, save it for closing.
All right.
Next question.
No problem. Okay. So another issue that you brought up, I believe that you said one of the things that you were interested in doing with easement 2 was making a driveway.
It was not something I was interested in. It was something we were afforded the option to do.
Okay, well, actually, as I wrote it down, I circled
It was enticing. That
Right,
was an
that's what you
option.
said.
Yes.
Okay. It was enticing. So in order to build or construct a driveway from West Andrews and that would go through the back of your property, right?
Not necessarily. A driveway could be a parking pad, a pea gravel lot where we could pull up and park the cars and walk. We never even got as far as to speak of where we would stop it, but I would not run the driveway through the back of my property.
Then how would you use it?
I would pull and have visitors pull in and park back there and
Okay.
walk
Okay.
to my property.
And then in order to do that, you'd probably have to knock some trees down, right?
No, the trees have been knocked down already. I don't need to.
And I know you're alleging some trees have been knocked down, but if they hadn't, then you'd have to in order to use them for that driveway or parking pad or whatever it is that you want to call it that's enticing.
It was not my language. In the easement agreement, the words were written, and through the realtor that was selling the house,
I'm talking about what the realtor told you.
it was written in a brochure, Your Honor.
Well, and I don't mean to interrupt you, but I'm asking you about what you said was enticing. So it doesn't really matter
It
what
was
the
an
easement.
option.
Stop. You guys
Sorry.
cannot talk over each other, so if the lawyer is still posing her question, and it's more like she was commenting on what you said, but she'll have a question.
Yes, sir.
You need to wait till she finishes.
Yes, sir.
What I'm saying is true, for, remember, she needs to let you finish your answer before she moves on to her next question. So ask a question.
Certainly. And, okay. So moving on actually to the tree removal allegation. How many trees were on, did you see any trees being taken down?
No, I did not.
Okay. So do you know what type of trees were removed?
I do not. I know that we have a gentleman that told us about what trees could have been there, but I do not know which specific trees were removed.
Okay. And did you take any pictures of easement 2 before any alleged clearing happened?
No, I did not.
Okay. And you've taken a lot of pictures in this case, right?
I wouldn't say I've taken a lot of pictures in the case. I've taken pictures.
Okay, fair enough. And I guess a lot is relative. Did you take any pictures of any trees coming down?
I did not.
Okay. All right, you talked a little bit about and I'm sorry, I know I'm trying to maintain eye contact with you. We have monitors. The dumpster situation. And you were asked earlier with your workers and I'm gonna pause for a minute. The workers who were working on your house before you moved in, right? And if I'm understanding the timeline correctly, you said you bought the house on March 27th, 2020, right?
Correct.
You moved in April 30th, 2020, right?
Correct.
And in that, month time frame, were y'all going, back and forth to the house regularly, not so regularly? How would you classify it?
Daily.
Daily. Okay. So you'd be aware of what was going on?
I wasn't there all day. We would go, if I had an appointment and I needed to go, we would go, or we would go late in the evening as a family.
Okay. But you at least get eyes on things every day.
I would see the house probably every day. There were some days I didn't go, but
Okay.
probably.
Alrighty. And you were asked if you got an invoice from the Andersons about your workers walking across their property, and you said no.
Correct.
Did you send the Andersons an invoice for your dumpster?
I did not.
Do you know how much you were ever charged for your dumpster?
I do have I can't tell you now. I have a document saying how much we were charged for every time the dumpster was dumped. Yes.
But you can't tell me off the top of your head right now? Okay. Alrighty. You indicated that your son practices lacrosse often on Easement 2, right?
Correct.
Okay. And you're comfortable with that?
Define comfortable.
Well, I mean, you let him.
I do let him. He can't go there if I'm not home or if his father's not home.
Okay.
Know when he's going out there. I have a door in my kitchen that I can hear when he's out there. He can communicate to me. I can communicate to him. He has a phone always with him.
Well, yesterday you testified that there was a situation where your son was on Easement 2 and you and your husband weren't at home and he called you. So I guess it's not all the time, is it?
That's this one time we were not with him. We were with him when he went out there. We left, we came back when he called us.
Okay. You were shown multiple times, kind of a sketch of a landscape plan for the Andersons property, right?
Once, I saw it yesterday once.
Well, and a few times today.
I saw that.
Okay. And they haven't done that, have they?
They've cleared it.
They've landscaped their whole entire property?
They cleared it. So the back portion is as it is on their landscape plan, it's now cleared, yes. So that part of the plan has been done. And I've also seen an email from Mr. Anderson to the person who was doing the plan, ready to go on, I think it was the first part of the plan, the first part of plan A or whatever, something like that. He sent an email saying, ready to go. Let's start doing this.
Wasn't it true that the fence was stopped?
The fence was stopped when my husband stopped it, yes.
Okay, and isn't it true that, well, I guess, were you able to memorize in the one time yesterday and a couple times today that you saw the landscape plan, are you able to memorize what it was to then think about what you know about the Andersons property to say that it's been enacted exactly like that? Because you said they started it according to the plan, so do you know?
The only part that I can attest to is the part that's cleared. That's the only part that's important to me. So I didn't really pay attention at all to anything but the easement.
Okay. You were asked, well, at any point in time, did you ever just try to work this out with the Andersons?
I sent an email, I sent a direct message to Mrs. Anderson. I did.
Do you have any idea if she ever received it?
She didn't respond, so I can't speak if she received it or not.
Okay. Did you ever just think, maybe I should just knock on the door and try to talk to them?
Never would I knock on his door and try to talk to him after the garbage incident. I actually reached out to Miss Anderson twice, one on the 24th and one on the 26th of February.
Okay, and what about before February 24th of 2021? Did you ever make any attempts to just say, we've just kind of got off on the wrong foot, we can turn this around, let's talk to each other?
No, how would I do that? Go knock on the door as my husband did and be treated the way he was? No.
All right, well, bear with me for a minute. You were asked in your deposition if you ever tried to work it out with the Andersons before February 24th of 2021. Do you remember how you
I
responded?
would object to her use of this deposition. There's a proper way she has to present my client with an opportunity to review her deposition testimony.
Okay, but the question was, do you remember what you said? And I'll ask for a verbal response. It looked like the answer was no. And then I suspect Ms. Meadow was about to bring her to deposition. But if she remembered, that's actually the right way to do it. Do you remember?
I don't remember. I probably said no because my interpretation would have been, did I ever go face to face and knock on their door or call them? No. I did reach out via Instagram.
Okay.
If you could let opposing counsel know page you're on.
Oh, I'm sorry. Page 61, line 14.
You can read that and your response is the highlighted portion.
You want me to read the highlighted portion only?
Yes, what did you say?
No, that's why you have attorneys. Correct. I would have asked them to reach out instead of myself.
So that's why you have attorneys before February 24th, 2021.
I did not have attorneys before then.
That was your response?
That was my response.
Okay. I believe I'm done with my questions, Your Honor.
All right. Mr. Hogan, do you have any questions? Mr. Logan, do you have any questions?
Some brief follow-up, Your Honor.
All right.
It sounds like a driveway was kind of an important thing for you. Is that fair to say?
Not important. It was enticing. It was a nice thing to hear that we had that option. It wasn't important to me.
You seem to be fairly attached to, I think you referred to it as a garden house. You said your husband calls it a shed.
I love the garden house.
you love the garden house. So would the garden house not have to go in order to connect a driveway from West Andrews to
You just
your garage?
testified.
Don't
Sorry.
talk over him, but you did just testify.
I just testified that I would not build a driveway through my yard reaching West Andrews.
What use would a driveway be then?
A lot of use. I have a narrow driveway. It's hard to turn around when cars are coming in. I could pull in West Andrews and park there and walk from my back property.
Through the trees?
There are no trees on the easement.
Through the trees in the back of your property?
I have trees in the back of my property. I walk back in the back of my property every day. Not every day, all the time I walk in the back of my property. And there are trees. I walk many places where there are trees.
You testified yesterday that there's not a path.
And there's not a path many places where I walk where there are trees.
So you want people to park to come to your house and then walk through the woods, over the pine straw, over the dead leaves, in the mud, through the ivy?
I didn't say how I want my guests to come and park. I said how I would get there. But it doesn't, I could easily build a walkway if I wanted to from the easement to my backyard. Yes,
Why haven't you?
because of this order going on. I'm not going to spend money on the easement right now until this is over.
Is it not true that,
And that wasn't a definite thing we were doing.
is it not true that you paid landscapers to cut a path from West Andrews through up to the easement?
I did not pay anyone to make a path. No,
They did that for free?
I did not pay anyone.
They did that for free.
I did not pay anyone.
You said that you place a lot of value on the fact that you could look out your back window and you couldn't see West Andrews.
Correct.
And now you can see West Andrews.
Not the fence there. No, I cannot see West Andrews. I see a fence.
Before the fence was up.
Yes, you can see West Andrews.
Do you have any pictures from your back window showing that you can see West Andrews?
I do not.
Okay. Now, I am still very confused about the timeline here. Did the clearing happen before the fence or after the fence?
Before.
Okay. So the picture of the stump removal device, the machinery that you said you took a picture of, that happened before the clearing.
I don't know. I said yesterday, I don't know if that was my picture. I don't know if that was my husband's picture.
Okay.
I don't know when that specific picture was taken.
And you testified that the first time that you saw Mr. Anderson's landscape plan was earlier this week.
Yes. This week, yesterday.
You didn't review that at any point prior to this week.
I did not.
And are you claiming damages for the, I guess, intended landscaping plan Mr. Anderson had?
No,
Okay, were you harmed in any way by his intended landscaping plan?
harmed by his landscape plan, by his plan that he cleared the property. Yes, I was harmed.
That's not what I asked you. I asked you about the landscape plan that you saw in court for the first time this week. Were you harmed by that?
No,
Thank you. Now, you said that your son is 15,
he's 15.
and you said that back when he was being recorded by Mr. Anderson, he was about 12?
No, I didn't say that. When we moved into the property, he was 12. He's now 15. Mr. Anderson has recorded my son for about 4 years.
Does your son ever record him back?
No,
And you said that you're always on easement too, to figure out what you have to purchase to, I guess, keep your son's lacrosse practice area kind of up to date.
not up to date. When Mr. Anderson pulls it down or moves it or throws it down or knocks it over and I have to
Right. Sure.
fix it, yes, or
Okay.
replace it.
And so, okay, is it important to you to make sure that your son has like proper equipment?
Proper?
Yeah, I mean, that works,
That works, yes,
that's in good condition.
yes.
Okay. Can you, please pull up the pictures of the nets? That one. That one. There we go. Can you come down and look at?
I can see it from here, but I'll come down if you'd like me to.
You see?
I can see it on my screen.
Okay. Is that like mold or dry rot or something like that over there? Is that a bounce back?
That's one of his 2 bounce backs, yes.
And that, it looks like that's just covered in mold and is that, I mean, what is all that green stuff down kind of on the bottom?
I don't see any green stuff on the bottom.
Right above the STNs.
Right above the STN?
That is,
Sorry, right above the STNs?
Yeah, the 3 letters, you can't,
Oh, okay.
unfortunately, you can't see it, but right above the letters STX.
Thank you.
I think what that is where it's netted and it's open and you're seeing the trees, the green behind there. But it very well could have mold on it since it's outside. But I think what that is I'm seeing the greenery where it's mesh, it's clear mesh.
So you don't think that looks like mold?
I do not, but if it was mold, I would not be concerned.
You're not worried about mold and dry rot and something that's supposed
I
to?
object to this.
I am not.
Learn more about lacrosse.
You know what, the jurors are gonna decide how important that point was to me, that there may be some mold on an outdoor piece of athletic equipment. We'll let the lawyers decide what they wanna share with this jury.
You also said that you bought a portable fire pit.
I did not say that.
You got one for Christmas.
Yes,
Okay, yeah. And that your son and some friends
Mhm.
took it out on easement too?
yes.
And is this like an in-ground fire pit or is it a portable?
You just said, and I said it was a portable fire pit.
So it's not one that you put down in the ground?
No,
Okay. And the easement area is covered in pine straw, correct?
I don't know how much pine straw is on the easement area. There is, I'm sure there is some. I could not testify to say, yes, the whole area is covered in pine straw.
Which pictures?
The first one that you had up before.
Look at this.
Yeah, the first one. Yeah, that's fine. Ma'am, okay, do you see now any pine straw in the easement area?
That's a portion of the easement area. I see some pine straw,
Do
yes.
you see any dead leaves?
I see leaves.
Do you see any dry pine cones?
I see pine cones.
Okay. Do you think that's a good place to build a fire?
I didn't build a fire on that. There was a fire inside a fire pit that has a cover around it.
You know, fire sparks.
Are you asking me if fire
I am.
sparks?
Do you know that fire
Sure,
sparks?
fire sparks.
And you said that you feel like you can't use the easement area, right?
Personally,
No, you said that you feel like you can't use the easement area. And I took you to mean you as in your whole family.
when did I say I can't use the easement area?
You indicated that you are intimidated and feel concerned about going onto the easement area, correct?
Personally, yes, I feel that way for myself, even going in my yard.
Okay, but your children are out there, quote, all the time.
Hopkins is out there a good bit, not so much lately.
And going back to the incident with the gun, just to clarify, it's more important to you to call your lawyers than the police in that situation.
Object to the floor of the question, it's just argumentative.
Right, and you share with the jury, how you would put things in a hierarchy. She's testified to what she did after the alleged gun incident.
I'll move on. And was that your same response after these incidents with the Algerian, you know what I'm saying. I'm not gonna say it.
What my same response?
To first contact your lawyers instead of the police.
Yes.
Nothing further.
All right, we're gonna take a break. You may have redirect, but jurors need a break, our full reporter needs a break. So we will break and I'll try to get everyone back in here, in about 10 minutes. Yes, no, we'll do that. I'm not forgetting that. There may be redirect. Mr. Schneider has the ability to do redirect, and I will definitely ask you all if you've got any questions. But most importantly, I'm gonna give you a break. Grab your stuff, don't talk about the case, and enjoy the jury room. Thank you.
All right, the jury.
First. All right, we are back on the record. Mr. B, before order that. All right, we've heard some testimony about someone from your household engaging someone from the Anderson household about the appropriate use, the proper use, the allowable use of the Anderson garage. Do you know what I'm referring to? You can have people live up there or clear it out or anything like that. Do you know the discussion I'm talking about?
Yes.
Was that a conversation that you had with any of the Andersons?
No.
Okay. Do you know, that was your husband who had that interaction?
Yes.
Are you able to put it on the timeline of you just moved in, it was 6 weeks ago, it was before the fence, it was after the clearing, we've got some markers.
I'm not sure when that was.
If you had a plan or found it enticing to have a parking pad area, on easement 2, why was it a concern for you that the Andersons cleared the area, which would have to happen if you're putting a parking pad?
Because I never had a plan for the parking pad. When we bought the house, it was wooded, and that's why we wanted it. We loved that it was private. It was wooded, it wasn't cleared, so we're enjoying it as a buffer, as a blockage from the street, nature. We didn't have a plan. It was an option in the realtor's brochure, and that was a selling point for them to use it as a driveway. And it was always an option that we could do that, but that is not what our plan was when we bought the house.
Do you have pictures that you can make available, not necessarily this moment, but before the day is done, that show a view from your house towards easement 2 before the clearing occurred and then after the clearing occurred, so people could see the visual impact for you of the clearing?
I don't think so. They cleared the property within a week of us going under contract. I don't think I had a photo. I have a photo of before it was cleared.
So by the time you moved in, all the renovations and improvements were done, or the remodeling, was easement 2 already cleared?
Yes, sir.
All right. So were there other areas on your property where your son could or did do lacrosse practicing?
Sure. He can do, we have another bounce back that's sometimes it's in the garage, sometimes it's in the driveway. When we first moved in, I think they put it from the truck onto the front yard. In the front yard on the left side. But we had to move it. That was not a good place with the traffic and with our neighbor's house there where it was to leave it there.
Neighbors, not meaning Andersons, but the neighbors on the other side?
Yes.
Okay. Do you have direct knowledge, as in you saw it happen, Mr. Anderson recording anyone on your property who was not on the easement? So not recording you or your son or your daughter or your husband, while they're on easement 2, but in your backyard or on, say not easement 1 either, but basically on what would be your fee simple dollar.
No, I do not.
Mr. Schneider, any follow-up based on those questions?
No, Your Honor, no.
Ms. Medwin?
No, Your Honor.
Mr. Logan?
No, Your Honor.
All right, thank you, Ms. David. Step down. Next witness,
Our next witness, Your Honor, is Hopkins David.
right? Someone can get him.
Oh, they run out and get it.
Before you sit, can you raise your right hand? Do you swear affirm that the testimony you will give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Go ahead and have a seat. Can you state and spell your name for the record?
Hopkins David, Hopkins.
Last name,
David.
thank you.
Hopkins, if you're okay, I'm just going to call you Hopkins, all right?
Yes, sir.
You can call me Jeff if you have to call me anything. Tell us a little bit about your background. Where are you in school?
I go to the Lovett School and I play lacrosse. I'm a freshman in high school.
And I understand that you're playing for the varsity team.
Yes, sir.
And I'm going to be asking you some questions about the house, your family house on Habersham. Do you remember when you all moved into that house? What year?
Around 3 years ago, I think
Okay.
it was
And how old were you then?
probably 12, 13.
And were you a lacrosse player then?
Yes, sir.
And still a dedicated lacrosse player?
Yes, sir.
Got it. I want you to take a look at a video.
Have any confidence it's gonna work?
She could get if there's an Academy Award for it. There we go. If you can back that up. And if you could freeze it right there. Hopkins, I'm going to be asking you some questions about your use.
Hold on 1 second. Someone needs to mute microphone and speaker. I'm guessing it's the machine playing. All right, keep going.
Your Honor, if I you can see the video on the screen in front of you, right?
Yes, sir.
And you're familiar with the area that we're looking at?
Yes, sir.
And we've been calling it the easement area. Do you know what I'm talking about when I refer to that?
Of course. Yes, sir.
And this is an area that is sort of attached, an area that is connected with your home property, right?
Mhm.
So, hold on 1 second, Mr. Debbie, I know you don't testify in court a lot, I suspect. When you're answering, I make sure that you use a spoken word, because you could say, we all know what it means, but our court reporter, someone right there, needs to actually type down words, so yes, no, maybe, I don't understand what you're saying, Jeff, whatever it is, but make sure it's spoken, okay?
Yes, sir.
And that appears to be you in that image right there?
Yes, sir.
And what are you doing there?
I am practicing and I am shooting lacrosse.
And that's an area, is that an area where you have practiced over time?
Yes, sir.
How often would you say that you have practiced in that area?
Many times.
More than 10?
Of course. Yes, sir.
How many zeros would I add to that?
At least another one.
Did you practice at school? Would you practice lacrosse at school as well?
Yes, sir.
And sometimes you come home and practice, right?
Yes, sir.
And would it be here?
Yes, sir.
And why is it that you're using this area to practice rather than your mother had, or we've looked at other yard pieces on the
Mhm.
property? Why did you select this area?
It's an area that I can specifically have for my purpose of shooting. And it's away from the house and it's away from where the dogs use the restroom. So I think it's a more isolated area where I can really focus.
And what is that device that's behind you, that netted looking thing.
That's my goal. And in front of it is just areas where I can shoot into it.
And are you currently using that area?
Yes, sir.
I understand you may be in exams or something, so you might not, but that's your go-to area to work out and practice, right?
Yes, sir.
And is it you, or is it you and a number of other people, or an entire team?
It's usually just me, and occasionally me and my friends use it for other recreational purposes.
Have you ever had has there ever been an incident where you've seen Mr. Anderson? Do you know who Mr. Anderson is? He's sitting here behind me. Do you recognize him when you see him?
Yes, sir.
And did you ever come across him videotaping you or watching you while you practiced?
Many times. Yes, sir.
More than 2 times?
Yes, sir.
More than 20 times?
No, sir.
Somewhere in there.
Somewhere around there.
And was he doing it to be helpful? What did you think he was doing it for?
Definitely not helpful. I don't think there is.
What was your experience? What did you see him doing?
So I would be shooting and he would come out and hold his phone up and video me.
Did he ask you whether he could do that?
No, sir.
Did you want him to do that?
No, sir.
How did it make you feel when he did that?
Uncomfortable, frightened.
Were there times when was he very close to you, or did he hide kind of off in the bushes?
He was never close to me. He would never cross into his yard to come and video.
And did it interfere or interrupt your use of your practice?
Yes, sir.
And it's your recollection that the duration of that happening was from really the time you moved in to when?
Anytime in the past couple of months,
We're talking years this has gone on, right?
like about around 3.
Do you know whether he's ever also videotaped your sister?
I do not know of that. No, sir.
Did you ever ask him to stop?
I have. Yes, sir.
If we could play this video. We've been having technical difficulties. We stop it there. Now, is this an incident where you're being videotaped by this grown-up neighbor of yours?
Yes, sir.
And do you remember this incident where you're being videotaped?
I do. Yes, sir.
Do you remember, because I can barely hear it, what you may have been telling him?
I said I would appreciate it if you were to stop videoing me. And I told him I was only 13. And I just asked him to please not.
Did he apologize and say he wouldn't?
No, sir.
What did he do?
Kept videoing.
Let's follow up on this. All right, if you can stop it here.
Sure.
You hear him say, sure?
Mm-hmm.
What did you tell him then, if you can remember?
Do you mind if I video you?
Did he sound at all conciliatory when you asked him that?
No, sir.
He said, sure, right?
Mhm.
He didn't ask you whether he could videotape you, did he?
No, sir.
And is this, what we're looking at here, consistent with the experience you've had with this grown-up man videotaping you in that area?
Yes, sir.
All right, let me ask you, and I'm finished with it. I promise you, I will not ask you to try that again. There were a couple incidents that I also wanted to ask you with. There was some equipment that from time to time you would leave out in that area, correct?
Yes, sir.
Describe what that was.
We have an old soccer goal out there. We have a lacrosse rebounder, which I can use to pass to myself, and a goal.
And did you ever experience any of that equipment either going missing or being pushed over?
I do, yes, sir. Usually if we do have any equipment out there, we'll find it tipped over and on the floor and not upright.
And who do you think causes that to happen?
Mr. Anderson.
And why do you believe that?
I mean, who else could it be? Who else has a purpose to do that?
Now, do you recall any incident recently where anything else was put out on the property that went missing?
So a couple weeks ago, me and my friends had a little solo stove, probably 1.5 feet in diameter. It's not a small metal stove. And we went out at night and had a fire and just hung out outside. This is probably 11 o'clock at night. Came inside at 11:45. And we can't take the stove inside because it's metal and extremely hot. So we had to leave it there overnight after the fire was put out, of course. And me and my buddy, we came out the next morning and found we did not see the stove at all. Did not know where the stove was. So we looked around a little bit and we found it probably, I'd say 20 yards into our property, thrown in a spot where it's pretty hidden and it has a large dent on it now.
And do you have an opinion of who may have caused that to happen?
Objection,
Miss-
speculation.
Don't answer the question yet. Response to the objection.
If he has a basis for it, he can testify as to why he believes it to be the case.
Well, but the basis needs to be something other than, I've got my hunch, so I'll let you go
Agree.
on to your next question.
Thank you. I will. Do you ever recall an incident involving Mr. Anderson that involved him carrying a gun case while you were present?
I do. I remember I was shooting one day. And
Shooting lacrosse?
Yes, sir. And one day I watched him walk into his garage, come out with what seems and is unmistakably a gun case, and walk to his mailbox, check the mail, went back to his garage, and was gone.
Okay. Was there some indication to you that he knew you were out there or he saw you out there?
I know that he saw me out there.
Yeah. Do you recall any instances in which you heard Mr. Anderson voice what I'd consider to be racist or offensive comments towards you and or your mother?
I have heard Mr. Anderson say racial slurs before. Yes, sir.
Okay. Let me walk you through those 2 points and I'll be brief about it. Tell us about the first incident.
So I was walking to my car, going to Lacrosse, and over the fence, he yelled a racial slur,
If you can recall what he said.
the N-word.
Who was there on that incident?
Me and my mom and some of my friends.
Okay. And how could you tell it was Mr. Anderson?
It was the same voice as I heard, and I don't know why it would be anyone else. A grown male's voice.
And how did you feel about that?
Frightened, attacked, confused.
And did you and your mother discuss it when that happened? In other words, did you say, did you hear that?
We did, yes, sir.
And your recollection was what?
We were a little bit confused of what was happening at first, and then we realized that where the voice came from and that it was him that said that.
And when you were there, when this happened, were you around that parking area?
Yes, sir.
Here, what we've been calling the shed, but in that parking area where your cars are parked?
Yes, sir.
So it would have been right next to the Anderson property?
Yes, sir.
Now, what about the second incident?
A second incident, I was aware that he had family over or friends over, and we were coming back in our driveway. We got out of the car and I heard him say that word again.
And were you able to see him?
Yes, sir.
And again, was there any discussion between you and your mother about that?
Yes, sir.
From that discussion, did she appear to have heard the same thing?
Yes, sir.
And do you remember what year that was in?
Early 2024, late 2023.
Pretty recently,
Yes, sir.
during this lawsuit.
Yes, sir.
Let me take you back to the Lacrosse pitch on Easement 2. In this video we just looked at, there was some tape that was put out there. Do you remember seeing that?
Yes, sir.
And what did you understand the significance or the purpose for that tape was?
Objection foundation.
I mean,
So don't answer. Maybe, I'm not understanding the foundation objection. The foundation, how we know what the purpose is?
How, yeah, the source of his knowledge for what the purpose was of those ribbons unless he did it himself.
Okay,
Well,
understood. So it's not how would you know that they were there? No pictures of them in front of them, but why they were put there.
correct.
Got it. So, probably need to ask it a different way.
Yeah, I will.
Suss out before he answers.
Sure.
Like, actually, Dad told me what the reason was.
Right.
I'm not saying what the reason is.
well, let me just circle back around on that.
Okay.
Okay. You saw the tape markers out there?
Yes, sir.
And what did you understand them? Were you involved in putting them out there?
No, sir.
Were you ever told what they were for?
Yes, sir.
Don't say what they're for, it's just whether you were told.
Yes, sir.
Okay. And did they ever get taken down?
At one point they were gone, but they always found a way to come back.
When you were playing out there, did you treat them in a certain way? Like, did they, in your own mind, did they mean I can't go beyond that point? Or what was your thought about it?
I don't cross that line.
Okay. How have at least the incidents that you've talked about in the last 15 minutes affected, your enjoyment of both living there and the use of these areas, what we've been calling easement number 2?
It's definitely an uncomfortable feeling to know that when I'm outside, I have the chance of being videoed and watched when I don't care to be, especially on my own property. And I feel frightened and almost scared to go outside.
Those are all the questions I have.
Do you have any questions for Hopkins David?
No, Your Honor.
Yes, sir.
Mr. Edwards?
Your Honor, we would move to admit defense exhibit 15, the elusive video.
It's,
Okay, I think it's already in, but it's in doubling now. Okay. Defense 15 is in as well.
but thank you. Hopkins, may I call you Hopkins?
Yes, sir.
Okay. I'm Randy Edwards. I represent the Andersons. We've never met before, have we?
No, sir.
And I can't help but notice that you're wearing the Lovett Upper School Boys uniform, right?
Sir.
It's been 5 years since I've seen that, so brings back good memories. I'm just going to ask a few questions. I'm going to share my screen. It's going to take just a second to go through these hoops to get it up here. But it's my understanding, or is it correct that the choice, it was your idea to put these nets on easement 2?
Yes, sir.
And that's because you thought it was some really good place to practice your lacrosse, right?
Yes, sir.
And speaking of lacrosse, your coach is Jim Busick, right?
I love it. Yes, sir.
Tell him I said hi. So on the screen in front of you are 2 pages from the Plaintiff's Exhibit 23, pages 1 and 2. And on the left is an aerial view of a portion of your backyard. It's got a net. And on the other page is an aerial view of the easement area, also with a net, right?
Yes, sir.
Okay. And you prefer the pine straw stuff with all the trees, well, not all the trees, the tree and the bushes and all the stuff behind it to your backyard with the nice lawn and everything?
Yes, sir.
Okay. And you have, how many times have you seen Mr. Anderson recording you?
I would say more than 5.
More than 5? Now, you've taken photographs of him, haven't you?
No, sir.
No, you haven't? Let me show what has been marked as Defendant's Exhibits 12 and 13. Do you recognize?
So if they're not in evidence.
They are.
They may be. Are 12 and 13 in evidence?
I don't know that they are.
I'm not saying they aren't. I just, want to make sure they are before they're up on the screen. I may be too late.
Well, it's my understanding that they were used in the cross-examination of Mr. Anderson.
Okay.
But if they're not, I will offer them Defendant's Exhibits 12 and 13, and I apologize for.
No problem. Any objection to your own exhibits 12 and 13?
No, Your Honor.
All right, they're in, they're up. Let's move on.
On the left is picture of someone sitting in a car in apparently the Anderson's driveway. Can you identify that?
Yes, sir.
What is that?
That is Mr. Anderson in his car.
And did you take this picture?
I did. Yes, sir.
And the other picture appears to be a picture of Mr. Anderson in his driveway. Did you take this picture?
Yes, sir.
We have asked that the David's lawyers give us copies of all photos and videos that you've taken, and these are the only 2 we've gotten.
Yes, sir.
Does that refresh your recollection that, yeah, I took a couple of pictures, but only 2?
Yes, sir.
Okay, thank you. And Mr. Anderson is a big guy, right?
Yes, sir. I've only really seen him from afar, never up close.
Okay. And this incident with the gun, do you recall approximately when that was?
2022, early 2023.
Okay. And do you recall, what'd you do when you saw him walking around with a gun? It scare you?
I instantly left and called my mom.
Okay. And to your knowledge, did you call the police?
I did not. No, sir.
To your knowledge, did the police show up because your parents called
No, sir.
them? Any of these other interactions with how soon after that incident with the gun was it before you went back on the easement to play whatever you were playing?
Almost instantly.
Later that day?
Can you repeat the question, please?
How soon after this incident? You said that you left immediately, right? You need to say yes or no for the court reporter.
Yes, sir.
You left immediately,
Yes, sir.
and you obviously have come back multiple times, right?
Yes, sir.
100+ times, right?
Yes, sir.
How soon after that incident did you come back? Was it later that day?
No, sir.
Couple of days?
Maybe a couple of days.
Maybe a couple of days. So obviously, whatever the fear or concern you had was gone, right?
Not that much No, sir.
Well, you obviously felt safe enough to go out there by yourself without police protection, right?
Yes, sir.
Your parents weren't out there with guns guarding you, were they?
No, sir.
And would your sister go out there with you from time to time?
Maybe once or twice, not
Okay.
often when she'd come out.
So both you and your sister, after this incident with the gun, felt safe enough to go out on this easement, which is clearly in some highly contentious litigation, right?
Yes, sir.
You can say yes. With this big, large man who has a track record of carrying a gun and cussing out your mother, right?
Yes, sir.
But you felt safe enough to go out there and practice your lacrosse.
Yes, sir.
And you still do that. I guess lacrosse season is either started or practice has started, right?
It's in the middle of the season.
It's in the middle of the season. So you're probably not out there now. You're going to wait till the season's over.
Yes, sir.
Okay. And this incident a couple of weeks ago with the fire pit, how many friends did you have?
When I was out there,
Yeah.
there was probably 8 of us, but when I came back to find that it was missing, only 1 with me.
Okay. But was it a weekend at night or a weeknight that you and 7 or 8 friends went out and had a fire pit party on Easement 2?
It was a weekend night. I think
Okay.
it was during Christmas break.
Were your parents home?
Yes, sir.
Okay. So you're out there during the Christmas holidays, you got 7 or 8 friends over, your parents are home, and somebody says, hey, let's take this fire pit over to Easement 2 and cook hot dogs or something, right?
Yes, sir.
And this is this past Christmas, correct?
Yes, sir.
So this is after the 2 incidents where Mr. Anderson has used that racial slur directed towards you, correct?
Yes, sir.
And directed towards your mother.
Yes, sir.
So Mr. Anderson, he cusses out your mother. She files a temporary protective order against him, right? You go out there and it's your idea to put these nets up, and he videotapes you, right?
Yes, sir.
He carries around a gun, scares you to death, right?
Yes, sir.
Nobody calls the police, right?
Yes, sir.
Then he sees you walking by with some friends and your mother, and he yells at you and uses this horrible racial slur on 2 separate occasions, right?
Yes, sir.
And after that, on Christmas, y'all decide, hey, let's go over to this crazy man's property and have a fire pit and cook hot dogs near midnight.
Yes, sir.
Nothing further.
Mr. Schneider, any other questions for Hopkins David?
Very briefly, Hopkins, just one question. Does all of these incidents that my opposing counsel just succinctly summarized, do all those linger in your experience on this property?
Yes, sir.
No further questions?
Jurors, any questions for Hopkins David? Seeing none, I have one for you. Westminster, love it. Who's got the better lacrosse team?
Depends when.
Well, I don't care about 5 years ago, or he was asking now, head to head.
Love it.
See you. Have a good day.
Thank you.
Judge, can we ask one thing for?
Can you state and spell your name for the record?
Diane Darby, Diane Darby.
Ms. Darby, good afternoon. Thank you for being here. If you could walk, is that chair have wheels? It's movable. You did it great. You just need to get a little closer to the microphone. Thank you
Okay.
so much. Ms. Sturm.
Good afternoon, Miss Darby. Are you familiar with the property located at 3377 Habersham Road?
I am.
And how are you familiar with that property?
I lived there for 23 years.
Okay, when did you purchase it?
We closed November of 1996.
Okay,
I'm sorry. So can you bring that a little closer?
Sure.
It pulls down. There we go.
did you catch that? Okay. And you closed in November 1996?
Correct.
Okay. And who did you purchase it from? Do you recall?
No, to be honest, I don't remember the name.
Does the name Mr. Stephen Weiss ring a bell?
That's them.
Okay. And now, did you sell your property to the Davids?
We did.
Okay. Did you know the Davids before they purchased your property?
No,
Okay. When you bought the property from Mr. Weiss, were you aware of any easements?
I was,
Okay. And where were those easements?
on the parking pad, and beyond the parking pad, there's a little walkway, and then on down, it's where that other easement was.
Okay. Were they on your property or were they on a neighboring property?
Neighboring property.
Okay. Can you describe the condition of easement? Do you know if we refer to easement 1 as the parking pad
Okay.
and easement 2 as the southern portion of the adjoining property,
Right.
can you describe what easement 2 looked like when you purchased it?
It was greenery, grass, maybe trees. We really didn't think that much about it, to be perfectly honest.
Did you use it?
We used it basically my feeling on it was we kind of let it grow up so it would give us some privacy. And sometimes a few twigs, whatever, were thrown in there. And occasionally someone that was having to park on West Andrews would walk through there to get to our house.
Okay. And did your husband use it to walk through?
Yes, he did. Mm-hmm.
Just so the court reporter, thank you for answering.
Yes.
Yeah, so the court reporter can
Yes.
get it down. We'll try not to talk over each other. At the time you purchased your property, do you recall who owned the adjacent property?
Mrs. Smith, yes.
Okay. Did you ever have any conversations with Mrs. Smith about selling easement 2?
Yes.
Okay. Did you sell it to her?
No.
Why not?
My feeling on it was, why would I sell something that would devalue my property?
Do you recall a point in time when Mrs. Smith moved on?
Yes, I do. Yes.
Okay. Do you recall who she might have sold her property to?
No.
Okay. Are you familiar with the name Parker?
To be honest, no.
Okay. Did you know Ann and Jeffrey Nykerk?
Vaguely, I had met her and spoken with her.
Okay.
Yes.
Did they live at did they live next door to you?
Yes.
Okay. Did you have any discussions with the Nykerks about selling easement 2?
I did with her.
Okay. And did you agree to sell it?
No.
Okay. And why not?
Same reason. I felt like it would devalue our property because we had actually thought about maybe someday putting a pool in, and that would be so much, you would have the easement to get in to do the work, plus you would have it to be back and forth to the pool. So.
And when you say back and forth to the pool, is that
Right from, yeah.
from West
Right
Andrews?
from West Andrews.
Now, during your ownership of 3377 Habersham, did you live there full time?
Yes.
Okay.
We have a home, or we had a home, we've sold them both now, but we had a home in Florida. And after my husband retired, we were spending probably 6 months in each place. We would spend a few weeks down in Florida, then we'd be back for 2 or 3 weeks, then we'd go down for 10 days. We were back and forth
Okay. So you were at the 3377 Habersham address. And how frequently did the landscaper come?
He came once a month.
Okay. And did he come whether you were in Florida or staying at
Correct.
Habersham?
Correct.
Okay. When you sold the property to the Davids, was easement 2 still wooded?
Yes.
Thank you. I have no further questions.
Ms. Edwards, do you have any questions for Ms. Darby?
No, you're not.
Mr. Edwards?
I have a few. Thank you. Ms. Darby, we met a couple of
Yes.
years ago, do you recall? Took your deposition.
Yes.
And it was my understanding from that deposition that your husband still with us?
Yes.
He is.
Yes.
Okay. That your husband was a CPA? But he
Yes.
retired, right?
Yes.
Okay. And I'm going to try not to talk over you. If you could try to do the same, it would be very helpful for the court reporter. Okay?
Certainly.
So your husband's a CPA. Didn't y'all become full-time Florida residents for tax purposes around 2001?
What we did was, and we did, yes, but law being that 6 months plus a day and you are residents. So that's what we did.
Okay. So you were gone a minimum of 6 months and a day?
Yes, back and forth. We
Back-
never were there for over 2 or 3 weeks at a time.
Okay. And, apologize, I left my notes.
While he's looking that up, I have a question, Ms. Darby.
Sure.
You mentioned that you and Ms. Nykirk, at some point had a conversation where she wanted to see if you would sell the easement to her. You said, no, thank you, and you've explained why.
Right.
Could you put that on a calendar anywhere? I don't mean month and day, but a
Well,
year before you sold it, 10 years before you sold it?
oh, it was shortly before because, well, here, what happened was they were selling. And because they were selling, they wanted to know, because this became an issue in selling, that people didn't want to buy something that had an easement with it. So they wanted us to sell them that property.
Got it. So if the Andersons are the ones who bought the property from the Nykirks,
Mhm.
and very close in time,
Very
that
close.
purchase that you explained to Ms. Nykirk, I'm not interested in selling.
Exactly.
Okay, thank you.
Mhm.
And that was one of my questions. In your deposition, you told us that your position was, I'm not selling it for $1 million. Do you recall that?
Right.
So does that mean that when you sold the property to the Davids, if they had said, we love your backyard, it's lush, it's beautiful, it's wooded, we don't need that easement, you'd have given them $1 million discount?
Probably not. Why would I do that?
Just trying to establish the value of the whole property as opposed to the value of the easement by itself.
The easement was an enhancement to my property. I
Okay.
had no desire to get rid of it.
Now, did you ever, talking about the woods and all that stuff, did you hire landscapers to go out there and plant trees to help build up the privacy?
No, we didn't. I mean, yes, we had landscapers, but they basically took care of the property that was there.
Took care
And we
of
had
your,
some things that were replaced, but no.
did they take care of your fee simple property? Or did they also maintain the easement area too?
Well, easement area 2 did not belong to me. I only had an easement. I didn't own it.
So the question is, did you or your landscapers actually maintain easement 2?
No.
Okay. And did you or your landscapers actually plant trees or bushes or anything like that on easement 2?
Not on easement 2.
Did you or your landscapers ever go out there and pick up refuse or trash or anything like that that was on easement 2?
Sometimes, yes.
Sometimes. And when was that?
I can't tell you exactly when it
All right,
was.
let's just focus it on you, stuff with your personal knowledge. Did you personally ever go over to easement 2 and pick up trash or stuff that was on there?
No.
Okay. Now, when the Andersons bought the Nykirk property, did you ever have any discussions with them about their possible uses of easement 2?
No.
Did you ever have any discussions with the Andersons about anything?
No.
When I took your deposition, you said you wouldn't recognize Tracy Anderson if he walked into the room.
That's absolutely true. I never saw him.
Okay. Now, one of the reasons we took your deposition in this case was because you signed an affidavit to be used in this case. Do you recall that?
Yes.
Yeah, leave that. So I'm going to give you a copy of the affidavit to help refresh your memory. And this is an affidavit that you signed and swore was true and correct, to the best of your knowledge, based on your personal knowledge, September 13th of 2021, correct?
Mm-hmm. Yes.
Okay. And you didn't actually draft this affidavit. It was drafted and sent to you by someone at the David's law firm, correct?
Correct.
And before signing this affidavit, you had a few discussions with Ms. Sturm about what would go into this affidavit. Is that right?
Correct.
Okay. And in your affidavit, paragraph 5, if you look at that, you said,
So this isn't evidence. You can ask her questions, and if she doesn't recall, you said you handed this to her to refresh her recollection.
do you recall stating in your affidavit that when you acquired your property, you acquired perpetual and exclusive easements over what is now the Anderson property?
Yes.
And do you recall from your deposition, and I've got a copy here if you want to see it, do you recall telling me who the first person in the history of these easements was that told you that you had perpetual and exclusive rights?
I would say it would have to be the Weisses. They were the first ones to have the easements.
All right. Let me hand you a copy of your deposition.
I'm looking at it.
No, you're looking at the affidavit.
Oh, okay.
I know, us lawyers. Let me flip over to page 14. And right here, beginning on line 8 and going down here to line 17. Take a minute and look at that, and then I'm going to ask you a question. That is page 14, lines 13 through 17. Does that refresh your recollection that in your deposition, you told me the first person who ever told you that you had perpetual and exclusive rights to the easement area was Casey Sturm?
I thought you were speaking, when you asked me the question earlier, I thought you were speaking of when it was ever mentioned to me before. And my guess would have been that it would have been Mr. Weiss at the closing of the house. But it could, I'm not saying I think I didn't totally understand what you were saying, but either way.
Okay. Well, my question beginning on line 13 was, who was the first person in your discussions with Ms. Sturm here to use the term perpetual and exclusive easement rights? Did you tell her that, or did she tell that to you?
I'd say she told it to me.
Correct. Thank you.
It's not something I would have thought of.
And in paragraph 9 of your affidavit, you talk about, on occasion, we, meaning you and your husband.
So you've got a question you're not gonna read to her what's in the affidavit.
Okay. Paragraph 9, take a look at the second sentence in paragraph 9, and then I'm going to ask you a question.
So she doesn't need to read the affidavit unless you're refreshing her recollection. I haven't heard Ms. Darby saying, I don't remember.
Okay, well, let me ask you this.
Question.
Well, let me ask you this. Do you recall ever using easement 2 for composting?
I guess you would say that, and that I took some dead plants and things like that, but I didn't have a compost.
Okay. And if you flip over to page 22 of your deposition, down at the bottom of the page, do you recall me asking you about that statement in your declaration, that you used it for composting?
I mean, it seems like I said about the same thing.
Well, the question was, so is that sentence, that portion of this sentence in paragraph 9 about we composted yard waste there, is that accurate or inaccurate? And your answer was, I don't know. Is that correct?
Correct.
Okay. Let's just keep going.
I'll just note the objection.
Yeah, noted.
Okay.
And in terms of using easement 2, you didn't actually use it in an active manner. You used it more in a passive manner. You just like to look at it and know it was there, right?
That and the fact that we used it for privacy. I had a wedding in that backyard, and privacy isn't always easy to come by.
Thank you, ma'am. Nothing further.
You have any redirects?
No, I think we've taken enough of Miss Darby's time.
Jurors, any questions for Ms. Darby? Seeing none, Ms. Darby, thank you for being here.
Thank
You
you.
are free to come. Folks, we're gonna fire Mr. Miller to go with that. How many folks do we have back there?
Everyone, it's about 7 or 8. I told them when they were ready, just hit the light again.
Oh, make the noise?
Yeah.
Well, we'll know. We won't need to guess. Okay, let's get on the record in 21 CV 48101, Anderson's versus Deeds. We're starting a little before 9. All the lawyers are here. I don't think the Anderson's outside. I'm sure the Deeds are here as well, but they don't need to be here right now. We've got the lawyers. We are talking motion for directed verdicts. The plaintiffs in chief rested late yesterday. And so before we pivot to whatever presentation the Davids will make, either in defense of the Anderson's claims or in propounding the Davids counterclaim that will begin soon. But Mr. Schneider, you had some things you wanted to say. Things you, it can be Ms. Sturm, no matter. Let's hear about the motion for directed verdict.
Yes, Judge. Defendants move for a directed verdict. In essence, you've seen the argument teed up before. In August of 2022, we filed motions in limine on plaintiff's claims regarding abandonment, adverse possession, and trespass. With regard to the abandonment claim, we believe that the plaintiffs in this case have failed to meet the burden of, they have failed to make out the elements of their case. So we're dealing with an express easement.
So tell me, I understand where you're going. 2 questions. One, you say express easement. Is that the same as one that's acquired by grant or deed?
Yes.
Okay, so we're on the same wavelength. 2, what is a claim other than adverse possession that the plaintiffs are advancing that's abandoned? It is sort of an argument they're making, but their claims are trespass and whatever the other claims are. But if you look in the complaint as amended 3 times, there isn't a claim of abandonment. In fact, it wasn't until that 11th hour of adding adverse possession that there is any affirmative claim that the Davids have lost their right to their enjoyment of the easement. So tell me what I would be, let's say I granted your motion for directed verdict on abandonment. What would I be telling Mr. Edwards? Like, you know what, that claim you didn't bring, you still can't bring. I'm being flipped, but
I hear you.
Yeah.
These are not my words. These are the words coming from plaintiffs. They said they have pled abandonment in their count 1 under quiet title.
Well, the quiet title isn't what this jury is working through. I don't think, I mean, I thought quiet title, maybe that's before them. I thought that was something for judicial determination, and what we're working through are the other claims.
I don't disagree with you that the issue of abandonment or quiet title should be for the court.
Mhm.
My concern is that plaintiffs have continually represented that abandonment is part of their claim. In fact, the special master even had a ruling on it in his, I think it was the motion to dismiss that he talked about. Plaintiff's allegations of non-use are insufficient to prove abandonment, as non-use alone does not constitute abandonment.
I think that is a principle of law drawn from all the cases that you all cite, and I think it will be part of the charge that you give the jury. And so it's sort of a proceed at your own risk argument that the plaintiffs may make that the Davids abandoned the easement. Certainly we need to talk about adverse possession, because that is an affirmative claim from the plaintiffs. But I'm only pushing back because I don't know what I would rule on with this question of abandonment. I could say that doesn't seem like a very strong argument to make, given the law I'm going to give the jury. But that's a strategic call for Mr. Edwards and his side to make, not for me to say you can't argue it. You're going to say some things and I'll tell the jury effectively that's all wrong. But the adverse possession claim is out there. So tell me what you think my ruling is on the abandonment piece. Accepting the case law as I do, of course, I'll hear from Mr. Edwards before I make any ruling.
Sure, and we haven't gotten to the jury charges. I kind of skimmed them briefly, and maybe something that we can address with the charge. I think it could be confusing to the jury to bring up this concept of abandonment, and so that we may need to take that up again. For the record, I'll just say that we've made this argument. It's in our brief in full from August of 2022 and the motions in limine that we filed then. We would just restate our argument in full there and say that there is no evidence that's been put forth that would satisfy a showing of abandonment.
Okay.
As for adverse possession, likewise, there has been no evidence to support a claim of adverse possession in this case. There has been an admittance by the plaintiffs, right? They have a deed. They took the deed. It was subject to an easement agreement. They purchased the property in 2018. My clients purchased their property in 2020. Their claim is based on adverse possession by 7 or 20 years. We don't have 7 or 20 years in there. Any effort to tack on a prior owner's use of the easement has been defeated as well.
So talk to me about that, because I haven't heard Mr. Edwards articulate that it's the Andersons and their duration in their house that constitutes the adverse possession. I don't know how good he is at math. He's not that bad at math to say that was 20 years or 7 years. It hasn't been that. And certainly, we're well past the point where anyone could think that the Davids aren't trying to use the easement. We're in the midst of that. There's the red chair, there's the nets, there's this and that. So it would have to be attacking on the Darby's alleged non-use if enjoying it as natural buffer is non-use. So I had a couple hurdles for the plaintiff here. But assume for a minute the non-use is literally because you didn't cut a tree down or put up a fence or build a fountain there, then you didn't use this easement that says actually you can enjoy it exactly as it is and you're using the easement. Set that aside. Why can't we tack? In other words, Darby's didn't use it for 19 years. And then the Davies didn't use it for 1 year. That gets you 20, there's adverse possession.
A couple points. We have one, kind of the real property point, that you cannot adversely possess that which you are already owning, right? Your own property. And in this situation too, with regard to the tacking, Mrs. Darby, her testimony, Miss Nykerk, her testimony was only such that it was her belief that there was non-use, right? But also that she could not see the whole easement area too. So she really couldn't speak to whether there was use or non-use of that easement area during the time.
But you, just to go back to my question, you're not saying that there's law out there that says you can't add consecutive owners periods of non-use? Because we're pretty clearly in the 7 range. I don't have all the numbers in front of me if we hit the 20 mark, but if you can add owners non-use together,
Sorry.
it's all right, you're hearing from 2 people at once.
I know.
Sorry. I asked my question, I'm just curious, you're not saying that I am not allowed to consider, insofar as I see the Darbys as having not used the easement for purposes of thinking about adverse possession, I can consider that time and add it to whatever period of non-use there was by the Darbys.
I think that, you know, when we think about adverse possession in a lot of cases, yes, we do have a tacking. We have a difference here, and that is because we have the exchange of these deeds subject to an express easement agreement. So one, we've got a person, so here are the Andersons accepting a deed subject to an easement agreement in 2018. And that in essence is one of the foundations in this case, that you cannot now tack on this allegation that there's been some non-use before that. If they would have gone in and say, well, we're going to take this deed and, you know, contest the easement agreement because we believe that, you know, it has been lost or abandoned, that would have been the time to do that. So that's one. Number two, plaintiff has to prove that there's been consecutive use, right? So there would have had to have been some kind of consecutive use by these parties to show that they've made this open, overt use of easement too, and we just don't have that.
Okay. What about the question of if you can't abandon an easement, which is what case law appears to say, how could an easement be adversely possessed against you? Non-use doesn't mean you've abandoned the easement. I guess other than someone knowingly and conspicuously, which I don't believe the evidence shows Nykerk did at all. And as this became messy between the Andersons and the Davies, one could argue, okay, then maybe the Andersons were saying, we're claiming this is our space, but we're not anywhere close to 7 or 20 years. Can I apply that same case law that says you can't abandon the principles behind it, like you can't adversely possess an easement by saying the other side never used it? Because I don't think there's any evidence. Ms. Nykerk didn't say, oh yeah, we were always up in that space. It was a buffer. We dumped some stuff in it. And so did everyone else. The neighbor, everyone dumped in it. So everyone was using it as a natural buffer and as a place to dump some things. And so that's not abandonment or non-use really by anyone, but it's certainly not, the grantor, am saying you are now not able to use this easement. I don't see any evidence of that until the Andersons and the Davids started running ads.
And that's why we say there is and can be no adverse possession in this case. You know, Your Honor, we have that landscape plan, and just by way of example, let's say Mrs. Nykerk and the Nykerks had implemented that landscape plan shortly after they had purchased the property. And they then sold it to the Andersons with that, you know, that they had already converted all of the easement to, and they had this stuff, and that was adverse to the interests of the Darbys. Perhaps then you have that situation. We do not have that situation here. And so this is a claim that just falls flat on its face. It cannot be moved out, and that's why we're moving for a directed verdict on it.
Okay, I'm trying to pull up the second amended complaint, so we've got all the pieces. So number one, that was final. Mr. Edward, when was the second amended complaint filed?
I believe
I found it.
the second amended complaint raised the claim of nuisance. That was in early 22, I believe.
Yeah, February 23rd, 2022.
But the only,
But you kept everything, I'm just trying to see, the only thing that I add to the second amended complaint will be the adverse possession pieces. You had a couple amended complaints where you said, hey, I'm just adding this one piece. So it didn't restate the entire complaint. I'm trying to just see it all in front of me at once. And second plus adverse possession gets us to where we are. All right. Because if I'm gonna grant a directed verdict on anything, it's actually to a count and not to a concept. So count one is quiet title. Count two is declaratory judgment. Those, I believe, are both questions for the court. Count three is trespass, which has to do with the people walking across the property. Count four is nuisance. Then we get to attorney's fees and punitive damages, and then it's the adverse possession at 7 and 8. So, you are seeking a motion for directed verdict on count 7 and 8. We discussed that. You and I don't need to talk about it anymore. I'll hear from Mr. Edwards in a minute. Are you seeking a directed verdict on any of the other counts?
I believe that is all for now.
Okay. Mr. Edwards, what we've got on the table is some concern about your ability to argue abandonment. I don't think you need to address that because that's not a claim, a count. It is the way you're gonna argue that you're gonna argue how you wanna argue it, but it affects the David's rights and claims. I think what we're really talking about is the adverse possession piece.
Judge, with all due respect,
It's never good when you start that way.
well, I understand. I'm looking for the order, on the original order on the special master, and I can't find it. But let me view this. We do have the first amended complaint because as procedurally what happened is we filed our complaint. They filed a motion to dismiss the quiet title. And the quiet title was based on abandonment. And the special master denied the motion to dismiss. He said it could be pled better, so we did. But he denied the motion to dismiss the quiet title claim based on abandonment. So we amended count one. Count one originally pled is deleted and replaced by the following. And we're talking about abandonment prior to the David's acquisition of the property. And you're right. While I do have a master's degree in finance, it is from the University of Alabama, so I may not be that smart.
Decimals aren't gonna work well for you.
No, things like 4th and 31 and 2nd and 26, that's what we relate to. But even by my math, 1996 to 2020 is 24 years. And by my math, 24 is greater than 20. So if we look at the amended count one in response to the special master's ruling, which denied the motion to dismiss, he found issues of fact. It's not an issue of law, it's an issue of fact in this case. Because easement 2 has been abandoned by more than 20 consecutive years as a result of both positive adverse use by the servient owners and non-use by the dominant owners as reflected in the Darby deed. The Andersons seek an order from this court giving them full and complete right to the title formerly burdened by easement 2, free and clear of any rights. So we have stated a claim for abandonment.
So you think that part of count 1, quiet title, is actually a jury question and not a judge question?
Not only do I think that, the special master found that.
Well, the special master is sort of out of the picture now. We're dealing with what gets in front of the jury. How do you respond to not 1 or 2, but I don't know however many cases it is that say, you really can't abandon an easement? Why does a jury get to decide something that would contravene case law?
Well, actually, the cases are all over the place on this. As explained in the case of Gilbert versus Reynolds, the cases are all over, but
Can I have the site for Gilbert?
the site is 233 Georgia 488. And it says here on the, do we have an extra copy of this? Oh.
I can, don't worry, I'll look.
Okay. An extra copy? Well, we'll get you a copy. And on the Penn site on page 335, the end of page 335, there's a long quote from a bunch of prior cases. But it concludes by saying this: as we have stated in the second division of this opinion, an easement of way acquired by grant will not be lost by non-user for any length of time unless there is a clear and unequivocal evidence of intention to abandonment. Furthermore, no presumption of abandonment arises from mere non-user for a time less than that required for the perfection of the easement by prescription. So in other words, non-use of an easement for 20 years, while it does not automatically result in extinguishment like adverse possession does, it raises a presumption of an intent to abandon. And that's the case law, and that's in our jury charges, and we'll talk about that later. But there's, to say that an easement acquired by a deed can never be abandoned by non-use for any period of time is not a correct statement of the law.
What's the correct statement?
The correct statement is a presumption arises by non-use for 20 years, which can be rebutted by contrary evidence.
And is 20 years a bright line number, or that's what that case said, or that's tied to the whole adverse possession number? Where does 20 come from? From Gilbert?
20 comes, I believe, if you go back to all the old cases, the Tietjen case from 169 Georgia, which is back in the 30s, I believe. I believe the 20 years comes from
Just spell T, now I want to.
Tietjen, Tietjen versus Meldrim, Meldrim, 169 Georgia 678. But this is from Gilbert, and I will.
Actually, I'm looking at Gilbert now. I'm
Okay.
seeing what you're saying. So there is a presumption, but that's all you get as opposed to prescriptive title. If this were the Anderson saying, you know what? That wooded area was your property, Debbie. It was on your plat, your deed, et cetera, but you haven't used it and we have for 20 years. They get, what, with an easement, all it gets you, the 20 years of non-use, is the presumption.
Correct. Which makes it a jury issue.
Okay.
There's a presumption of abandonment, and in Gilbert, it also says this, and I'm looking at the other column, the current of authority seems to be that mere non-user for 20 years affords a presumption, though not a conclusive one, of extinguishment, even in cases where no other circumstances indicating an intention to abandon appears. And if there's been in the meantime some act done by the owner of the land charged with the easement, inconsistent with or adverse to the right, a much stronger presumption of extinguishment will arise. So the law is clear that it's not an issue of law for the court, it's an issue of fact for the jury. And we've got non-use for 24 years. That creates a presumption of abandonment, and contrary to one of the central themes that Ms. Sturm seems to be making. The fact that there is a subsequent deed doesn't start the 20 years clock running again.
And I'm not heading in that direction anyway, but walk me through why, if the easement is for any use at all, and use could be, it sure is nice having foliage there, so I don't have to look at West Andrews, or I can't remember, I guess what you see if you're looking in that direction, if it were clear cut, you might see cars go by. And so I'm actually using it. My use is, it's a buffer. How do you square that allegation, or why do you get to say non-use, the use has to be the kids playing lacrosse on it? And the fact that there wasn't someone playing lacrosse on that means it wasn't used when the easement is for any use whatsoever.
Well, and that's a disputed fact, okay? And we do have, we're probably going to have testimony from Ms. Darby today talking about how we used it by not using it. And we
The
think,
jury will work through that.
we think there is a jury issue as to the difference between active use and passive use. And as Ms. Sturm has often suggested to me, I like to pull up the Webster's Dictionary or Black's Law Dictionary. And the definition of use.
But you can stop, I know what use means, and you're gonna need to thread the needle with the jury, but I think you get to thread that needle. I don't find that, having that be a wooded area that, blocks your view of a street, maybe makes it difficult for people to get in your backyard, is a use of it. But you're gonna be able to argue to the jury. I think you made a good point, and it was helpful to read Gilbert. I think that, I get what part of count one is going to the jury. Let's go to adverse possession.
Okay. Adverse possession is the same, similar theory, but the law is clear, and we cited this in my letter to you a few weeks ago on this subject, that adverse possession is an alternative theory. There's the argument that the sole and exclusive means to extinguish an easement that burdens somebody's property by abandonment is just not the law. For that, we cited Jones versus Lick Log Creek, Inc., 336 Georgia Appeals 899, a 2023 case. Cert was denied in that in August of 23. Cert, C-E-R-T. Says, however, and in this case, there were claims of both adverse possession and abandonment of an easement. And the court said to prove abandonment of an easement, there must be clear and unequivocal evidence. Here, plaintiffs only need to prove adverse possession by preponderance. And this is similar to the case of Kelly versus Randolph, a case that Mr. Schneider handled, where the court said it is undisputed, and dealt with an easement, adverse possession of an easement, and the court affirmed summary judgment in favor of the dominant, the Anderson's type, the burdened property. Said the building of the terraces changed in nature, but basically it was a different standard of proof. Is obviously for abandonment, we have a higher burden. We've got to have clear evidence of two things, non-use and the additional element of intent to abandon. On adverse possession, all we have to prove is adverse use for a period of 20 years. And again, just with, again, at the risk of saying with all due respect, just to perfect the record, Webster's Dictionary of Use, number one, is to put or bring into action or service, employ for or apply for a given purpose, which seems to certainly support the argument of active use. Mr. Schneider and I both like to exercise by riding our bicycles. He's obviously much fitter and faster than I am. We both use our bicycles, take them on the road and we ride. If I said, I use my bicycle, it's down in the basement, it's got cobwebs on it, hadn't been ridden in 20 years, that's not using my bicycle for exercise.
Got it. All right, anything else on adverse possession?
Yeah, on the adverse possession, the pattern charges on adverse possession that we have requested, that in the draft, you're not going to give, is actual possession may be evidenced by enclosure, cultivation, or any use or occupation of the lands that is so notorious as to attract the attention of every adverse claimant. So we're looking here at a street view image of the access point for alleged ingress and egress of easement 2 for West Andrews. This is impassable. Or the jury, it's an issue of fact, the jury may find this to be impassable.
What is it that the grantor did? I think the problem with the argument is that there was, you don't like the word use, but there was passive use, or there was non-use by everyone. And the language you just read to me is that you've got the person who's claiming adverse possession pointing to facts where, you know what, I put up a fence, or I regularly mowed it, or I put a sign on there that says Anderson's, or I did X or Y or Z. And I don't think you got evidence that people did much of anything, especially with the picture you just showed us, that anyone did anything with the stuff that's curbside. So I'm trying to follow, especially the 7-year claim, what the open and notorious things were that were happening for over 7 years that no one did anything about.
Well, the language I just read from pattern charge 50.110, which as of now you're not going to give, may be evidenced by enclosure. And it doesn't have to be a man-made structured enclosure. We submit, a jury may find this is enclosure of easement 2. That's number 1. That's enclosure.
Enclosure by the person claiming, is there any evidence in the record? Because this is a motion for directed verdict after you've made your case. Point to a fact in the record that the Andersons or the Nykirks enclosed it. Whether they put up a fence or they planted things.
Judge,
Because otherwise you're back into, oh, it's passive. And you can't have it both ways. If it passively became enclosed, as it was being passively used by everyone, it became enclosed. So my question is, what's in the record that the Andersons or the Nykirks took any steps to enclose the easement?
well, I submit to you that this mosh pit on the street frontage, that is enclosure. That blocks it. If you look to the right, it's cleared. So they made active use of clearing the portion of their front yard outside of the easement and allowed the rest of it to become overgrown and impassable. To me, that's a jury issue for use. Second, this theory of, oh, we loved it for natural wooded beauty and this, that, and the other. Using it as a dumping ground is the opposite of natural beauty, wooded area, nature, all that stuff.
That's usually.
Right, the Nykirks used it, not the Darbys. The evidence is that the Nykirks and their predecessors let the street frontage become overgrown so it's impassable, and that they used it by using it as a dumping ground. And
Was it a dumping ground, like there were old cars there, whatnot, or it would have been, or compostable things where if you are on the grantee side of things and looking over there, like, hey, it's still green. I don't have to look at West Andrews or the neighbors or whatever that natural backdrop provides you.
well, if we're
I
going,
hear Ms. Nykirk say, yep, when our Chevy ran out of love, we just parked it on easement 2 and let it get overgrown. Or that's where we throw our old furniture or dead bodies or anything like that.
well, dead bodies are compostable.
Okay, so that'd be another dead.
So anything, there's no requirement in the law that I have seen, and they certainly haven't cited any, that says use has to be with man-made materials and, or non-decayable materials.
I'm not suggesting that Ms. Nykirk saying we and others put things on easement 2 is non-use. That's not my point. That's why I was asking what you think is in the record that would suggest they're using it, your phrase was dumping ground. And that may have been Ms. Nykirk's, but if the dumping ground was for grass clippings, I'm over on the other side, I don't see those grass clippings. I'm wondering why that's adverse use, as opposed to, it's not interfering with my easement rights. And the way I'm exercising my easement rights is to say, this is a nice buffer, I value that buffer. It is not the Nykerk's clear cutting it and putting up a place to hang their laundry to dry.
Well, it's not just grass clippings. There is evidence in the record from both Ms. Nykerk and Mr. Anderson that it was used as a dumping ground for railroad cross ties. Now, technically, those are compostable, but it takes 50 to 100 years. That is clearly trash. That is clearly an adverse use.
All right, that's enough. I get it.
Okay.
That is a jury question.
All right.
Good luck with the jury on that one.
Thank you.
I want to pivot back to, you talked about adverse possession, you talked about abandonment. That's what Ms. Sturm brought up. So I need to ask her a couple of questions and we can move on.
Okay.
So Ms. Sturm or Mr. Schneider, your thoughts about Gilbert v. Reynolds standing for the proposition that if it's been abandoned for 20 years or more, there's a presumption of intent. I'm asking because a more recent case, Sermons versus Agasarkisian, I'm not going to spell that for the court reporter, I'll give you the site so you can look it up. 323 Georgia Appeals 642 says that Gilbert stands for the proposition that there's no abandonment of an easement where the defendant owned the property for only 13 years. This easement went back to 1880 and it's recognized in the chain of title by both parties. That's this case. Everyone knows there's an easement and it's actually resetting the clock for each owner. So frankly, it doesn't matter what Nykerk's did or anyone else. What's relevant is what did the Davids do? They got this easement. It wasn't contested at the time. The Andersons got the easement and the Davids haven't been there for 7 years, or certainly not before this litigation started, and they're far, far from 20 years. So it seems like that presumption wouldn't apply. That's how the appellate courts are applying Gilbert versus Reynolds, is that you have to look within the period of ownership that's at issue, which would be David ownership, which is far, far short of 20 years. And so there's not even a presumption of intent to abandon. Your thoughts?
That's exactly correct. There is no presumption of intent to abandon. We believe that's clear in the case law. And I don't think Gilbert v. Reynolds is applicable. I think it's factually distinct from what we're dealing with here. We are talking about rights in an alley. It is, in this particular case, I think that, well, there's several perhaps frustrating aspects, but it simply, there's a mixture of abandonment and adverse possession that is going on or is attempting to go on. And that is one of the problems with that, is that you heard Ms. Nykerk, she said, even they use it as a buffer from the neighbor behind them. And there's no open and notorious use by her that would tell somebody else, hey, we're using this easement to your disadvantage.
Or you're using it in a way that doesn't interfere with the right of enjoyment. I mean, you don't have this in the record yet. So I want to short circuit this. I'm going to deny your motion right now, but I'm taking it under advisement. I'm going to absorb more of Gilbert. It's an important case. I appreciate Mr. Edwards flagging it because it throttles back a little bit on the, hey, you can never ever abandon an easement. Not so. And in fact, there can be a presumption of an abandonment. I need to know if that applies here, so I'm going to think about that. It may well be, when everyone rests, that I still grant a directed verdict, either on the quiet title abandonment piece or adverse possession or both. But a lot of this will shift if the prior owner of the David's house testifies in the way you're saying she's going to testify, which would be, hey, here's how I was using it. And we can get all technical about you only use the bike if you ride it. But you don't ride trees, is that? So there could be a different way in which you benefit from and enjoy easement too. But that's not in the record yet. That's an argument. I do want just a few words from you about the adverse possession argument that we heard, that in fact it has been adversely possessed, and that's a lower burden of proof for the Andersons.
Look, and this, one thing I will say is conceptually, the argument is impractical too, simply because if we think about green space, and we know green space exists in its natural format, Mr. Edwards' argument is that after 7 or 20 years, it would just become, it could no longer exist in that space. And we know that not to be true. There is a reason and a purpose that we do have green space places. The principle, and we've talked about this before, that a landowner cannot adversely possess against itself is rooted in the very definition of adverse possession. So in order for you to take possession, that possession must be exclusive, it must be continuous, and it must be hostile. We have none of that here. We have nothing more than Ms. Nykirk saying, yes, I agree, it was used as a buffer. Hey, my landscaper may have also dumped compost, landscape materials, his clippings, his whatnot. Even if we accept that as true, it is not exclusive, it is not continuous, and it is not hostile to a use as a buffer. And she admitted that use.
Okay, well, I think that you ought to renew your motion after you present your case, because as the record stands, I think that Mr. Edwards has pointed to questions of fact that would exist that a jury could navigate. And my role isn't to say that a compelling question of fact or not. The motion for directed verdict standards is a real high one, because you're trying, appropriately so, to take something from the jury. But I do find that there are points that there's evidence to which Mr. Edwards could point, and a jury could say, based on that, we think that that was sufficiently open and notorious, or that shows abandonment or whatnot. So I'm going to leave it open for now. We'll revisit it, and I will become more richly informed on the state of the law post Gilbert v. Reynolds, which is from 1975. So there has been some evolution of that. Not that we have many new property laws. Presentation from the David's attorneys. You call your next witness, please.
Yes, we call David Shoecraft.
All right, it's coming up.
Before you sit, can you raise your right hand? Do you swear affirm that the testimony you will give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You can only have a seat. Can you state and spell your name for the record? You have a seat.
David Shostak. David Shostak.
Good afternoon, Mr. Shostak. Can you tell the jury what you do for a living?
I am an arborist and an urban forester.
Okay. And can you tell us what is an arborist?
An arborist is somebody who specializes in the care of trees, and the identification of trees, and the care of an urban forest and things like that.
No, I'm sorry. I didn't just have to direct witness.
Sure, Scott, unfortunately, the microphone doesn't move, which means you have to move. So if you could just, it actually bends all over the place. The base doesn't move. So if you move it more towards you, you're a soft-spoken arborist. You make sure you can hear your words about arborism.
Sure.
Thank you.
Can you tell us briefly your educational background?
Starting way back, I have an associate's degree in math and science from Nassau Community College in New York. I have a dual bachelor's of science from the College of Environmental Science and Forestry in Syracuse, New York, in forestry and ecology. I have a ecology. I have a master's from Auburn University in forestry, and I did some post-master's work working towards a PhD at the University of Missouri in Columbia.
And where do you currently work?
I technically have two jobs. One is I am the city arborist for the city of Alpharetta, and my other job is as a consulting arborist for a company that my wife and I own.
Okay, and what is that company called?
It's Cadis Incorporated.
Okay. Can you give us an idea of your job and responsibilities as city arborist for the city of Alpharetta?
Sure. At the city of Alpharetta, my main role is to enforce the tree protection ordinance. In doing that, I handle all of the tree removals from private property, as well as all of the plan review for all of the new developments that go on throughout the city. That involves reviewing tree surveys, reviewing arborist assessments, making sure that the trees that are supposed to be preserved are preserved, and making sure that the trees that are supposed to be planted are planted. In addition to that, it includes all of the landscaping that needs to be planted as well. Trees, shrubs, ground covers, turf grass, everything like that, all gets reviewed by me.
Okay. And do you go out on site to review?
Yes, I do go out on site to review tree surveys as well as verify the tree assessments. Basically, what I need to do is look at the reports from a third-party arborist and verify if what they're saying meets the science and the code. So I do that, verify tree surveys, making sure that if a tree's on a survey, it's there, or if it's not on a survey, it's not there. The sizes are right, all of that kind of stuff. A lot of this revolves around tree condition as well.
Okay. And you mentioned you have, outside of your city job, you have a consulting practice. Is that correct?
Correct.
Okay. And can you tell us about your jobs and responsibilities at your consulting practice?
Yes. So that consulting firm is a registered engineering firm. I am the arborist and environmental scientist for that firm. Most of my responsibilities revolve around doing arborist assessments. For example, one of the things that I do, if somebody calls me and says, hey, I have a tree in my yard, do I need to remove it? Do I need to care for it? Is it in good condition? I will go out and do those assessments. I also do risk assessments for trees. So if somebody calls and says, I think there's a problem with this tree, I do a full assessment to determine the biological and structural health of that tree to make sure it is safe and there's no risk associated with that tree. One of the other things that I do is appraisals and valuations for trees and shrubs that may have been removed from somebody's property without permission, in order to put a value on that for whatever the reason may be, whether it's a insurance claim, legal matter, or anything like that. Those are just some of the quick things that I do.
Okay. And you talked about valuations for situations where there may be a clearing already and you have to go out and value it after the fact.
Correct. I've done a few of those where all of the vegetation had been removed all the way down to the stumps, and I have to go and provide a value of what was assumed to have been there.
Let me ask you this. Are you a licensed arborist?
Technically, there is no licensing for arborists. It's a certification. It's a third-party certification through the International Society of Arboriculture. And I am a certified arborist, yes.
Okay. And do you maintain that certification in good standing?
Yes, I do.
Okay. Are there some kind of like continuing education or classes you attend to stay up to date?
Yes, you need to get a minimum of, I believe it's 30 continuing education credits every 3 years.
Okay. I want to focus us back for a moment to what you were talking about, the component of your work that focuses on appraisal or valuations of trees and shrubbery. Are there certain standards and methodologies you utilize in doing that work?
Yes, there are.
Okay. And can you explain that process to us?
Yeah, so there are 2 guidebooks out right now. One is the 9th edition of the Guide to Plant Appraisers. One is the 10th edition. Most arborists that I know are still using the 9th edition because the 10th has come out and there's been a little bit of controversy about the techniques. So, but in addition, when this was done previously, the 10th wasn't really out yet. They were still doing revisions and things like that. So With the 9th edition, it is a guide. So it provides you with how to do the appraisals, what you're supposed to look at, how the formulas work and everything like that. I also use other publications that have been provided as guidance documents on the guidance document, on the guide, to, come up with my formulas that I use from the guidebook and the different ratings that I use to put into the formulas to get the final results.
Okay. To kind of help the jury understand how this process might work, can you tell us, so with regard to a situation where you've been hired to go out and value trees and shrubs that have already been removed, walk us through how you would go about that process.
Do you mean remove down to the stump, or do you removing the stumps are still there?
Okay, well, you tell us, is there a difference in how you would value if the stumps were still there versus a complete removal?
Yeah, so let's start with if the stumps are still there. So if the stumps are still there, I would go out and I would measure the stumps and identify the stump species, genus and species. In doing that, I would also do a condition criteria on the stump. And then I would also look at surrounding vegetation to determine if the condition is good on those trees, because without having the actual tree there, you have to go off of the data you can find. So I would look at the stump, measure it, identify it, and then, like I said, look at the surrounding vegetation to make sure it was good, fair, poor, whatever the condition may be. In addition to that, you look at the location, because the location matters. And then I take that data, collect all sorts of stuff, take a bunch of photos, bring it back to my office, sit on a computer, clean up the data, run it through a spreadsheet, and then that gives me the value of the vegetation that had been removed. Now that's a tree. If it is a shrub, I do the same basic data collection, but I also have to make an assumption about how large the shrub was. Because when I do replacement values on shrubs, it's a replacement value. So if you have a shrub that is 3 feet by 3 feet, then you go to the nursery and you say, oh, a 3 foot by 3 foot shrub costs this much, and that's the value you use. Going back to the trees, and I may be jumping ahead a little bit, but going back to the trees, what you do is you take the value of a smaller tree and you extrapolate it to the size of the tree that was removed to get an overall value. Included in that, in the formula, you have 3 ratings, like I mentioned before. One is for condition, one is for location, and one is for species. So different species are valued at different amounts from 1 to 100%. Different locations are valued from 1 to 100%, and a condition rating is based on 1 to 100%. So those things also get put into the formula to determine the overall value of that tree. So I guess I'm jumping back and forth between trees and shrubs, but that's how you come up with the value of the tree versus the value of a shrub that typically can be replaced in kind. If the shrub is so large that you can't replace it in kind, you typically calculate a volume. So if it's like a 10-foot tall by 10-foot wide shrub, you figure out the volume that shrub takes up, and then you figure out how many smaller shrubs that you can buy fit into that volume, and then you come up with your value based on, so if it takes 10 shrubs to fit in that volume, that's how much it is, 10 times the value. So that's how you do that. Now, moving on.
And now you're talking about, so we were just talking about what happens if you have stumps on the ground.
Correct.
And now you're going to explain to us what we do if we don't have any stumps on the ground. Is that correct?
Correct.
Okay.
So if you don't have any vegetation and everything's been removed down below the stumps have been ground, dug up, whatever it may be, the standard protocol is to find an area that you have determined to be similar in nature. and collect your data there. There's two ways you can do that. One way is by sampling the data. If it's a really large area, talk with my hands. If it's a really large area, then you do samples, and then you use standard sampling techniques to blow it up to the area. In a lot of cases, the area is small enough that you could actually measure out an area adjacent to it that may be similar, the same size. And then you collect all the data in that similar area and you do your valuation based upon what you find in that area. Again, trees and shrubs and ground covers, anything that you're looking for.
And so we don't have to repeat ourselves. Is it fair to say the valuation process is the same?
Yes, the formulas that you use or the valuation that you use for shrubs is the same either way.
And is that standard in your industry for valuations of trees, shrubs, vegetation?
Yes, it is. It is a formula found again in the 9th edition, which is what I've been using.
How many tree vegetation valuation appraisals have you done?
I went back and kind of tried to determine it. The ones that I've actually recorded and have files on is about 20 or so.
Okay. And do those involve, I think you indicated earlier, but do those always involve litigation?
No, they do not.
Okay.
No. As far as litigation goes, I believe of those 20, I've only dealt with actual court cases where it's somebody v. somebody about 7 times. I believe that's the number.
Thank you, Mr. Shostak. Your Honor, I would move to tender Mr. Shostak as an expert arborist and in the area of tree and vegetation valuations and appraisals.
Ms. Medwick, do you have any objection to that, or do you want to examine Mr. Shostak on his credentials and qualifications before I rule on that request?
I think I would like to examine on a very small issue that is kind of vague at this moment.
Sure.
Good afternoon.
Good afternoon.
I'm sorry?
I said good afternoon. There's an echo in here.
Yes.
Wide open.
Sorry.
All right, I muted it. He said good afternoon.
I thought he asked me something and it was other voices, so, you know.
Say that.
Sorry about that.
That's all right.
You mentioned a couple of times a ninth edition, guide that you use to, and that's instructive of performing these appraisals. Did I catch that right?
Correct.
Okay. You also mentioned that you personally use some other publications to guide you in your appraisals. Is that what you said?
Yes.
Okay. What other publications do you use?
I don't have a list of them in front of me. However, they are listed in the back of the report I presented as references.
Do you need a copy of that report?
Sure, that'd be great.
Okay.
Thank you. Do you want me to read these off?
Yeah, tell me a little bit about these publications.
Okay, so before I read off the publications, I'm going to say a lot of these publications are designed for the layperson. So there are terms and there are other information in there for the layperson to understand. The reason why I use these publications is because they give you definitions for the different condition classes of how you determine the condition. They give you the species class ratings because there is no species class ratings that I could ever find for the state of Georgia anymore. They stopped publishing that years ago. I do not know the year they stopped publishing that. So I do use those publications for the condition rating definitions. I do use it for the species ratings, and I also use it for the definition of the location ratings. So that's the main reason why I use those publications. I can tell you they're publications from different universities. One of them is from, well, two of them are from Purdue University. One is from the University of Tennessee. Some are from the University of Kentucky. So I've tried to find those publications that have that data in it as close to the Atlanta or Georgia as possible.
Okay, and thank you, and thank you actually for talking about them generally, so we can kind of condense this. So if I'm understanding what you said about the publications that you used, is you're using publications from universities talking about species identifications in other states because you don't have them for Georgia, and you tried to get states that are as close as you could get?
No, they're not species identifications.
So
They're
what-
species ratings for the
Ratings.
formulas.
Okay.
It's the species rating has to do with the intrinsic value associated with a tree. So for example, an oak may be rated higher than a pine tree because people like them better. So that's what those ratings are. And that rating gets put into the formula to come up with a monetary value based upon that rating.
Who decides, who's the arbiter to say that people like oaks more than pine? Feel bad for them. I got some.
Yeah, I always say that I hold no biases against any tree. But the arbiter of that typically is a group of arborists and horticultural professionals put together in each state that puts these guides together. And like I said, the one in Georgia hasn't been published in a few years, and I don't know what that few years is. I just never have seen one. So I do go to Tennessee, and I do go to some of the closer states. And
Going for the closest approximation you've got.
that's right. And I can tell you, again, this is off the where we're going with this, but in Tennessee, because a yellow poplar is the state tree, it is given 100. And I know here in Georgia that a yellow poplar is not given 100, and I don't. So again,
Whatever Alabama's tree gets.
yeah.
So is that a standard in the industry that you might kind of pick and choose publications for species ratings to help you out in a different state?
You're not picking and choosing to help you out. You're trying to find the closest data that you can use for your valuations.
Is that an industry standard, though?
It is an industry standard that you can use information that's out there if you don't have it for your state.
Okay.
So meaning there's none for Georgia. There's no published data for Georgia right now.
So there's no arborist in the state of Georgia who could perform the type of appraisal you're talking about that would have that information available to them?
There's no official publication with that data in it for the state of Georgia. So if an arborist was able to find that data that was published by a professional organization that had that data, I would gladly use it, but I have not been able to find it.
Okay. And does that kind of cover your explanation of those other guides that you use?
Yes, that is why I use those guides.
Okay. Thank you so much. And I'm going to get that report back.
All right, so on the table is a request to have Mr. Shostak qualified as an expert in the field of being an arborist and some of the valuations of plants. Do you object to that or not?
I do have an objection because I think there are some concerns about, I mean, we're talking about very specific Georgia property.
Sure.
And
Is your concern about the weight that jurors would give his opinion because he's already explained there weren't some resources he thought would be available? Because that's not the question. The question is he qualified as an expert? Your questions you were asking him had to do maybe some of his methodology but not so much about the degree of his expertise or his ability to offer an opinion that a layperson such as myself wouldn't have about the value of a tree, which you're free to explore with him. Hey, you're really triangulating. This is what Tennessee arborists say a tree is worth, and so what do we do with that? And he may say, I'm going to give you a margin of error.
I mean, he's given a description that he's done 20 of these, and that it sounds like there's really no comparison with anything Georgia related. So it makes me wonder about how is this reviewed? How is this accepted? I mean, we've had very little information about that.
Got it. I feel like we've had enough. I will qualify you as an expert in those two fields for the purposes of these proceedings. Of course, Ms. Medwick will be able to follow up when she's asking me questions about the very concern she's got.
Thank you.
Back to you, Ms. Sturm.
Thank you, Judge. All right, Mr. Shastak, can I draw your attention then to 3377 Habersham Road?
Yes,
Are you familiar with that property?
yes, I am.
Okay, and how are you familiar with that property?
I was hired to do an appraisal and valuation of the cleared area from the easement.
Okay, and did you go on site and look at the area?
Yes, I did.
Okay, do you recall when you were on site? Have you been on site more than once?
Yes, I have.
Okay, do you recall the first time you were on site?
I do. I believe it was April 20th of 2021.
Okay.
Or April's. It was in mid-April of 2021. I don't want to give an exact date.
Did you prepare a tree appraisal valuation related to your assessment of the clearing of easement 2 in association with the 3371 Habersham property?
Yes, I did.
Okay. Hand you that document. Do you recognize that document?
Yes, I do.
Okay, and can you tell us what it is?
This is the report I prepared for that valuation and assessment.
Okay, and if you turn to page 2, you don't have to read it for us, but just take a look at the top. Does that refresh your memory of when you may have been out on site the first time?
Yes, April 17th,
2021?
2021.
Okay. Can you tell us how you went about performing your tree valuation and assessment for this area? And let me strike that for a second. Mr. Shasak, were you out, did you bring anybody out on site with you?
I did not bring anybody with me.
Okay.
I was with Mr. David. David, sorry.
Did he stay for the entirety of your assessment?
He did not.
Okay. Can you please walk us through how you performed your tree valuation and appraisal for easement area 2?
Yes. So when I started to do the data collection, basically what I did was I measured the cleared area from the easement to find out length and width. And then what I did was I looked around and I selected an area that I assumed was similar in nature to the cleared area. This was also selected in a manner that was as random as possible. I didn't really have the ability to do much of a random selection, but I did review aerial photographs and street view photos beforehand. So I had a good idea of what the cover looked like from above. So once I selected that area, I did pull out my 100-foot tape and I marked some corners and made sure it was the same size and approximate shape. And once I did that, then I started to systematically go through that area and collect tree species and diameters and condition. And then I did the same for the shrubs. And then I did the same for the ground cover species that were in that non-cleared area.
And Mr. just to help us and the jury understand, earlier you talked about what you can do if there's stumps existing and what you do if there's not stumps existing. In this situation, did you evaluate easement 2 to determine whether there were any stumps existing upon which you could do your assessment in that manner?
Yes, I did. I walked around the easement area that was cleared. I probed in the soil. I moved the pine straw around, looking for stumps to see if there were any present or if there were any remnants of stumps that I could find.
Did you find any?
I did not.
Okay. Did you encounter other objects on easement 2?
Yes, I found there was one tree remaining in easement 2. It had a light on it. I believe I found some irrigation heads in the easement area. Also found wood chips and pine straw. Some of the vegetation, the ground cover vegetation, like the ivy, English ivy, I believe had already started to grow back around the periphery.
Based on those observations, how did you determine, I guess, to use, instead of the stump analysis, you went with this alternative analysis? You've got to evaluate it under a different scenario. Was that based on your observations that day?
Yes, that was based on my observations that day, that there was nothing there for me to observe and collect data on within the easement area.
Okay. Judge, I would like to pull up the cover of his report so that we can help the jury see where he's evaluating.
Report in evidence?
No, and I would object to the report being in evidence, Your Honor.
Well, the report can go into evidence. It doesn't mean it goes back with the jury. And given that someone's talking about it, it may make sense to make it part of the record. That doesn't mean that the jurors will necessarily see its contents, but given your concerns that you've raised during your voir dire of the witness, what number is this?
This is Defendant's Exhibit 20.
Okay, so I will admit Defendant's Exhibit 20 for the record. Now, if you would show Ms. Medwick the page that you want to publish, she may not have an issue with that page. That's not going back to the jury. And I will look at Exhibit 20.
If it's just a picture, that's fine.
I could do a call out of just a picture.
Yeah, if it's just a picture, that's fine.
All right, why don't we present just the picture from the first page of the. You're ready to get back on the record. All right, we're back on the record in the case of the Andersons versus the Darby's. And during the break, Mr. Edwards and Ms. Sturm and I discussed a concern Mr. Edwards had. It wasn't even a concern, I appreciate him flagging it. It was, so this doesn't blow up, during his cross-examination of Ms. Sturm about her legal fees. Mr. Edwards is going to ask about communications that he sent to Ms. Sturm about a possible, his term is de-escalation, tensions over the easement 2 area. I'm going to allow him to enter those emails into the record, reference them and share them if he needs to with Ms. Sturm, ask her, did she get them? And then did she pass them on to her client? So Ms. Sturm, you're free to answer in all the ways you think are appropriate to his questions. And you are objecting, one, because you think it violates 408. And you also want an opportunity, which I'm giving you, to supplement the record, again, not for jurors, with any emails that would fully round out the nature of the content of the dialogue between Sturm and Edwards at this time. Is that a fair summary of what we talked about? And if not, feel free to add any other objections you want to my ruling that Mr. Edwards used.
I think that's a fairly fair assessment of it. I would just add for the record that we will object also to the extent that it seems to be a cherry-picked, one-sided characterization of a communication. It seeks to insert attorneys as fact witnesses into the case, and we think it is more prejudicial than probative.
Okay, thank you.
Your Honor, before the jury comes in, I want to make sure that we have clarification before more substantive questioning starts happening. When we were talking about the motion in limine, I know that you said testimony about the vegetation was coming in. Is it still that limited?
That was my understanding. I was sort of surprised, but always happy to meet a new witness. I didn't think we'd be hearing from Mr. Shostak based on how, say your last name again?
Shostak. That's
Shostak. Based on
correct.
our discussion about the motion in limine, I thought my ruling was have at it with the vegetation, but with the missing trees based on what I understood the record would become, and as I think it has become, we wouldn't be getting into a valuation of allegedly missing trees because there's no stumps, there's no, here's what it used to look like. Here's some nearby stuff. And so I think there ought to be a few more trees here. Has that changed at all, Ms. Sturm, or you're still, when it gets down to the brass tacks of Mr. Shostak's expert opinion and valuation is going to be the value of the loss or decrease in value of the clear cutting that occurred in terms of bushes, shrubs, non-significant trees. That's not the terms of art, but you know what I'm talking about.
Bushes, shrubs, under 6 dBH.
Yeah, that's what you're going to be dwelling on.
Yes, I without forecasting his whole testimony, I was just trying to, help the jury understand which methodology he chose and why,
Okay,
right? And then we'll move on.
that's all good, but you're not going to be saying, and what's the value of the trees that weren't there? Okay, does that allay your concern?
It does. And the reason that I wanted to bring that up was because it has been worded as the tree appraisal has been very forefront in the wording. And so I just wanted to make sure we were still on the same page.
We are. Do we have just the picture up on the screen now? I mean, all we have is Mr. Shostak on the screen, but,
It's sad when the happiest pleading you received in the day is a suggestion of death. You're a person party. That's terrible.
all right, can we check on the jurors, please? I guess if they're ready.
After all that, there it is.
Is that,
Yeah, that's it.
I got it for you.
All right, for the jury. Jury President, accounted for.
Thank you, Deputy Gordon. All right, let's resume, please, with the direct examination of Mr. Shostak.
Thank you, Judge. Before we took a break there, Mr. Shostak, we were talking about your appraisal valuation of easement area 2 and the easement area that you assessed, and then the comparable or the area that you utilized to make your valuation. We now have up on the screen an image. Does this help you explain to the jury, Can you kind of walk them through how you went about determining your appraisal area?
Yes. So this is an image I provided on the report. Basically, it's the property location map as well as the easement to and the areas where the work was completed. So if you look at the blue polygon, that is the easement area. And these are approximations because they're what I put on there, not a surveyor.
And can I stop you just for a moment? Your blue polygon, does it sits within that red,
Yes.
what are my shapes these days?
Yes, the blue polygon goes all the way from the bottom up. It encompasses the full red area. A little portion of the green area comes across and goes down. So it is the largest of the three polygons. The red area is the area that was cleared. And then the green area is the similar area that was adjacent. That is where I collected my data. The red area is the one that was measured. And then the green area was measured and the corners flagged. So I knew where I was and was able to collect the data only inside that polygon.
Can you tell us about your findings and observations related to the valuation of easement area 2 as it pertains to the vegetation, shrubs, and any trees under 6 inches DBH? And
Yes.
you may want to explain to the jury what DBH is.
Sure. DBH is what's considered diameter at breast height. That is measured at diameter, yes. Breast height. So it's diameter at breast height, and that is a forestry and arboricultural term, and it's 4.5 feet above the ground line. So that is where we measure trees, whether you're looking at it for timber or whether you're looking at it for aesthetic or whatever the reason may be. It's how you classify trees when you're doing reports of various and different reasons. So in doing my valuation of the area, there were approximately 4 trees that were under 6 inches DBH. And that's under 6 inches, not including 6 inches. And then there were various shrubs and ground covers of varying sizes and heights and types. If you would like me to go through that list, I would do so, but I need to use the report that's in front of me if that's okay.
If you need to refresh your memory on the types, if you could just give us generally the types of vegetation and shrubbery that you encountered.
Yeah, so I believe there was either an English or an oak leaf holly. There was a bunch of those. I believe there were some azaleas. There was this one called the Fuzzy Pride of Rochester. There was English ivy. Let's see, what else did I remember coming across? Do not recall the types of trees that I came across that were under 6 inches. It was back in 2021 when I did this. I'll just stop there
Okay.
without having the report for assistance.
Sure. If you want to take a look at the report to refresh your memory,
Yeah.
in your report, did you do a table identifying the types of vegetation and shrubs you encountered?
I did. It's on page 5.
Anything of note that you want to draw our attention to, Mr. Shostak?
What do you mean by that? What would you be?
You weren't sure if you had a complete list?
Oh, no, I did not have a complete list.
Okay.
So, I mean, I'll just run through the list. Do you want me to include the quantities as well?
That's fine.
Okay. So there were 11 English hollies, there were 2 azaleas, 7 tea plants, which is a type of camellia, 1 fuzzy pride of Rochester, 1 Mall's quince, 1 heavenly bamboo, which is a nandina, that's what you might know it as, and then there was English ivy and vinca. So those were the shrubs.
Vinca?
Vinca, yes, vinca. And then as far as the trees go that were smaller than 6 inches, there were sweet gum, water oak, southern magnolia, 2 of those, and that is it. That was smaller than 6 inches.
Mr. Shostak, did you take photographs when you were on site for your assessment?
Yes, I did.
Okay, let me have you take a look at Defendant's Exhibit 21. Do you recognize the images and have you had a chance to flip through it? Let us know if you recognize the images in that it's a,
Yes, so far these do look like my photos.
okay. Are these photographs of this green appraisal area?
Actually, they're photos of both areas.
And when you say both areas, is that easement area 2 that's been cleared and the appraisal area?
Yes.
Thank you. We would move to admit Defendant's Exhibit 21.
Any objection to defendants 21?
No, Your Honor.
All right, it's admitted.
Mr. Shostak, did you walk through the appraisal area?
Yes, I did.
You didn't have any problem walking through it?
No, I did not.
Mr. Shostak, turning back to your appraisal valuation, can you tell us the opinions you arrived at for the valuation of the vegetation, shrubbery, and any trees under 6 dBH?
Yeah, the total value of that was around $90,000.
$90,000?
Around $90,000, yes.
Does your report include, you had indicated earlier in your methodologies, how you go about valuing. Does your report include a table that identifies the valuations for the various shrubs, vegetation, and trees under 6 inches?
Yes, in the appendices section, there is a Excel spreadsheet that shows the valuation of the shrubs. And then there is another that shows trees on it. They're 2 separate tables or Excel spreadsheets.
Thank you. Mr. Shostak, did you return to the easement area 2 and Darby property prior to this trial?
Yes, I did.
Okay. And when did you return to the area?
It was about a week and a half, 2 weeks ago.
Did you have any encounter with Mr. Anderson while on site?
While I was on site, Mr. Anderson was over, I believe it was near his garage, and he was yelling, "See you in court, big boy." That is all I remember.
Thank you, Mr. Shostak. I have no further questions at this time.
Ms. Medwood, do you have questions for Mr. Shostak?
Yes, Your Honor. And y'all can leave that picture.
Okay. You want me to move it?
Good afternoon. I believe you testified earlier that you were first contacted. You said you weren't quite sure when you were first contacted by Ms. Sturm.
No, I didn't say that.
Oh, so when were you first contacted by her?
Oh, actually, you never asked that question. That was never asked when I was first contacted.
Oh, I'm sorry. I thought she asked you. So do you know when you were first contacted?
It was about a month before I did my site visit.
So in March of 2021?
Correct.
Okay. And do you remember what that email said?
I do not remember what that email said.
Okay.
I believe it was asking if I was able to do what an appraisal or evaluation and if I had any conflicts. I don't
Okay.
know the exact verbiage verbatim.
Do you, were you given any more information about this case when you were contacted?
Not that I remember.
Okay.
Just kind of take a look at these.
And let me know when you've finished reading them.
Okay, I'm finished.
Okay.
Did that refresh your memory a little bit?
Yes,
Okay. And so did that show that she contacted you on March 18th, 2021?
yes,
Okay. And did that also show that she let you know that she was representing the Davids?
yes,
And I think she also very clearly stated in capital letters that she did not represent the Andersons. Is that right?
correct,
She told you that her office sent a cease and desist letter to the Andersons?
correct,
Okay. And she told you that their specific concern was a clearing of easement 2, which was previously wooded and consistent with other wooded areas at the back of the David property. Isn't that what she said to you?
correct,
Okay. She sent you a survey of the David property.
correct,
Yes. And she referenced a marked up version of a survey in her email.
correct.
Okay. All right. So you gave a deposition about your evaluation. Do you remember that?
I do.
Okay. And I believe that was around January 20th of 2022?
I believe so.
Okay. And can you still see the picture on the screen?
Yes,
Okay. So if I'm looking at the picture on the screen, and that's from your report, it looks like the red box is the one that you marked with the cleared area that Ms. Sturm told you about? Is that right?
well, that was marked after I did my site visit.
Sure, but was that the area that was being referenced in the email?
Yes,
Okay, okay. And the green area, the green box, it's marked as your appraisal area, correct?
correct.
Okay, and isn't it right that you randomly choose an appraisal area?
It is as random as it can be when you have a limited area of space.
Okay. And how limited was your area space?
My area was limited to the two properties that were not cleared.
Okay. And what are the dimensions of the quote unquote cleared area that you were evaluating? Did you measure that?
I did measure that. I would have to look back in my report for those measurements.
Okay. Let's see.
So this just gives the square footage, which was about 1,800 square feet.
Okay, thank you so much. So that cleared area was 1,800 square feet?
Correct.
Okay. And you had never been there before you went to perform this valuation, correct?
No, I have not.
Did you know anything about that property before you went out there?
The only thing I knew about that property was reviewing some aerial photographs and Google Street View photos.
And of course, Ms. Sturm's email.
Correct.
Okay. But you wouldn't know when the Andersons purchased their property, is that correct?
Correct.
You wouldn't know when the Davids purchased their property, is that correct?
Correct.
You wouldn't know if before the area was cleared, if it actually contained weeds, yard clippings, poison ivy, plastic bottles, rotted wood, trash.
I wouldn't know that, but I did not see any of that in the Street View photos that I looked at.
Okay, and I believe you also said it was dense in some views, right?
The vegetation near the street, yes, was dense.
Okay, so would it be fair to say maybe you couldn't see all the way through inside there?
That's possible.
Okay. And you would also have no knowledge if anybody at any point in time had made any efforts to landscape it in any way, correct?
No, I would not.
Okay. So, let's see. I believe you said, well, do you remember kind of describing how you chose what you were going to compare the cleared area to?
Yeah, I mentioned that I looked for an area that was adjacent to it that had what I would assume to be the same or similar vegetation in it.
Bear with me for just a second, I'm dropping things.
Do you remember testifying in your deposition that you randomly picked a spot?
Yes, I do.
Okay. So I am going to ask you some questions about that table that you were talking about with Ms. Sturm with the ground vegetation. Remember that just a minute ago?
Which table? The table with the list or the table with the values?
The table with the values. And do you have that in front of you?
Yeah, I
Okay.
still have the report in front of
You
me.
still
yes.
have the report, okay. So starting with the English holly, is that native to Georgia?
No.
No? How big does that get?
I believe an English holly would eventually get to about 15 or 20 feet tall.
Okay. You said 15 to 20 feet?
Yeah,
Okay. And you estimated 11 were removed?
no, I did not estimate anything. I counted 11 on the appraisal area.
Okay,
That
so,
was not an estimate. It was an assumption of what was on the red area, but it was an actual count of what was in the green area.
okay, so when on the quantity removed column,
Correct,
you're counting things that are actually present in the green area
correct,
and assuming that they're in the red area.
correct. And that's the standard practice that we discussed earlier, that you
Okay.
do when everything's gone.
Okay. So then going down to the next one, the azalea. Is that native to Georgia?
There are native azaleas to Georgia, but most of them are not.
Do you know if the one that you looked at in the green area was native to Georgia?
No, I didn't identify it down to horticultural variety.
Okay, so not sure.
Right.
Okay. And how big does that get?
The azaleas typically get to be about 6 feet tall by about 6 feet wide. Those are maximums.
Okay, and so you saw 2 azaleas in the green area and made the assumption that there would need to be 10 in the red area.
No,
That's not what you said you were doing?
I did not make the assumption that there would be 10 in the red area. The way that this works is the volume calculation that I explained earlier. So in order to replace the 2 azaleas that are 5 by 3 by 3, you calculate the volume of that, and then you say how many you need of the smaller new shrubs you purchase from a landscape supply place that fit in that area. So it's a volume calculation to get a total area of missing shrub. So in order to replace the 2 larger ones, you would need 10 smaller ones.
Aren't those 10 smaller ones going to grow?
They will grow, but what you're doing is calculating the value at present day. You're not calculating the value in the future. You're calculating the value at day one.
Okay. Moving on to the tea plant. Is that native to Georgia?
No, camellias are not native.
Okay, and how big does that get?
Camellias can get fairly large. I believe they can get to about 10 to 15 feet tall.
Okay. And let's see. Going down to the fuzzy pride of Rochester.
Yes.
All right, is that native to Georgia?
It's a native to the United States. It's not native to Georgia.
Okay, so not native to Georgia.
Right.
Okay. And how big does that get?
That was at its mature height. It gets to be about 10 feet tall.
Okay. And so for that one, so the one that you saw in the green area was at its full height.
Correct.
Okay. And so in your column that said quantity needed to be replaced, you have 2,250.
Correct.
Is that a typo?
No, that is not a typo.
Okay. Can you explain that?
Yeah, so if you do the math and you take 10 by 15 by 15 and you get the volume, and then you take the volume of a replacement shrub, which is a 3-gallon, which is 1 by 1, and you do the math, that's how many of the 1 by 1 or 3-gallon shrubs you need to fill in the volume created by a 10 by 15 by 15 shrub.
But with that math, conceptually, what that says to me is that if you think of these as slices of that geometry, you cover that bottom slice with the 1 by 1s, but now you're buying and stacking on top of the ones you just planted, more 1x1s, and stacking, but not planting others, eventually crushing the ones you planted, because I get it, you have a prism that you're filling with all the 1x1s, but layers 2, 3, 4, 5, 6, 7, however many it would take, they're not even in the ground. They're hovering, maybe it's hydroponics. But I mean, am I understanding the math? And if I am, how is that the right number?
So you are understanding the math. And again, so to use a comparison, if I will, let's go back to a tree. So when you buy a 4-inch caliper tree, and caliper is the measurement at 4 inches above the ground line, okay, and you're buying that tree and you're saying, this brand new tree costs this much money, but the tree that was removed is this big, 25 inches, you take that smaller tree and you extrapolate it to that larger size. So you can't do that same kind of an extrapolation with a shrub. So the standard practice is to calculate the volume that that shrub took up and use a comparable plant to come up with the extrapolated or expanded value. It's not necessarily that you're going to put them all back in the same place and stack them. It's that you're using that smaller shrub to come up with a comparable value to the shrub that was in the ground. Now, if I called the landscape supply company and I said, hey, I need a 10 by 15 by 15 shrub, and they had one, that's the number I would have used.
Right, and that would be $1 gazillion because that's a ginormous shrub.
Correct.
Okay, so.
So if you look at the value price, the gajillion dollars matches up.
Okay, understood. And what you're describing, even though part of it seems a little counterintuitive, it's the standard practice.
Correct.
You didn't do this just in this case.
No, and I didn't come up with it.
Moving on to the, am I pronouncing this correctly, Malls Quince?
Yes, Malls Quince.
Okay. Is that native to Georgia?
No, it's not.
Okay. How big does that get?
I do not know how big that one gets.
All right. We don't know. But you have one and you need 125 more of them?
Correct. It's similar to the last one. You take the volume for 5 by 5 by 5 and you fill it up with 1 by 1s by 1s to get that number.
Okay. Nandina, is that native to Georgia?
I do not know, but I don't think so.
Okay. How big does that get?
The largest I've seen in those is about 4 or 5 feet.
Okay. And so for one, you need 4.5.
Correct, at the size that the landscape supply company had.
All
Again,
right.
if they had larger ones, I would have, used that.
Okay. English ivy, is that native to Georgia?
No, it's not.
Okay. Do you know, is that ever considered to be invasive?
It is.
Okay. Vinca, did I say that right?
Yes.
Okay. Is that native to Georgia?
I don't believe that is.
Okay. All right. And going back to that little green area right there, you hadn't been out there before the day you did all this, right?
No, I had not.
So you would also not know if that area had been previously landscaped. Is that fair to say?
I wouldn't know if it had been previously landscaped, but based upon the vegetation that was in there, I would assume it was landscaped at some point.
Because none of those plants are native to Georgia, right?
Correct.
All right. Those are all of my questions. Thank you very much.
Sure.
Edward and Mr. Logan, do you have any questions for Mr. Shostak?
No, sir.
Okay, any redirect?
Mr. Shostak, did you rely on my representations regarding allegations of clearing or your own observations on site of easement area 2 as to clearing?
I relied on my own observations. I go into everything that I do without any preconceived notions. I've actually gone out to a site where somebody has told me something and told them that they may not be correct and have left.
Understood. Now, Mr. Shostak, your green appraisal area, it seems to overlap a little bit onto the easement area too, is that correct?
It does.
Okay, in your observations, was the, strike that, let me ask you this. When you were out on site, whether the first time or the second time, did you have an opportunity to review some other areas outside of maybe your appraisal green area, or easement too?
Yes, I did. The last time I was out on site, I did look a little bit in the area of the easement that's only in blue, just a little bit.
The vegetation we just walked through, was it consistent with your observations in the blue area of easement too?
I didn't actually identify anything specifically, but visually it looked similar.
Thank you very much. No further questions.
Just a couple follow-ups.
2 it is.
I believe you identified just a couple, you said under 6 inches in diameter trees that were not included in your report, correct?
No, they're included in the report, but they're not included in the table of vegetation. They're included in the tree table.
That's right, you did mention that. I'm sorry, I forgot. And when you were saying you looked at some of the stuff in the blue area, that's not included in your report, is it?
It's not included in my report, except there may be, and again, may, because normally I do this, is I do a general observation of areas surrounding. So there may be a general observation in my report of that area. Do not remember if I did that this time.
Okay, so it would have been a general observation, but the specific one we have is that table that you and I went through. Is that right?
Yes.
Okay, thank you so much.
Any questions from the jurors for our arborist? Yes, sir. Hold up, Deputy Gordon, please. Sir. Council, we look at these, we need to head out, but we're all. Okay. Sir, a few more questions.
All right.
Do you can flip through your pictures that were, I think it was exhibit 21. Do you have any pictures of the green area? In other words, the appraisal area that you sample on the W property?
Yes, I do.
Okay, can we put that there in evidence, I guess, which, pages, the pages, I think, are they numbered for you there? Like 1, 2?
Yes.
Okay, which pages from defendants 21 are photos of the green area?
So the first 3 photos, page 1 and page 2 are, and you can actually see in those photos.
Let's stop then. So let's
Okay.
get that first page up.
Yeah.
Because now they're on the screen in front of you, so the jurors can react to what you're saying.
Yeah. So if you look at the bottom photo on the left, about 3/4 of the way down.
If you tap the screen, I'm risking it. A little circle with a pencil in it should show up in the lower left-hand corner. Match the screen. Is there a circle with a pencil in it? Lower left-hand corner, move your drink.
So what I've circled there is the flagging tape that I used to denote one of the corners of the easement area when I was out there. So I knew where I was while I was walking around.
But if I'm you holding the camera, are my feet in the green area and I'm taking a picture of the easement, or am I in easement 2 taking a picture of the green area?
You're in the green area, taking a picture of the green area.
Okay, and the picture above, same thing, I'm in the green area taking a picture of the green area.
Correct.
All right, and as we could look at the picture, please, on page 2. There's a little back circle with the arrow pointing like you're going backwards in time. I think if you tap that, it makes your red ring go away.
I don't see that.
What is the erase thing? Is it in a circle that goes?
Oh, here it is on the, maybe I have to touch the screen again for it to show up.
Yeah, feel free to touch the screen. It's a touch screen. Mind me.
There you go.
All right.
Yeah, so in this,
What does this show?
so in the center of that, you can also see another flagging tape that shows another area within another designation of the boundary of that. So I believe to the right is the easement area in that photo.
But again, this picture is taken by you standing within the green
Correct.
box that you drew on the original picture we were.
Yeah, correct.
Okay.
And if you keep going, you can kind of scroll through some more of those photos.
Well, they're in evidence and the jurors will be able to look at that.
Yeah, okay.
Is there a reason why you wouldn't have, you go back to, the picture with the blue and the red on it, please? While she's pulling that up, is there a reason why you wouldn't have done a little bit of a survey, if you will, of the blue area? It's also adjacent to the red area.
Yeah, because when I was out there in the field, I did not know where the bottom property line was, and I did not want to trespass and go on the neighboring property without permission. So I stayed where I was confident or comfortable that I was not be trespassing.
You talked about an English holly, is that correct?
Correct.
In the green area. About how old would you say that was?
That's really a difficult question to answer. And the only reason for that is because tree growth is related to species, genetics, as well as site conditions.
Sure,
And
but I'm not saying 2.7 years old. Was it a 1-year-old? Was it an 80-year-old? Or even that's hard to guesstimate?
yeah, so I'm going to give a decent range, but I'm going to say it was probably between 15 and 30 years old.
The English holly.
Yes.
Okay, thank you. Last question from me. Does industry practice support the notion of a single comparison? In other words, you did green area to red area, as opposed to say in home appraisals, I'm actually gonna go out and find 3 comparables out there, so that we can kind of triangulate. One's a little more expensive, one's a little less. How is this different from that, and why?
The only reason why it allows a single appraisal like that is because if you walk around and you look at other areas, then, and you determine that those are similar in nature, then you can do a single area instead of multiple areas.
Make sure I follow that. If you determine that the adjacent area upon which you're gonna rely is sufficiently similar, industry practices, that's enough data.
Correct.
Okay, and that was your conclusion here.
That was my conclusion.
Got it. Ms. Sturm, do you have any other questions for Mr. Shostak?
No further questions.
Senator,
No, you're on.
thank you, sir, for your time.
Thank you.
You can leave anything.
Leave
that's not
those there.
yours Up there, and so the Dr. Pepper goes with you.
It does. You're correct. It does go with me.
All right. Everything else stays. Thank you. Good night, Dr. Pepper. Next witness.
Defense called Noel, Darby.
All right, Mr. David. And if you could come up, Ms. Sturm, and click, it's kind of chaotic up there.
Sure, I will take care of that.
Mr. Schneider can, but there's not a lot of.
You are
adequate space.
released, yes.
Mr. Darby, can you,
Do the one thing.
State- yeah.
They've done it before, but
I guess,
you've been recalled. State your name and spell your name for the record.
of course. My name is Jean-Noel David, Jean-Noel
David, spelled as David as the last name.
Can you introduce yourself to the jury?
Sure. So I was born and raised in West Africa, Senegal, in a little city called Kaolack, 100 miles southeast of Dakar. My parents are from Lebanon. They fled the civil war. And so grew up in West Africa in an Arabic family. And then after high school, moved to Paris, went to college, and studied math undergrad, mechanical engineer as a master. Then started working in France, and then eventually made my way to the US in 1998 at Emory, where I got my MBA, and I'm here now.
Thank you. And you are a U.S. citizen?
Yes, I am.
And you said you came to Emory.
That's correct.
Okay, and so you've been in Atlanta for how long?
Since 1998.
Okay.
Is it 26 years?
And what do you do for a living?
I work for a manufacturing company. We make radiopharmaceutical, nuclear medicine. To be a bit more specific, it's the active ingredients, actually, that's linked to a linker and a protein, and actually put in the body, kills the cancer cells. And we work in the field of prostate and breast cancer now.
Thank you, Mr. Darby.
I had operation.
I'm sorry.
I had operation. I'm the vice president of operation.
Okay. Turning to your property at 3377 Habersham Road, how did you come to purchase or buy this property?
Sure. So my wife mentioned we lived into a very small home. It was our first home. It was our plan to be 5 years. Ended up being 17. And then we moved into a house on Garden Hills. And then the day she walked in, she didn't like it. I passed the details, and then we agreed to, say, if we find the right place for us, let's just do it. And then we started looking, and 10 months later, not even that, we ended up on Habersham, and we looked for a while, and that was the one she wanted, because we looked at it multiple times.
Okay. And talk to me a little bit about did you do any due diligence prior to purchasing?
Yes, we absolutely looked at everything that first didn't work in the first house, and then second didn't work when we walked into the second house, but also all the surrounding. So yes, we did, bedroom, bathrooms, daughter, son, also play, because we have, our boy is very active, our daughter too. So yes, we did.
And did you walk the 3377 Habersham Road property before purchase?
Yes, we did.
Okay. Did you walk, were you aware when you were looking at the house that there were easements involved?
Very well aware, yes.
Okay. And before purchasing, did you walk easement 2?
Yes, we did. I did.
Okay. And tell me, did you walk the fullest extent of it from 3377 Habersham to West Andrews, or did you walk West Andrews to 3377 Habersham?
Both ways, multiple times.
Okay. And did you have any problem doing that at the time?
Oh, no, not at all.
Okay.
No.
And can you describe easement area 2? Was it wooded or was it cleared?
No, it was actually wooded. It was wooded.
Did you close on the home with attorneys at Campbell and Brannan?
Yes, we did.
Okay. During your closing, were you provided a copy of your easement agreement?
Yes, I was.
Okay. Did you have any questions about the easement agreement at the time of closing?
No, I did not. It was actually pretty straightforward reading. No question, just confirmation of what I was reading. So it was very clear for me.
Okay. Were you, at that time, were you aware that the attorneys at the firm, Campbell and Brandon, also had closed on the neighboring property?
Yes, we were made aware. That's correct.
Was it were you aware, strike that. Did you move into the property at 3377 after purchasing?
We did not.
What transpired?
So we closed on March 27, 2020, and moved in on April 30, 2020. So during the whole month of April, we were in and out. We were having renovation in the house, painting, kitchen, yes.
Now, during this time, what were you doing for work?
Actually, my work is outside the state of Georgia, so I travel a lot in the States and also internationally, sometimes all the way to Australia.
Okay.
So same, yeah.
Same
Yeah,
field?
yes. Yeah, visit clients, visit other plants, yes.
Okay. At the time you purchased this property, were you traveling internationally a lot?
I was, yes.
Okay. At the time that the renovations were occurring, were you traveling internationally a lot?
I was traveling, yes, quite a bit, yes.
Did you know Mr. Anderson when you purchased the property?
No, I did not.
Okay. And when did you first meet Mr. Anderson?
It was during that trash incident.
Okay.
You know, that's when we first met. I believe, yeah, it was on April 27, yes.
Were you home
Yeah.
at the time or were you traveling?
No, actually, it was, I know exactly, because when you travel a lot, you know your Fridays and your Mondays. Those are the days you get on the plane. So, no, it was a Saturday, and it was April 25th, 2020. And I remember that because when first it was a weekend, so I knew it was a weekend, I was not traveling. Second, my wife and I were just coming down to the house because we knew the new bin was being dropped for trash. And we were meeting our contractor at some point that night to talk about the next next stage of renovation. So it was during the end of the day, you know, on a Saturday. It was a Saturday.
Now, we've heard prior testimony in this case already about your knocking on the door of the Anderson home. Can you tell us, did the Andersons invite you in?
No.
Okay. Can you tell us how you left that conversation?
I honestly didn't feel warm and fuzzy at all. I was really looking forward to an opportunity to introduce myself, kind of, you know, have a conversation, you know, maybe, you know, try to say, well, you know, drop trash, why not? I mean, you know, kind of reset. But it did not go that well. I walked out and I was actually the one thing that even light the bulb for me was he mentioned something about the workers parking in front of his trash bin and not to be able to access the trash bin. And that's why he actually dumped it in, not him, I mean, the son-in-law, in our bin. And I walked away, and that's it, very, very skeptical, because it was a Saturday and a day, no workers, not able to access the trash on a Saturday afternoon. For me, the things were not connecting.
Okay. Does the city pick up your trash on a Saturday?
Friday morning.
Friday morning. Okay. Did you have any conversations with Mrs. Anderson at that time?
No, I saw her in the back.
We heard some testimony about the clearing of easement 2.
Yes.
Okay. And when you purchased the property, easement 2 was wooded?
Yes, it was.
Were you home when easement 2 or this portion of easement 2 was cleared?
So we have bought the home, we're not home.
You were not home or the family was not home?
The family were not home.
Okay. Were you out of town?
It was between that period between April 2nd and April 25 when the renovation was happening.
When the renovation on your home was
That's
happening?
correct, yes.
When did you, when did you discover
yeah.
the clearing?
So when we moved in on April 30, the view, we remember really well, the view from our bathroom. There's a big window and you can, see this great wooded area in the back, and Noel couldn't see the city, the street of West Andrews. And it just appeared that now it's all gone and you can just see West Andrews. So it was just soon after we moved in on April 30.
Okay. What did you do when you learned that?
Well, my wife and I talked about it, and it was a very big disappointment because that was a big selling point for us, is this privacy and being able to have this wooded area in the back.
Did you contact anyone?
I have not.
Okay.
I did not.
At any point after the clearing occurred, did you contact anyone, your closing attorneys?
I did contact, actually, yes, Erica, just reiterating and reviewing the easement agreement, making sure I'm not misunderstanding, making sure I'm reading it right. English being my third language, I always question myself when I read something. So having the lens of a lawyer or someone else to validate was important for me, which they did.
Did you have concerns that maybe you weren't reading the easement agreement?
Yes, I did have concern. Like I said, I learned English 25 years ago, so it's I always question myself when I read something. Am I reading it right? So I always ask them, even sometimes my wife, and now my kids correct me. So that's a different. How do you understand this, and make sure I understand it? So yes, I do that.
Okay. Do you, are you familiar with the name Whitwood?
Yes.
Okay.
Parcel, yes.
Who is Mr. Wood?
Part of the closing attorney firm.
Okay. Did you reach out to Mr. Wood?
I did.
Okay. Did you inquire about your easement agreement?
I asked the very, very specific question. Please, Whit, help me understand. Am I reading this right, or am I missing anything on the easement agreement?
Okay. And following your conversation with Mr. Wood, how did you feel about your understanding of the easement agreement?
Well, first, it made me feel good because I understood it and read it right. So that was a relief on my end. But it was not a good feeling because now suddenly I'm in contentious, in my mind, just like suddenly, my neighbor has made a decision to do something that I thought was not allowed to do.
And so you felt confident in your understanding of the
That's correct.
easement agreement afterward?
That's correct. Yes, I did.
Let's talk about another incident that we've heard some stuff about. Fencing of the property line, and tell me about what happened with this fencing.
So I was home that day, and it was in October 2020, and I didn't see it. My wife calls me and says they're building a fence, and I says, a fence? And then I went out there and I says, effectively, they're building a fence. So I went out and I saw the workers out there, very nice, introduced myself. And then he didn't speak English. I can get by in Spanish. It's the fourth language I didn't mention, but I lived in Mexico a couple of years. So I just, nicely asked him, hey, what you doing? And then, when English is not your first language, you get by, figure out how to communicate, so which I did, and then I understood he was building a fence. I understood he was going all the way down to the easement.
Hearsay. It's hearsay from his fourth language to his third language. Apparently this worker was speaking Spanish. It's clearly hearsay. He's relating what the worker told him either in Spanish or English or whatever.
He's not relating what the worker told him, he's relating his understanding.
Which is
Well,
100%
his
based.
understanding of what someone said. So let's not get into what someone else, we talked about what he told the workers, and maybe as a result of that exchange, the workers stopped working, or they handed him a business card, but not his sense of what the response was.
Mr. David, did you observe the area that the worker was working in?
Yes, I did.
Okay. Did you make personal observations about where the work was being done?
Yes, I did.
Okay. We've seen some, I believe, some photographs. Defendant's exhibit 10. Let me hand you what we've identified as defendant's exhibit 10. Do you recognize this picture?
Yes, I do.
Okay. Can you tell us what it is?
Yes, it's a worker, someone building a fence. There's a, yeah, that's what it looks like. He's putting a fence up.
Okay, in this picture, there's a worker, and in the photograph, the back of the worker is what we see, is that correct?
Is that correct? The fence, yes.
Okay, what side of the fence is that showing? Is that your property?
That's a view from our side.
Okay. Your Honor, we would move to admit defendant's exhibit 10.
No objection.
It's admitted.
Cheers. And Mr. David, can you help the jury understand where this is the worker? Is the worker on your property or on the Anderson property?
No, he's on our property.
He's on your property. There's some wood pieces that are leaning and, oh, I am so sorry. Take two. Okay. In this photo, the worker is standing on your property or the Anderson property?
On our property,
Okay, and we see some wood leaning.
yes.
The bottom pieces of the wood, is that your property or the Anderson property?
No, definitely on our property.
Is this fence that's going in, is this on the property line essentially?
It's actually wood.
Objection, no foundation.
Mr. David, do you know the location of the fence that was installed?
I do.
She re-asked it, are you renewing your objection, or?
I think that requires a surveyor, and we've had 3 years litigation. We haven't seen a surveyor support this position.
Okay, you're renewing your objection.
Yes, sir.
Okay.
No foundation.
All right, if you want to ask him why he thinks it where it is, then if someone wants to explore that in cross-examination, they can.
Why do you think you know the location of this fence?
Because I've looked at my survey that was issued during closing by McClung, and I know where the property line is, and they explained to me when they came out where they put the fence.
Objection.
Don't go into what they said to you.
No, I'm not.
You just said they explained to you.
Yeah.
So don't go into what they explained to you either. I'm gonna call that's what they said.
And based on their explanation, I actually draw a conclusion that this is the easement, this is a property line.
Now, in this photo, are we closer to your home, or are we closer to the easement, or are we somewhere in the middle?
Now we're actually just in front of Mr. Anderson garage, so we're closer to our home.
Closer to your home, okay.
And did you say, that the gentleman whose back is to us, he is on the side of the fence that faces your property?
That's correct.
So what is this brick, or there's white along the edge of the photo?
That's probably the shed.
Okay, that's your
Our shed.
Okay. Is that the brick path we've seen pictures of? It looks like a dirt or paved area, just a couple feet behind the gentleman.
That you walk on?
Yeah.
Yes,
We've seen these aerial
Yes.
shots of a
That's right.
brick path, and you said, sometimes I take that, sometimes I go through my back.
that's correct.
Okay.
Now, did you observe work being done on the fence further down closer to the easement area?
Yes,
Okay. Did you have occasion to observe any work beyond where the fence ultimately stopped, extending into the easement area?
they have already made the holes for the poles on the easement area.
What do you mean?
Well, when you build a fence, I'm not a contractor, but I'm telling you what I read on the Home Depot book. When you build the fence, you actually put the holes, put the holes of the, where you put the put holes, and then that's where you will end up putting the base of every certain distance of those big poles, and then you put build the fence in the middle, in between. So they've already marked it out and already identified where to make the holes, and in some cases on the easement already made the holes.
Okay, so you observed when you went out there and work was being done on the fence, you observed holes in the ground going down a portion of the easement area.
That's correct.
Okay, and then what happened?
Then I asked him to please stop at the end of the property line and not go any further down until I talk to someone.
You said that to the worker?
The worker. Yes,
Okay.
ma'am. Yes.
And after you spoke with the worker, what did you do?
Well, after we communicated, he gave me the business card of his, the company, so I can talk to someone in English, so we can, communicate, because he was having a hard time to really understand why I was stopping him, but he understood that I needed him to stop right there. And then I just called the office.
Okay, did he stop?
Oh, he was still going and finishing, like he understood he needed to stop, yes, at the property.
So he didn't proceed with fencing off the easement area?
He did not.
Okay. Did you call the company?
I did.
Okay. Did you call anyone else?
Actually, I went to knock on the door of Mr. Anderson. And then,
You went and knocked on the door of your neighbor's house?
that's correct.
Okay. And did you speak to anybody?
Yes, Mrs. Anderson opened the door.
Okay.
And, yes, I asked to talk to Mr. Anderson because we wanted to talk about, the situation. I was not aware, I wanted to talk about what he was doing and that he couldn't just go on and do it by himself without talking to me because of the easement agreement. But he was not home, so she gave me his number,
Okay, his phone number?
his phone number, which I called
Okay.
and left a message.
You left a message for Mr. Anderson?
Yes.
Okay. Did he call you back?
Yes, he did.
Okay. Do you know how
Oh, in the
long
same-
it took to call back?
Oh, it was in the morning, within the hour, he called me back.
Okay. And did you have a conversation with Mr. Anderson?
We tried to talk, yes, I explained why, I asked, the worker to stop because he was very unpleasant in terms of the fact that I was asking his workers to stop working. He just start saying, no, I have the right, I pay taxes on these properties, I can do what I want. And I said, well, there's an easement agreement, how about we talk about it first? So that was it.
Okay. How did you leave that conversation?
I ended up I was not 100% sure that he was not gonna continue, but I really like 80% sure that he was not gonna finish. So I didn't know what to expect, so I just sat, in the back of my house and waited to see if they're gonna finish the work or not, which they did not, all the way down.
Okay. You indicated that you knocked on the door and Mrs. Anderson answered. Did you have any discussion with Mrs. Anderson about their garage
Oh, yeah.
or work they were doing on their property?
Yeah, because they were doing also some work on their garage, and I asked her if she was planning on having, people live up there, and she says no, they were just finishing it. That's
Okay.
it.
Did you tell her she couldn't have people
No.
living there?
No.
Did you tell her she couldn't renovate the garage?
No, not in my place.
Did you tell her she couldn't do work on her property?
No.
Let me ask you a question. During your time at 3377 Habersham, how would you describe the traffic along Habersham Road?
It's actually pretty heavy and in some cases dangerous. We had a car flipped on our, on our yard one day because they were going too fast and it just flipped. So yeah, it's pretty heavy.
Okay, it flipped over and landed
Yes.
upside down?
Yes, upside down. I mean, on our yard, and I mean, I don't know if you're asking me to go into that story, but he did. Yes, police came over and.
Okay, we won't get into what may have happened with the gentleman. We've heard, and I don't want to belabor this, the jury has heard a lot already. We've heard about the trash incident, we've heard about the fencing, we've heard about the clearing. How many times would you say that you've had an interaction or a run-in with Mr. Anderson?
4.
Okay. And what are those occasions?
So the first time was the trash incident. The second time was when we talked on the phone, but the fence incident. The third time is when I was on the easement, putting, I believe the picture was up yesterday or the video, putting a net for my kid. He just screamed at me, says, "Oh, this is gonna cost you a lot of money, buddy." That was the third, and the fourth time was 10 days ago when I was with Mr. Shostak on the easement. He just screamed at me, "See you in court next week, big boy."
Give me an idea of how those interactions made you feel.
I honestly, I don't feel good. I mean, I'm very conscious about where I come from. So, I mean, I have parents play a civil war. I made it on my own all the way, living 19 years in West Africa, and my parents never finished high school. I'm all the way here. I'm a U.S. citizen, and sometimes I do not feel good about it. I mean, I worry. I worry. I don't know. I mean, I don't feel good at all. I really worry about my safety. I worry about my wife, my kids. I travel a lot. I don't know what's going to happen. I don't feel good.
So we talk about 4 incidents. Trash, and that is shortly after purchase, is that correct?
The trash was on April 25, that's correct. And then the fence.
And then the fence. Do you recall, did you contact an attorney right after this trash incident?
I sometimes right after the fence, no, I did not after the trash incidents, no. But yeah, no.
Okay. Do you know when you first reached out to anyone at Weissman?
I did. It was right after the fence event in October, and And the reason really was to once again make sure I was not missing out on anything on the easement agreement. And then instead of having a closing attorney, I says, well, I better talk to another attorney and give another opinion. And that's when I reached out to the office, yes.
Did you decide to hire Weissman at that point in time?
No, because the conversation was, no, sorry.
Don't tell anybody what
Sorry.
conversations you had with any attorneys
No,
over at
sorry,
Weissman.
sorry.
But did you decide to hire the firm?
I did not.
Did you feel like you didn't need to proceed with legal representation?
I didn't feel like I needed to.
When did you decide to hire Weissman?
It was actually early, right at the beginning of the year, the next year, early January of that year, 2022. 2021.
2021?
Yeah, it
2021.
was just a few months after.
And why? Why did you decide to proceed with hiring an attorney at that point in time?
There was, so I was actually traveling a lot, and my wife has brought to my attention that she's been seeing a lot of activity on the easement, and she was worried that they were going to do something, and then just like the history, they would just do it without saying anything. So I did not. That's when I decided to just hire the lawyers. I mean, that's when I decided, is because between the traveling, not being here, I figured even if I knew how to read English and the agreement, having representation would be a peace of mind for me.
I want to go back. I was asking you about your conversation with your closing attorneys,
Yes.
Mr. Whitwood, and I believe, Jeff, is this the one you were getting for me?
Which one? Yes.
Okay. Let me just show you what we've identified as Dependents Exhibit 7. Do you recognize this document, Mr. Darby?
Yes,
Okay. And can you tell us the date and what it is?
it was May 27, 2020, and it was from Whitwood at Campbell and Brennan to myself.
Okay. And it CC's Erica Eaton. Who is Erica Eaton?
She's our realtor who's help her buy this house.
Okay. And so this is you testified earlier about you reached out to the
That's correct.
closing
That-
attorneys.
That's correct.
Is this when you reached out to the closing attorneys about the easement agreement?
That's correct. Yes, I did.
Okay. And did they send you another copy of the easement agreement?
They did.
Okay. We would move to admit B7.
Objection, hearsay. Out of court
I saw
statement by
that.
Mr. Wood.
I saw that coming too. Tell me,
I think we can redact portions. It goes to one that he obtained another copy of the easement agreement, so state of mind. And we can redact the statements from Mr. Wood.
what were you planning? Were you planning on publishing anything right now?
No.
You want it in the record at a minimum, and then we can work through if it's something that goes back to the jury, and if it does, what should be redacted before it goes back. Is that all a fair statement?
That's a fair statement.
Okay. If we handle it that way, Mr. Edwards, do you still have an objection?
I need to see what is redacted. I mean,
Sure, we have to work through that. It may be that everything has to be redacted, in which case it's in the record for other purposes, but it would be something that the jury can see.
He's established that he got another copy of the easement around.
Agreed. I will admit defendant 7 subject to those caveats.
Thank you, Your Honor. Mr. David, after you hired Weissman, you were aware that a letter was sent to the Andersons?
Yes.
Okay. There's been some discussion about surveillance cameras on the Anderson property.
Yes.
Okay. Are you aware of cameras on the Anderson property?
Yes.
Okay. Did you have any concern regarding those cameras?
Yes.
Okay. And tell me about that.
Well, they're not anymore, but they were pointing really high for what you would want the camera to be looking at, especially in front of your house. I mean, if you're doing security in front of your house, should be pointed down instead of pointing up. And they were there's a few of them that were pointing up higher than they should.
Okay.
Yes, I had concern.
And do you know, did the cameras, were they readjusted or moved at any point in time?
Yes, they were adjusted.
Do you believe that was after the letter that the firm sent?
I believe it was coincidence just after that, yes.
So we've talked a little bit about these incidents that you've had. You've seen, and your son was here earlier testifying, you've seen videos of your son that Mr. Anderson has taken. Can you tell us how that impacts you and your family?
It's really hard actually to maneuver and manage. There's always the stress of the work that you deal with, the pressure and, that you deal with. And you always want to feel like your family is in a good spot, which is not the case. Knowing that my son stresses about being out there, that's always in the back of his mind, that I have to travel on Sunday night, Monday morning. If I have to drive from Macon, it's different than if I have to fly back from Sydney. So it's very stressful. It's been putting a lot of pressure and a lot of strength on the family, that our relationship is suffering financially. It's tremendous pressure, and even my health is, it's taking it. Yeah.
It's stressful?
Yeah, very stressful.
How would you characterize, or how would you describe the impact these events with the Andersons have had on your ability to use Easement 2?
It has prevented us, it's preventing us from going out there and do what we want to do. Play or even walk by. I actually think twice before when I come back from Iran, or even I want to go out from Iran, just because I do not want to have an encounter with Mr. Anderson, because I know for some reason, every time I'm out there, he just shows up. And I also want to avoid any opportunity to run into the gentleman.
Okay.
So it's now it's getting to the point where we don't want to be out there trying to do the Easement 2. So.
Okay. Do you, have there been any incidents that have led you to believe that you should not be using the area?
Every time we are out there, the fact that we have to replace equipment, the fact that we are constantly have to watch it, I'd rather not deal with it than just deal with it. Like be out there and deal with, Mr. Anderson. So I sometimes choose, many times, not to be out there. Okay. And that's Easement 2, but I mean, there's also the fact that my daughter drives now and comes back home by herself, and, I mean, parks on easement one by herself. It has crossed my mind that what if one day happens to my daughter what happened to my wife, where someone shows up from the back wall and starts screaming at my daughter because she's on easement one, and that would be Mr. Anderson. So it's becoming a problem, major problem from a personal health and family financially.
Do you believe that the Andersons are intentionally preventing you from or impacting the way you use the easement to?
It'd
actually be speculation.
His belief about their intentions seems like not something he needs to share.
Okay. Mr. David, do you feel like you are being personally attacked?
Yes, I feel like I'm being bullied. I think that maybe he assumed I don't speak English, I'm not from here. He just can come in and roll over and I will just not fight it. And he just probably assumed I don't speak English very well, or I don't understand the language of the law. And that by just doing it, by those actions, I would just back down and not fight it, and he'll take it over. Just like putting a fence through the easement and preventing me from walking on the easement and preventing my kids to get on the easement. And yes, I do.
This is always tough, but if you knew now if you knew then what you know now, would you have bought this home?
Never. Regardless of how much my wife loved it.
This isn't, well, let me ask you this. What do you want?
I want to be able to go to work knowing that my family is safe. I do never want to be getting that phone call that I got one day, ever, when I was at work, and never, when she couldn't talk for 10 seconds, that felt that when I thought one of the kids was dead because Mr. Anderson had attacked her verbally on that, that day and called her those words. I want to be able to live my life. I never filed this lawsuit. I exercised an easement agreement. I bought a property like everybody does and wants to do. I'm living the American dream. Apparently not anymore, but I'm living the American dream. I just want to keep doing it.
Does it feel like a dream?
No.
No further questions at this time.
Remember? Actually, let me check. We've been going for a little bit. You guys need a break? We're gonna take a break in a little bit anyway, but keep going. Keep going. Okay. Never.
So it sounds like there was about a month in between when you bought the house, when you first moved in, right?
That's correct.
Okay.
Yes.
Did you ever, and I believe you actually indicated that the dumpster incident happened on April 25th of 2020, right?
Yes.
That was the day?
Mhm.
Okay. So in between March 27th, 2020, April 25th, 2020, did you ever go over to the Andersons' house and say, hey, we're really excited about these easements. Can we talk about, like, what did you and the other owners do? Or how can we work this out? I know they're on your property, but, let's talk about it.
I don't understand. Why would I do that? I did not.
You did not.
Mm.
Okay. All right. And I believe you have stated that you cleared a path on August 12th, 2021 in your yard?
I removed some ivies.
Remove some ivy, okay. And that was from your yard over towards where easement 2 is?
It was more from West Andrew going up easement 2.
Okay, so some of it was in easement 2?
Yes, it was all on easement 2.
Okay, and that was fine, right?
What's fine? I
Like
don't-
you didn't think that, you thought, that's fine for me to do, I can clear this path?
Yes, I can clear this path, yes.
Okay. Did you talk about it with Mr. and Mrs. Anderson?
About clearing the path?
Mhm.
Yeah.
Okay. Did you take any photographs of any of those surveillance videos that you thought were pointed at your house?
I've seen photographs. I did not personally take photographs.
You did not take photographs. Okay. Did you ever call the police about it?
No.
No. Okay. You, for efficiency's sake. We're 10.
Yes.
Okay.
Yeah.
And you pointed to that worker that's working on the fence.
Yes.
In this photograph. And it's correct that you've never had a survey done on where the Anderson's fence is, correct?
I did not hire a surveyor to survey where the fence was.
Okay.
Yes.
So if you truly believed that he was standing on your property, why didn't you say something to him? You didn't say something to him, did you?
No, it didn't bother me.
Okay, all
I
right.
mean, you're talking about, sorry, clarify the question.
Well, I mean, you said, you made a point today to say that he's standing on your property.
I answered the question, if he was standing on my property, I said yes.
Okay, and so did you ask him not to?
No, I did not.
Okay. Okay. I believe those are all my questions.
Edwards?
I'm gonna have a few minutes, not a lot. I mean, I can try to go through real quick.
Really up to you. You say a few minutes, you're just gonna hold it to those words.
Okey dokey. Fine with me. I'm gonna follow up on, excuse me. Y'all took a lot of pictures of stuff that y'all saw the Andersons doing that annoyed y'all, didn't you?
I'm sorry, what was the question?
Y'all saw the Andersons doing things you didn't like. You took pictures of it, right? Like this picture of the fence.
I can't, which picture?
There's a 2 or 3 second lag. There you go.
Oh, yeah,
Picture of the fence. Y'all took a picture of this fence going up, right?
yes.
And I just want to make sure the jury understands the claims that you are and are not making in this case. You're not making you're not suing us for trespass for this worker being on your fence, on your property.
Yeah. Yes, ma'am.
I think he's getting into a legal area. I guess we can see where this goes, but I'm concerned he's getting into a legal area and I don't want him to elicit communications.
Okay. He's not there yet, so, you can ask your question again, so we queue up your question.
To your knowledge, are y'all seeking damages from my clients because this worker is on your property?
No, not to my knowledge.
To your knowledge, are y'all seeking damages against my client because of the wood supporting the fence that appears to be on your property?
The wood on, you mean, can you point it on the screen, please? What you're talking about? I just want to make
Is
sure.
that the wood you're talking about, the support beam right there?
No,
What are you talking about?
I'm asking you, what's the question? I'm sorry. You have to be very specific.
When Ms. Sturm showed you this picture, you said, yeah, there's some wood on our property.
That's correct.
And I'm trying to find the wood that's on your property. Is it not this support beam
Yes.
here? Okay. To your knowledge, are you suing my clients to recover damages for that support beam?
No,
Is that support beam still there?
no,
Okay. Now, you walked, and I underlined this, you said, I walked easement 2 before we bought the property. Does that mean just you?
I've done with my wife, I've done it with the realtor, I've done it by myself.
That's my question, whether it was just you or anybody else. Now, did you take your camera and say, oh, look at these beautiful trees, look at this beautiful 10 by 15 by 10 bush? Did you do that?
I did not.
So you have no pictures of easement 2 in what you contend is its heavily wooded and heavy vegetated state, do you?
I do not.
Okay. And you bought the property on March 27th. That's when you closed. You moved in April 27th, right?
April 30.
April 30, okay. And it's my understanding from your testimony that the tree clearing occurred between April 2nd and when y'all moved in on April 27 or 30, is that right?
That's correct.
Okay.
Yes. Yes.
So you're not contending that the clearing occurred between when y'all closed on March 27th and April 2nd, are you?
No, it's between the closing and when we moved in.
Well, you said April 2nd, and that was a specific date, which is why I wrote it down and asked you about it.
Just because it was a weekend, yes.
Now, you complained to the workers and to Mr. Anderson about the fence supposedly or planned to cross the easement, correct?
No,
Who did you complain to about that?
Mr. Anderson.
Okay, you complained to Mr. Anderson because it looked like the fence was going to extend beyond or into easement 2, correct?
That's correct.
And as we sit here today, does the fence extend into easement 2?
No,
Okay, so y'all got that resolved, didn't you?
it's not there anymore.
Was it,
It's not there. There's no fence there, so it's resolved, I guess.
was it ever there and it had to be torn out?
No,
Okay, so that's an example of a potential problem. You talked to Mr. Anderson and y'all avoided a problem, right?
I responded to an action Mr. Anderson has started, and then he stopped.
And he stopped because you picked up the phone and called him and said, hey, don't do this, right?
Because I caught him.
I understand you caught him. That's not the point. The point is,
So you're not lecturing him what the point is. You're asking a question.
I'm asking the question. This was resolved because you picked up the phone and called him neighbor to neighbor, man to man, right?
Because I caught him. Yes, he stopped because I caught him. Have I not caught him, he'll be all the way down, which he admitted yesterday.
Okay. I think we've got the point.
He said what he said, and then you ask the next question.
I think the jury's got the point. Now, again, you testified on direct a few moments ago that it is your position that part of the fence actually is on your property, correct?
It's really close. It's like within inches, yes. Also, yeah.
Well, is it really close or is it on your property?
I can't confirm where it is, but it is really within an inch. So it could be on the property at some point and not on other areas.
And during your discussion with Mr. Anderson about the fence, you complained about it going across the easement. Did you complain to him about it being a 6-foot tall wood plank fence?
No, I did not.
Okay, so that was not an issue that you raised with him or tried to resolve?
No, I didn't talk about that.
Did you express any concerns to Mr. Anderson that, and by the way, I think your fence might be on part of my property?
I did not.
Okay. And we've been in this litigation for 3 years now, right?
Yes,
And Ms. Sturm's going to testify about the attorney's fees. Y'all spent a lot of money, right?
yes, yes.
Have y'all spent a few hundred or a few $1,000s to have a surveyor go out there and actually get a professional opinion as to whether the fence encroaches on your property?
I'm sorry, what's the question?
I'll move on. These surveillance cameras. Again, going back to the pictures y'all take when things upset you, did anybody take a picture of a surveillance camera like that one up there in the corner saying, oh my gosh, this is pointed at our daughter's bedroom? Did y'all do that?
I did not.
Okay. And I just want to make sure the jury understands. To your understanding, are y'all suing the Andersons for invasion of privacy based on this alleged illegal surveillance?
No, no,
To your understanding, are y'all seeking money damages from the Andersons for having illegal surveillance cameras in violation of the laws that Ms. Sturm cited in her letter?
no.
Okay. And kind of follow up to the surveyor on the fence, you have not spent a few hundred or a few $1,000s to have a surveyor go out and look at easement 2 and confirm how much, if any, of the sod encroaches on easement 2, have you?
I'm sorry, what's the question?
The question is, in the 3 years we've been in this litigation, have you paid a few hundred or a few $1,000s to send a surveyor out to say, I'm registered licensed surveyor number blah, 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 and the sod encroaches 3.2 inches into the easement area. Have you done that?
No, I have not.
You've had a total of 4 interactions with Tracy Anderson prior to this week in court, correct?
I have, yes,
That was the trash incident on April 25th, right?
yes,
The phone regarding the fence, right?
yes,
The issue with the net in August of 2012, right?
yes,
And a week ago Sunday, when you and Mr. Showstack were out there checking out easement 2, right?
yes.
Other than that, you've had no interactions with Mr. Anderson in any way, shape, or form. Is that correct?
To my knowledge, that's correct. Yes,
Okay. Now, there have been some interactions between him and your son, right?
yes,
And one of those, we heard from your wife yesterday and your son today, Mr. Anderson was carrying a gun, right?
yes,
And it was in the case.
yes.
And your son called you, right?
He called my wife. I was with her, yes,
So y'all were in the car.
yes.
And how far away from the house were you roughly, or in minutes?
Really within 10 minutes, not
Within-
even, yes.
Within 10 minutes of the house.
15 minutes, yes.
So he left the property, right?
Who,
Well, that's what he testified. Did you tell him to get the heck out of there?
yes, my son, yes,
And you said, we're on our way.
yes,
And on your way, you picked up your phone and called somebody, right? You called these lawyers over here.
yeah, probably my wife did, yeah.
Okay. Your wife called these lawyers. Nobody called 911.
Objection. He's assuming facts that aren't enough.
Well, he's asking the witness what he remembers, so, if you don't know who was calling, you
Yeah.
talk about what you did, if you know your wife called the lawyers, great, if you don't,
I mean,
just
I-
put words in your mouth.
I don't remember calling the lawyers.
Okay. Well, did either you or your wife call 911
No,
because of Mr. Anderson allegedly waving a gun at your son?
no, we didn't call 911.
Now, you hired the Weissman firm in January of 2021, correct?
Correct,
This is almost 2 months before this incident with the sod and the incident in the driveway with your wife, right? You'd say
Yeah,
yes.
about a month, yeah.
And you said we hired them because of all the activity.
Yes.
Tell me the activity that was going on in October, November, and December that justified you hiring the Weissman firm.
There's people walking in, people out there, the trucks coming in, stopping by. I mean, there was more activity than normal.
People coming by the Anderson's house, you had to hire
Yeah,
one.
yeah, because there's people out there on the easement standing and just talking. And, yeah.
So,
Activity.
all right, so this is just a few weeks. This, the fence went up in early October, right? You need to say yes.
Yes.
And you got that successfully resolved, right?
Yes.
You covered.
I'm moving on.
Events and being resolved maybe 400 times?
And I'm leaving that, I'm putting it in context for the next incident. Now, there's additional activity in the easement you don't like a few weeks later, correct?
I noticed activities, yes.
But this time you didn't pick up the phone and call Mr. Anderson, did you?
I did not.
What was the activity that was going on in late 2020?
There's trucks, pickup trucks, people going, I mean, there's movement.
Did you take pictures of it?
I did not.
Thanks, sir. Nothing further.
Do you have any redirect? Think carefully before you answer.
Very brief. Mr. David,
Yes.
did Mr. Anderson ever reach out to you before clearing the easement?
Never.
Did he ever reach out to you before putting up the fence?
Never.
Thank you. No further questions.
Jurors, any questions for Mr. Darby? Yes, Bricker, Deputy Gordon.
Simple. Maybe I'll overlook it.
You're thank you.
Raise your right hand. Do you swear affirm that the testimony you will give will be the truth, the whole truth, and nothing but the truth, so help you God? Go right ahead. Have a seat. State and spell your name for the record.
My name is Casey Sturm, KaseySturm as in Mary.
Ms. Sturm, how long have you been practicing law?
20 some years now, almost 24 years.
Okay, and are you a member of the State Bar of Georgia?
I am.
And how long have you been admitted in Georgia?
Roughly the same amount of time.
Okay, and where did you go to law school?
I went to law school at Vermont Law School. I got a dual degree and my law degree and also a master's in environmental law.
And have you been practicing in Georgia since being admitted in the state?
Yes.
Okay, and what's the nature of the practice been?
And to clarify, I practice both in Georgia and in South Carolina. My practice covers a number of different real property areas. I practice environmental law. I practice zoning and land use law. I practice condemnation, real property law, these kind of disputes that we're talking about with this case, dealing with easements, handle a lot of property contamination issues as well. Maybe stormwater often happens to be a big one, but also toxic tort type situations as well.
Other than your practice for pay, so to speak, do you do any teaching or any other education?
Yes, I teach land use law at Emory University's law school.
And have you been lead counsel in this case?
I have.
And are you familiar with the lawyers that have been active in this matter?
I am.
Okay, and including myself?
Yes.
have you prepared a fee statement including detailed recitation of the time incurred in the matters done on behalf of the client?
Yes.
Okay, let me hand you exhibit number 35 and ask you if that is your statement. Collective fee statement.
Yes, so this would be a billing record from the firm. It runs from 10/26/2020 to March 5th, 2024. So doesn't quite capture through trial prep and this week of trial.
Okay. And what would you estimate your hours incurred during the course of this trial?
My hours incurred are just under 500.
I mean, in addition to the statements there, and in terms of the trial time this week.
10,000.
Right.
You all know how long we're here.
Right.
When you go home, we still work.
Okay. Are you familiar with, have you reviewed those statements to determine the rates that were charged by the lawyers involved in the case?
Yes.
And was that work done under your direction or your supervision?
Yes.
And who were the lawyers that were involved in this case?
So the lawyers involved are myself, I'm lead counsel on the case, Mr. Schneider, one of our attorneys at the firm, Mr. Feldman, Brandon Arnold, and EJ Inying.
Okay. And
Yes, INYANG.
And you've reviewed the hours that have been billed and for this matter, right?
Yes.
Okay, and they're reflected in that statement. Based upon your expertise and your experience practicing law in the state of Georgia, are you familiar with the rates that are charged by lawyers of similar expertise in matters of similar complexity?
Yes.
And based upon your review of that, are the fees charged by those lawyers and the time expended fair and reasonable for the handling of this matter?
Yes.
And were they necessarily incurred as a result of both the defense against the plaintiff's claim and the prosecution of the counterclaim?
Yes.
Okay. And the cumulative balance of those statements, do you have that number?
I do.
And what is that?
So the cumulative balance of the hours, along with the fees and expenses, is $262,685.
$262,685, correct?
That's correct.
How long has this litigation been going on?
It's been going on, well, the litigation itself has been going on for close to 3 years.
Yeah. And do you have a sum of the hours?
The total hours spent, 662.2.
Your Honor, we would tender exhibit number 35.
No objection.
35 is admitted.
Those are all that I have for this witness at this time.
All right, Mr. Edwards, questions for Ms. Sturm?
Yes, sir, I have a few. Now, Ms. Sturm, on the very top of this, inquiry activity work build report, October 26, 2020 through 3/5/2024. That doesn't mean that y'all are actually retained. That's just the time frame y'all went back for this report, correct?
So in our business records, what's going to show up is 10/26/2020 is going to tell me that either Jean-Noel David or Stacy David reached out to the firm.
Okay.
If we look at so the first page of this exhibit is a summary. The second page will start with time entries. If we look at the second page, the first time entry is January 4th of 2021. And so based on our billing records, what this tells me is that a client reached out I talked to someone, appears they didn't decide to hire us. So at the close of 2020, any, entries that an attorney would have made, the firm's gonna write off saying, we didn't get hired.
And we all have to run conflicts checks, so that would have been done around that October 26 timeframe, right?
Yes.
Okay. And the activity actually started in January 4th, right?
So there are time entries, January 4th, January 20th, 2021. It appears that the activity really picks up February like February 22nd and February 24th in that time frame.
Okay. Yeah, because there's maybe an hour or so in the month of January, but then, as you say, things really pick up February 24th of 2021, right?
That's correct.
Okay. I'm not going to ask you what happened. I think everybody knows that. And then if you flip over to page 4 of 65, about a little less than halfway down, an entry on March 11th, 2021. You are identifying an appraisal expert and valuation expert for conversion of forested land on back easement, correct?
Tell me that date again.
March 11th, it's ID number 3068757. It's on page 4.
Yes.
Okay. So March 11th, you've reached out to an expert, and we now know that's David Shoestack, right?
That may be David Shoestack.
Okay. And if you look at the next page, page 5, 1, 2, 3, fourth entry down is March 19th of 2021. Brandon Arnold attends a TPO hearing, correct?
Yes.
And then if you look at the next page, page 6, on April 1st, 1, 2, 3, fourth entry down, the big one, 0.3 hours. Receive, review email communication from Randy Edwards identifying himself as new counsel. So that's when you first heard that I'd be involved representing the Andersons, right?
I believe so.
Okey-doke. And you were here for my opening and you heard Mr. Anderson talking about some activity going on in mid-August. Do you recall that? The clearing of the path to West Andrews and Mr. David putting those nets up and things like that. Remember that?
Okay.
Is that a yes or a no? I mean, you remember that testimony from the last couple of days?
Yes.
Okey-doke. And around that time, you and I were exchanging a bunch of emails, were we not? If you look on page 16 of 65, August 9th, receive, review latest email communications from Randy Edwards, about the middle of the page.
Okay.
And then a few entries down below that, you have a 7/10 of an hour call with Stacy David, right?
Yes.
And then the next entry, most of it's redacted, but there is something receive, review, email communications from Randy E. I assume that's me.
Yes, I see that.
Okay. And then we go over to the next page, page 17, August 11th, the second entry, receive, review, email communications from Randy Edwards. Do you recall what generally was going on here in this August 9, 10, 11, 12 timeframe?
Not necessarily.
Okay. Do you recall that I reached out to you to try to figure out a way to de-escalate the antagonism that seems to be going on between our clients?
I'm going to object to this line, but it's calling for some communications or communications between counsel.
Okay, your objection is noted. We spent some time talking about this outside the presence of the jury. I'm gonna overrule it so long as Mr. Edwards' questions are consistent with the ruling I entered when the jury was outside the courtroom.
You got a big notebook in front of you. Could you flip that white notebook is plaintiff's exhibits? Can you flip over to plaintiff's exhibit 18, tab 18 in that?
Okay.
Do you recognize plaintiff's exhibit 18 as a 4-page email chain between you and I, and the last page is just the footers from, this is an email communication. But email communications between you and I, the first one is August 11th, 2020, from me to you at 11:50 a.m.
Yes?
And then you replied a couple hours later. And then you replied a couple hours later, and we exchanged a couple emails trying to set up a telephone conference to discuss the issues raised in my email, correct?
It appears that we are trying to get in touch.
And do you see on August 12th, the same page, about a third from the bottom, time entry 309-2805, email communication with clients. Do you see that?
What page are you on again, Randy?
Still on page 17.
Okay.
So, and in fact, the last 4 entries on this page are all either email or telephone communications with your clients on August 12th, 2021, correct?
Yes?
And if you flip over to the next exhibit, plaintiff's exhibit 19, you recognize that as an email I sent you subsequent to our communications earlier, our telephone conversation earlier that day.
I recognize this as an email you sent me. Yes.
Your Honor, we would offer plaintiff's exhibits 18 and plaintiff's exhibits 19.
All right, over objections that have already been stated and are not waived but preserved, they're admitted for the record.
Thank you. And does this refresh your recollection that I was reaching out to you in an attempt to de-escalate antagonisms between our clients around the time all these nets and ribbons and everything are going up?
It is an email from you characterizing a conversation. I wouldn't say that's an accurate representation.
Well, would you agree that I actually did use the phrase de-escalate the antagonism that seems to be going on, specifically the long chair and new, bigger, bolder?
So let's not get into the
Okay.
contents. That was
All right.
exactly what we talked about.
All righty.
All right.
I will move on. And you had, I'm not asking about the substance of your communications with your clients on this occasion, on this day, but you ended up billing a total of 5.3 hours to this file on August 12th, consisting of exchanging emails with me and talking with your clients and talking with Brandon and a lot of other stuff that's redacted, right?
And give me that line item number.
Well, starting with 309-2793 on the 12th on page 17, all the way down to 309-0315 on the next page, your time entries are 0.2, 0.3, 0.1, 1.3, 0.8, 0.1, 0.1, 0.1, 0.2, 0.3, and 1.8, correct?
Yes, it appears like we are communicating with a special master in this case, among some other things. So we're doing various different activities.
Well, and among some other things are the issues that I have raised in the emails, correct?
Again, Mr. Edwards, I think it's a mischaracterization of the communications that were had.
And Mr. David, again, I'm not asking for what any advice was. Mr. David said yesterday during my cross-examination that whatever advice you would have given him, he would have followed. Do you recall that testimony from your client?
I recall him saying them.
Do you agree with that he followed your advice?
No, let's not get into it. Whatever your advice was, whether you follow it.
All right.
You know better than
You,
that.
you know I can't answer.
You don't have any redirect. None. Okay, any questions from the jurors about attorney's fees? All right, thank you, Ms. Sturm. Ms. Medwick, I didn't mean to shortchange you. Did you have any questions about attorney's fees?
I do not.
Mr. Edwards covered them. All right. Ms. Sturm, your next witness. Sir. Oops, yeah, I missed that. Why don't we do this? We have to take a quick break. And while we're doing that, why don't you guys figure out how to get on the screen just the unobjectionable part. So ladies and gentlemen, you will go back to the jury room. We're going to digest the break. We'll get you out here as soon as we can.
Randy, I can do it
And
myself.
we'll
Thank
resume.
you.
Don't talk about the case.
I'll rise.
No outside research about trees. We'll go off the record. I'm sorry, Mr. Williams. I got swept up in arborism and lost track of the time. I told Ms. Sturm I monitored that, so thank you for flagging it. You let us know when you're ready to come out. Please.
Judge, if it's okay, there's something I'd like to talk about off the record, and then when he comes back, we'll create the record.
That was mine.
You again. Okay.
I know, I might get a while.
Okay.
This circle back to the standstill. My efforts to negotiate standstill back on August 2011. It was, this firm has produced her into that time frame, and on the cross-examination, she will admit that she received my emails forwarded. I assume she will admit because she's billing her client, forwarding them to her client and discussing them with the client. I don't know what those discussions are, but just to establish what we contend is bad faith and non-like transaction. They're trying to get a standstill agreement. Mr. David is out there picking up these nets and hiring these friends to come in and do all this. I think the jury need to put two and two together and see what's going on.
I think the jury's been adding a lot of numbers so far, but it's nothing wrong with having them add more numbers. Let me make sure I follow. You want to be able to ask Ms. Sturm if she forwarded to her clients what you're calling your standstill emails.
And I want to offer those emails to the evidence because they're clearly not settlement communications. This comes from the police. Bad faith in the underlying transaction. As my first email says, hey, Casey, can we have a chance to talk and de-escalate tensions? These new bigger, bolder women's and everything aren't doing anybody any good. We set up a time to talk. We have a totally unproductive conversation. Next thing you know, he's out there putting up to debt. The paths are being cut. And I send an email and say, seriously, do you seriously think if the jury's going to believe this, the court and the jury's going to believe this is a close? So this is all that was manufactured. The jury needs to hear that to put it into context for bad faith and underlying transactions.
So needs is different from whether they should be able to hear. How is it not settlement? I appreciate it's not resolving the whole thing. And I don't bump into 408 much because lawyers aren't ever trying to push their communications in front of a jury. I understand why you would want to share. I get that. But how is a communication you have with Ms. Sturm to say, these are my words, let's sort a piece of this out? How is that not part of let's work the case out overall?
Well, because Rule 408 precludes evidence of settlement negotiations when offered to prove the validity or the amount of the claim. It does not bar, doesn't bar a pure settlement negotiation to prove bad faith or intent. And that was, we cited cases to that effect in our motion for pretrial ruling on this really.
Well, before you go further, Ms. Sturm, do you have an objection to this?
I do.
Okay.
These are cherry-picked email communications that Mr. Edwards, I mean, essentially what he's trying to do is insert the attorneys as witnesses into a case.
Well, it's different from that. And I don't know that it's cherry-picked so much as it's relevant to a time frame. He's already asked Mr. David about, or Ms. David, one of the other both, where they said, no, we never heard from our lawyers that you, Mrs. Edwards asking questions. Did you ever hear that we were trying to de-escalate and then you put this net up? And my recollection of the answer is nope, never heard of any of that. This would be impeachment of that. So I don't know so much that the emails need to go in as you would, it would not be inappropriate for Mr. Edwards to ask you, isn't it true? You're billing for some emails you reviewed and you forwarded these emails on to your clients. Now, whether they read them or not, Mr. David testified, I didn't read them. So that doesn't, so he can't go too far with it because there is testimony that I don't remember them or I didn't read them or maybe they're stuck in the spam folder. And there are ways to defend against the claim that in fact, Mr. David got them. But it's not settlement per se. That's really not what he's getting at as it is, this is impeachment. So
Also, Judge, in our motion, we cited Nevitt versus CMB Realty as it relates to settlement discussions.
which, I want to be able to read this myself, which you filed a bunch of motions in limine.
This
What
is
was
the
this one?
motion for a pre-trial rule on admissibility of our efforts to maintain the status quo pending final resolution.
Got it, I'm looking at it. That's the one where we've had some of these pictures.
I
Okay,
attached some of the pictures and the emails, and the case says evidence offered for another purpose, such as showing bad faith may be admissible. And that's what this is for, is to show bad faith in the underlying transactions. Because she forwarded the emails to her, and in her bills, there's telephone conversations, she billed 5.3 hours on August 12th.
But the problem with this is, Mr. Edwards and I have a conversation. He, in an email, reports a one-sided version of that conversation
Right.
that I have to forward to my clients, because I have ethical obligations
right.
to send that information. And so it's a complete misrepresentation of what's even transpiring. And so if we're gonna get into this, I mean, we almost have to get into all of the emails that kind of go around what's happening here.
We're perfectly fine with that, Judge.
And that is not what this case is about.
You being perfectly fine doesn't mean that.
No, because we were trying to negotiate a truce, and we were.
And that's your perspective on this.
Well,
Your perspective is you were trying to negotiate a truce. I'm hearing Ms. Sturm say, maybe it was a truce at gunpoint, it was a truce that we're gonna sue you, or who knows?
We're already-
What you're negotiating is you're already in the 408. I mean,
You just said
might as
it.
well say we're in the middle of 408. Now, there is case law that is, here's to say, and I'll read Nevitt, I don't need to rule on this right now. It's dealing with 408, evidence offered for another purpose, such as showing bad faith may be admissible, but 106 then gets in the way, which would be, they got your emails, but what about Ms. Sturm's emails and the full context of you saying, hey, we're willing to stop carrying guns around or whatever that everyone's concerned, but we're not gonna litigate in front of these jurors who really don't want to hear more about this case. They really don't. To now get into how badly did the lawyers behave with each other before the trial, because they're sitting it during the trial. And I mean,
It's for the narrow purpose of showing bad faith in putting out these nets, putting out these buildings, having the pads cut in for the first time in over a year. This just shows bad faith on that 2 or 3 day time frame.
so Ms. Sturm, tell me what your objection is to Mr. Edwards being able to ask you, did I present you with, I share with you some emails that were my efforts to, my view of what would de-escalate the rising tensions about the easement. At the time, these little pieces of tape were going, let me finish. So did I send you some emails with my suggestions of how we could de-escalate this? Answer would be yes. And you can answer, I mean, it's not an only yes or no. You did. I don't think those were accurate representations of what was going on, and I didn't think they were helpful to de-escalate. I think they might have agitated my clients. Did you send them to your clients? Yes, I did. That's as far as he can go. It wouldn't be getting into that. He can characterize them the way he wants, and you're free to characterize them the way you want, and to say, and of course, there's much more to it than your emails. I didn't think they were accurate. Whatever your testimony is going to be, he opens that door by asking that question. That's why you often don't ask your legal adversary a question. You're like, I'll drive the bus through that one. But I think he's entitled to get into evidence that however the jury's going to weigh it, that you in fact did forward to your clients what Mr. Edwards is characterizing as efforts to de-escalate. Because Mr. David said, I didn't ever get anything like that. And then maybe he read it and said, this is the opposite of de-escalation. I'm even more insulted now. Okay. But right now the jury is left with Mr. Edwards saying, did you get these things? And Mr. David saying, no, I didn't. And it sounds like you at least forwarded them. I think he's entitled to explore that without diving into the substance of the communication.
Well, the one thing I'm concerned about, and again, it's his characterization that he's trying to de-escalate. And
Right.
so there's a problem with his characterization. And there's been a practice of this, you have a conversation and it comes back and.
I'm only suing to de-escalate.
And so I think that's why when we have demand letters, those certainly come in, and that's typically where we start a bad faith conversation.
Right.
These one-sided, let me have a conversation with somebody and then send you an email that re-characterizes it and then go, aha, you didn't do it. I have a problem with. The second thing is, it's a lot. So we've been around and around with this. There was an emergency motion before the special master on this. It makes a big assumption. One, what time did the email go? What time did the client read it, if at all?
It's more than just a 30-second reaction. If I'm remembering the testimony, tape goes up, net goes up the next day. So it's not a within 4 minutes kind of thing. And if you all think that jurors are following the timeline that closely, again, you're misreading the jury. But I hear you on that, but you're able to argue what you want out of it. It seems like it is factually correct that you and Mr. Edwards had some conversations. He synthesized them in a way that may inure to the benefit of his client. That's his job. Send it to you saying, hey, maybe this is a way to de-escalate. And you, doing your job, send it to your client. You may even give them some advice that this is crazy, don't do this, or maybe it's a good idea. He can't get into that. He won't get into that. But he is entitled, I think, to say, did you get this? You can say, I don't characterize it the way you did. Did you forward it to your clients? Yes, I did. He can't go further than that.
Judge, just for the record, I'm sharing my screen. I mean, the words de-escalate, antagonism, the phrase, I specifically used that phrase in my letter.
I don't doubt what's in there. What I'm hearing from Ms. Sturm is that she's saying, not my words, not hers, a little rich to say, hey, it's the Davids who need to de-escalate and antagonism.
Well, Judge, if you read the whole thing, we asked for a mutual injunction to bar either side from accessing easement 2 until this case was over. It was, and I say on the next page, goose gander. Goose gander.
Right. Okay. So yours was in your mind a fair and balanced proposal. The jury's not going to decide that because.
I understand that, but just to put everything in context, this is what happened. If she wants to call me for cross-examination, by all means.
You know what? I don't know why you think that's gonna advance your client's cause to dive down that rabbit hole right now. If that's
Okay.
where you guys decide going and the rules of evidence allow it, I'll do it.
Okay.
As painful as it may be for everyone involved.
Right, I think,
We
I think I've made my,
witnesses in
No.
this case.
No, it was Mr. Edwards said you could call him, not that he called you. You're gonna be on the stand talking about all the money that you're charging your client, and I think that is the opportunity for Mr. Edwards to say, hey, did you not get these emails that talked about a mutual de-escalation? The words are in there. And you're free to say, yes, but it wasn't mutual, or, you know.
Well, I don't think those emails should come in.
No. I don't think they should come in either. My ruling is this. He can ask you about them. He can ask you, did you forward them to your clients? And your answers are whatever your answers are. And he can characterize what the gist of the emails were. But my ruling is, and he can object if it's not sufficiently broad, and he'll preserve that for the record, is that the emails don't see the light of day. If we want to enter them into the record, I'm fine with that. But they're not going to go up on a screen. They're not going to go back with the jury. But I don't think he showed me the whole thing, which is always smart. I don't think it is a mischaracterization on his part to say, I sent you an email that said, even if it may not have been, in your mind, a fair summation of the exchange you and Mr. Edwards had, said, hey, you know what? Let's de-escalate mutual injunction. Just everyone stays off there. It goes back to the good old days of Nightkerks and Darby's, and people are just throwing their compost in there. And I don't mean their avocado rinds, but just the yard trimmings and everything. It's a beautiful, natural, pastoral backdrop for both houses. And he's saying, let's just do that until we get clarity on how this case is gonna go. You forward it to your client, and he then has that handhold that he's entitled to say, here's bad faith. I made this offer, and what is the response that my clients get? Lacrosse nets, party of 8 people on Christmas Eve, burning things where there's pine straw everywhere. If that's what argument he wants to make, he's entitled to make it. And I think this is relevant to that. And it isn't, if we keep it at this level, violative of 408. So that's my ruling. Mr. Edwards, if you want to tender those, feel free. Just label them.
they're already marked. They're already,
Plaintiff's X, whatever they are. When we get Mr. Williams back in here, I'll admit them for the record. And that way you're preserving, if your argument later on, if there is an appeal, is that I unduly circumscribed your ability to explore this with Mr.
that's fine. And they're in our exhibit binders. I'll have her look at them. And I'll offer them, and I understand, of course, where you're going.
I think we would have to make an objection to, just simply because it's a one-sided story. It has none of our communications. And so I think it would be improper to make him part of a record. If he wants to show them to me, I think that's fine. Making him part of a record without the complete record is a problem.
No, you make a great point. So I want to reemphasize, record, if there's an appeal, not for the jury to see, but if you think there are corresponding emails that ought to be entered to complete the record, that an appellate body should be considering in connection with this pretty narrow issue, which is, can I effectively impeach Mr. David's testimony and establish possible bad faith? Those should go into, I haven't heard Mr. Edwards say anything other than put them all in. So let's make the record as complete as you need it to be. That doesn't have to happen right now. The onus is on you to corral those emails and say, here's defendant's exhibit X. And these are the emails we think corresponds to the ones that Mr. Edwards admitted to the record during, in about 2 minutes. Okay,
That's fine. Thank you, Judge.
all right. Mr. Williams, welcome back.
Thank you.
You're very welcome. You're always welcome to take care.
I'll move first, next report.
Thank you, Deputy Gordon. Hello, smaller number of jurors. How is everyone? It's Friday morning. I hope no one got here at 8. But I appreciate everyone being on time. That when you flip that switch, a little light goes on. It's great. Annoying buzzer goes on as well. So you immediately pay attention when you press the button. We are ready for closing arguments. The way closings work in civil cases is that the party that brings the initial claims has the ability to open and close. First word, last word. This is a little complicated because we have sort of two sets of claims. But the first set of claims brought would be the Andersons' claims. And so Mr. Edwards has the ability to open and close. You can waive your opening, which Mr. Edwards has done. So he's going to get up in front of you one time at the very end when everyone else is done. That means I turn to the David's lawyers to say, what are you going to do? And they, of course, need to give, if they choose to give a closing, talk to you about their defense against the claims. But they also are proponents of counterclaims. And in theory, they can waive that opening to try to have the last word. But that gets kind of complicated. So we're actually going to hear first from Ms. Sturm on behalf of the Davids concerning a defense to the claims and being a proponent of the counterclaims. Then we'll hear from Ms. Medwick defending against the counterclaims. If Ms. Medwick says something that Ms. Sturm really wants to get up and rebut, she has that right to close, opening and closing on the counterclaims. So she may sandwich what Ms. Medwick has to say. But when Ms. Sturm is done, Ms. Medwick is done, then Mr. Edwards is going to get up and say, let me tell you about the Andersons' claims. And he'll have the last word. When he's done, I will give you the law. That's what we've been talking about this morning. We've distilled it down to something that I will share with you when it's my turn to address you all. And then you'll be able to deliberate. Now, this isn't going to take 5 minutes, so we'll be done today. You'll get the case today. That's not my point. But we may have a break in the midst of closings. It may be at the end of closings, we break before I give you the jury charge. Fit lunch in there somewhere. We can make it a short lunch. Figure out if we can get lunch brought in, as I know you all want to get this case so you can begin the last part of your job, the most important part, which is your deliberations. Just wanted to give you a forecast of what today is going to look like. And with that, Ms. Sturm, please.
Thank you, Your Honor. Good morning, ladies, gentlemen of the jury. First, let me take this opportunity to extend, both on behalf of my client and myself, our wholehearted gratefulness for you being here. We understand, we certainly do, that this is time away from things that you have to do. And those things are important. And so we appreciate your patience with us. If you've learned something, you've learned, one, that the legal field is not good with technology, right? Bright idea of some entrepreneurial mind out there. We need help. But in all seriousness, we do need your help, and we do appreciate that patience that you've extended us. We didn't want you here. We certainly did not bring this lawsuit. We didn't envision we would be here. We didn't envision that we would have to bring 12, now 9 of you into this nightmare with us. That is not at all where we thought this would go. And so we really appreciate your time, your consideration in helping us resolve this. You heard my client say they want and need this to stop. It's their home, right? I don't have to go back there when this is over. You all don't have to go back there, but these parties do. They're going to be living next door to each other. And so we need your help. And what we're asking for is, we think it's real simple. I told you at the beginning of this case, this is a case about interference with easement rights. It's real simple. You've heard the evidence, and we're asking at the end of this, when you go back and deliberate, that you return a verdict denying all of the Andersons' claims and returning a verdict in favor of the Davids. And that's on their claims and damages. You heard me say it's not a difficult case. I told you that at the start. I said it's an easement case. And in this case, we have an easement agreement. So we've got a document in writing telling us how this easement works, right? I want you to keep in mind one thing. When we started this case, right, the Andersons put up their claims. What did they not show you? They did not show you that easement agreement, right? They didn't want you to see it. They didn't want you to read it. They didn't want you to hear me talk about it. There is no dispute. The Andersons purchased property subject to the easement agreement. Mr. Anderson admitted it, bought it, knew about it, got a copy of it, several occasions. The Davids purchased the neighboring property, subject to the same easement agreement. Easement 2, which is at issue here. Davids can use for any legal purpose whatsoever. If they want to build a shrine, they can build a shrine, provided it doesn't defeat some kind of zoning or land use code. If they want to build a parking area, they can build a parking area. Again, we got to make sure we're complying with zoning and land use laws. If they want to walk across it, they can walk across it. If they want to play lacrosse on it, they can play lacrosse on it. If they want to sit on it, they can sit on it. If they want to use it as a natural vegetative buffer for privacy in its natural state, they can do that. There is nothing unlawful about that. Again, the Andersons knew about this easement agreement when they purchased the property. And I want you to remember, they purchased their property only a year and a half before the Davids. They did not do anything with easement 2 until after the Davids move in. Mr. Anderson tried to change his testimony on that on the stand. You will recall I deposed him and he said there had been no use of easement 2 before the Davids purchase. I want to talk a moment about the claims that the Andersons have brought against the Davids. And you heard me talk about them in opening as well. One, you heard me say, don't be fooled, right? These are distractions because of the conduct and the activity that is carried on in this case. They're intended to distract you. They're intended to make you think, oh, there's something else here. There's nothing else here. It's clear. It's a case about interference with easement rights. But what they want to claim are some other things. And I want you to pay attention because these are manufactured claims. And you need look no further. You heard it in the opening statement from opposing counsel, Mr. Edwards, when he said, in my office, when we get a demand letter, that means you're a defendant. Right there, he told you that the point was not, I'm going to reach out to the other side and see what can be done. It's, we're going to sue you. And that coincides actually with what his client's perspective was too. You can look at, I think it's Defense Exhibit 25. It's an email from Mr. Anderson to his landscapers. And that's when he got caught, when Mr. David caught him trying to fence off easement 2 from the David property. Mr. David called up Mr. Anderson, and apparently Mr. Anderson sent an email to his landscapers. And in that, he tells them, you can read it, it'll be in evidence. But he says, one, the French dude's right. Assuming that's Mr. David. 2, he says, I'm going to go ahead and consult my legal team. I'll get the legal fight going. That's October 5th of 2020. That's before my office does anything. We're not even retained. But it's before any cease and desist letter. It's before any notification. The strategy here on the Anderson side, as I told you before, it's to intimidate, it's to harass, it's to bully. These are all the things we see out of folks who bully. I am going to bully, intimidate, and harass you to prevent you from doing what is rightfully yours to do. As a society, we should not stand for that. And as jurors, I hope that you do not stand for that kind of behavior. So they have broad claims in this case. You heard me say at the beginning, one of the things that they're arguing is that this easement was extinguished or it was abandoned, so to say. And you heard me say at that time, don't be fooled by that argument, right? We are not talking about extinguishment. We are not talking about abandonment of an easement. The judge is going to instruct you on the law, but when we talk about the law, again, we've got a written, recorded easement agreement. It's Defense Exhibit 1. You get to see it too. I'm real sorry, it's small print, but you can read it. When we have this written document, the problem we have here is that it's not merely what the defendant, what the Andersons want to argue to you is that they didn't use it. There was non-use. There's no use of this easement. We don't like your concept that somebody may enjoy this natural buffer. There's no use. The problem with that is that you cannot abandon an easement like this merely for non-use. The law is abundantly clear. It's got to be unequivocal, decisive abandonment. That would be Mrs. Darby saying, I abandoned easement 2. We certainly did not hear that from her, right? I mean, Mrs. Darby was real clear. She enjoyed it for its natural state. Her husband walked through it. She had a wedding in her backyard, enjoyed the privacy it gave. There's no decisive action. She also talked about the fact that on 2 separate occasions, folks had asked to purchase that easement 2. She said no the first time, and she said no the second time. And what's important about that too, keep in mind, is that second time was right before the Andersons purchased. When the Nykirks asked if the Darbys would sell easement 2. She said, no, why would I do that? It's valuable. It's valuable to my property, right? It's a valuable right. I'm not gonna sell it. So don't be fooled here. This is not an extinguishment. This is not abandonment. And on top of that, again, we show you that when they purchased in 2018, and remember, they bought from Miss Nykirk, real estate agent. She signed the deed saying, what I am conveying to you is subject to an easement agreement. Same easement agreement it was subject to when I bought it. That is what she conveyed in 2018 to the Andersons.
You hold on 1 second, Darby. I'm sorry. No, would you like some water?
I can't hear you.
You can't, sorry, I didn't know that was.
I'm sorry.
You're okay. So the Andersons bought it with notice in their deed, and then a year and a half later, my clients buy their property. Again, their deed explicitly referenced same easement agreement. You heard Miss Darby talk about the fact when she bought the property. And she bought it from the original, one of the original owners who entered into that easement agreement. And she said the same thing, when I bought this property, subject to the same easement agreement. Nothing has changed. This document has not been rescinded. It has not been modified. It has not been amended. And you need to pay attention to that because there is no evidence of that anywhere. It appears that the evidence that they want to use is this, what they call the trash heap. That a landscaper that the Nykerks used at some point in time dumped trash into this area. Again, don't be fooled. That does not meet the standard of where we need to be. Let's talk about adverse possession. Because similarly, they have brought a claim for adverse possession. Claiming, again, if we look at what they call this trash heap, this landscaper who dumped yard waste, sounds like some materials. We heard about some railroad ties, and some other materials into easement too, that now has created this claim of adverse possession. What does adverse possession mean? Again, you're going to hear from the judge. This is not adverse possession. To be adverse possession, it's got to be open. It's got to be hostile. It's got to be notorious. And so exclusive of a use that you defeat the use for which it would be otherwise. There is nothing notorious here. One, it's not like they went in, the Nykerks went in and fenced it off and said, hey, nobody can come in. It's not like when the Davids purchased it, there were a whole bunch, and when the Nykerks had it, there were a whole bunch of no trespassing signs. And I should say, with their claim for adverse possession, what they're trying to say is that if we go back 20 years, there's been such an open, notorious, hostile, so exclusive of a use that it's obvious it's now ours. And again, this appears to be based on this concept that a landscaper dumped some stuff in there and that there was vegetation that had grown up, right? Let's break that down. Ms. Nykerk couldn't tell you exactly where in easement 2 this dumping occurred, correct? She even indicated at some point in time that she was able to get there. She didn't walk the whole thing, and she didn't know if maybe somebody walked in an area she couldn't see, whether they were still using it. There's nothing about this landscape waste that's being dumped that's open, notorious, and would prevent somebody from otherwise using easement 2, which can be used for any legal purpose whatsoever, right? What did Ms. Darby tell us? She defeated this immediately, right? To the contrary, there is nothing obvious and so hostile to use that would defeat our use of it. In fact, Ms. Darby, who lived there the whole time the Nykerks lived there, said that she continued to use easement 2 for that natural buffer. She had that wedding in the backyard, the privacy that it afforded, and her husband continued to walk easement 2. You may recall she also mentioned visitors that came to the house that on occasion would park on West Andrews and use that area to come up. So there's nothing in the evidence that shows any adverse possession that would benefit the Andersons in this case. And even more basic than that, we would bring you back. I don't need to repeat it, but we would bring you back to the deeds, what everybody purchased, right? 2018, we don't even, they say lawyers are bad at math, and I will attest to my math skills are not the best, but we don't need to do a lot of math to know 2018 doesn't get us to the 20 years that we would need it, even if we could show some kind of open, notorious, hostile use, right? It's just not there. You bought in 2018, you bought subject to an easement agreement. And my clients bought in 2020, subject to that same easement agreement. So don't be fooled. I know you won't be, but don't be fooled by these claims. They also have claims for trespass. It appears that those claims deal with some workers that crossed the Anderson property, alleged. We've seen no photographs of that. You've heard the Anderson property has 9 surveillance cameras on it. 9. Not a single footage of workers going across the Anderson property. And keep in mind also that this allegation is not the Davids. They don't have any evidence to show you that the Davids came on, trespassed onto their property. Right? Unless they want to say when Mr. David went and knocked on the door, you know, to talk about the trash, which hopefully neighbors do, right? Go knock on the door. That's a trespass. I mean, certainly they're not going to go down that road. But so we have these workers. We have no evidence that this happened. It's an allegation. There's no evidence of it. 9 cameras, not a single footage. There's also no evidence that the Davids controlled where those workers went. In fact, you heard Mrs. David say, we didn't. But when we did learn that somebody alleged that they were doing this, we reached out to their boss to say, hey, make sure if you are doing, you know, parking on West Andrews, you know, that you use the easement. So there is simply no trespass. Nuisance, one of the claims that they brought. The interference with a property rights. You're going to get the law from the judge again. And what they're going to argue, or at least what it appears that their case is based upon, is that my clients exercising their rights to use easement 2 have created a nuisance. Okay. They're going to talk about those property stakes that went up, those property lines that went up. I mean, you heard Mr. David and you heard Hopkins on both of those as to why those are important. But I suspect that they're going to point to those to say that's a nuisance. They're ugly. They, you know, interfere with our use and enjoyment. Remember, it's got to be an unreasonable interference with use and enjoyment. But I suspect that's what they're going to argue, along with the equipment. Equipment that they call raggedy, rusty, molded. They're going to say, Hopkins, you heard from Hopkins, that his equipment and his activity out on easement 2 was a nuisance. Think about that. That would be your kids playing in your yard or an area where they're rightfully allowed to be, now being called a nuisance. Be a problem for society in general because most of our kids, ideally, are outside playing. And if now they're playing, it's just because your neighbor doesn't like it, maybe he doesn't like lacrosse, or maybe, you know, he prefers they play football. Is that now a nuisance because I don't like it? So I caution you that this is not a nuisance situation. There's also a claim by the Andersons for attorney's fees. And one of the claims they are going to make appears to be based on what they call bad faith. Bad faith, from a legal standpoint, the judge will tell you, pertains to bad faith in an underlying action. What Mr. Edwards and the Andersons are trying to do with this claim is manufacture a bad faith claim after they filed a lawsuit. And part of that is what you heard Mr. Edwards try to say was an effort to de-escalate. You heard me on the stand say, I believe that is a mischaracterization of what has transpired. But you don't have to listen to my words and you don't have to listen to his words. What transpired before all of that? Anderson's purchase with full knowledge of their easement agreement. Year and a half later, my client's purchase. After my client's purchase, the Andersons clear. They install fence that they intend to install all the way down the easement line and block off access. They put lighting in a tree on the easement. They put sod and have an intent to go all the way down that easement area where they cleared, easement area 2. We know that not just because we have a landscape plan that shows that. We know it because there's a sprinkler head. You don't put a sprinkler head in pine straw. You put a sprinkler head where you want grass to grow. And so we know, again, that this is not unintentional. There was an intent to what they were doing. So don't be fooled by this concept where Mr. Edwards may try to say to you, oh, well, hey, we were trying to de-escalate. That is not at all what was going on. Punitive damages. They brought a claim for punitive damages. Intent to harm. There's no evidence that my clients intended any harm to the Andersons. It's quite the contrary. You've heard them say over and over that we bought a property that gave us rights to these easement areas. We were merely exercising our easement rights. This is not a punitive damages case where the Andersons are entitled to punitive damages. If anyone's entitled to them, it's the Davids. Let's talk about the evidence and the Davids claims. And I want to be real clear again that those are the claims. I don't have the crystal ball of what Mr. Edwards will get up here and tell you. That is what I believe he's going to tell you. And again, I would say, don't buy it. There is no evidence on any of those claims to sustain them for the Andersons. The evidence in this case supports exactly what we told you at the very start of the case. We have an interference with these. Anderson's bought 2018, subject to the easement agreement. Davids bought 2020, subject to the easement agreement. You've heard all of that in evidence. You're going to see documents. After the Davids purchased their property, what do we have? We have interference with an easement right. You've heard both Mrs. and Mr. David talk about why they purchased this property. And one of the reasons they purchased this property was that it had what you would call a selling point, right? It had this easement access. It had this easement agreement that gave them these rights. And these rights to do anything, any legal purpose whatsoever, right? You can use it for any legal purpose whatsoever. You heard them both, though, talk at the start of, in their testimony, that when they purchased it, sure, there may be other thoughts like, hey, this is great because we could potentially put a driveway in. But you heard from both of them that the selling point, when they purchased it, what they enjoyed about it was that wooded area, that privacy.
The same thing Miss Darby talked about, this privacy, this ability to have this area where it feels like, you know, you're sheltered, you're set off from West Andrews, that you're in this little forest. That's what they enjoyed, and that's what was immediately taken away from them. Andersons don't deny clearing. They also don't deny that they didn't ask or even notify the Davids before they did it. Interference with an easement. We also have the fencing. You heard the testimony about the fencing from Mr. David telling you how he encountered the worker and that the worker had already dug the post holes. We have Mr. Anderson admitting in his testimony, yes, I was going to extend it all the way down the line. We have the landscape plan that the Andersons had put together. It doesn't dispute that. It shows that the fence was going to go all the way down the line. And that there was going to be a fence on the West Andrews side. Interference with easement rights. There's a light. They don't deny putting up in the tree. Didn't ask, didn't even notify. It interferes with the easement. There's sodding and a sprinkler system. Now the sodding at this point, you look at the photos, you'll see that it barely encroaches. And you heard the testimony, and you have the landscape plan again, that shows that there was an intent to extend it further. And again, we know that because we've got a sprinkler head too. It's an interference with an easement right. But what's even more obvious and maybe upsetting are not necessarily the clearing. The clearing is extremely problematic. But these things I've talked to you about, they interfere with an easement right. But let's talk about what's even more upsetting, right? It's the yelling. I'm not going to go through all the terminology in this case. You and I know it's not neighborly talk. It's not the way we teach any of our children to speak. It's morally reprehensible. This is not the way people behave, and it shouldn't be. But those events, the yelling, the racial slurs, the conduct associated with that, make no mistake about it, that is intended to intimidate and prevent and bully so that you are not using this easement right, so that you do not feel comfortable when you're out there. I want to make sure you know that I do not want you out there. And I don't want you comfortable in your use of it. And who did we hear that from? We heard it from Mrs. David. We heard it from Mr. David. But I think if you think back to Hopkins testifying on the stand, remember what he said about being out on the easement. And not that he hasn't, but the way he feels every time he's out there. That lingering in my head, right? That uncomfortableness. That is interference with an easement right. It may not be the fence blocking off, but make no mistake, it's no different. It is an interference with an easement right, and in this case, it's intentional and it's designed to have a specific impact. And you heard these folks saying it is. Mr. David testified that he would probably use the area more, but it's uncomfortable, doesn't want to. Mrs. David doesn't want to be out there, right? She goes out, she will pick up some stuff, but she's not feeling good about it. And she's restricting her use because of that, right? I don't want to be seen by this guy for fear that I may be on the receiving end of some unwanted aggravations again, some assaults, some yelling. So the conduct here is a clear pattern of interference with these easement rights.
Describe their backyard, a secret garden. And we saw a couple pictures of their backyard. It's gorgeous. It's beautiful. A secret garden. Well, a dumping ground for yard clippings, trash, rotten wood, plastic bottles, place where venomous snakes live. Is that a secret garden? No, they weren't the same. And you don't have to take my word for that. I went through every single plant that David Shostak saw in the green area, and it was on the screen the whole time. You could see for yourself. It was the David's backyard. It was randomly picked because Ms. Sturm told him it was similar. And I went through every plant. We talked about it, and I asked every single time, is that native to Georgia? Is that native to Georgia? Is that native to Georgia? No, 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 no. And I even asked one of them, I said, is that the Old English ivy? Is that considered invasive? He said, yes. So they weren't similar. And I even asked, I said, you wouldn't know if the random area that you picked had ever been landscaped, would you? And he said, well, actually, yeah, I would. Oh, really? How? And he said, well, because of all the plants that we just talked about. And I said, right, because they're not native to Georgia. And he said, right. Well, here's something that we all know. And of course, everything I'm pointing out is in evidence, things that you heard. Easement Area 2 had never been landscaped. You heard from Miss Nykirk. You heard from Miss Darby. You heard from the Andersons. Everybody who's owned that property or lived next to it for a period of time, Miss Nykirk never used it. No, except for a dumping ground. Sure, yeah, I dumped stuff in there. I think she even said she let her neighbors dump stuff in there. Mrs. Darby said, I never planted anything in there. No, absolutely not. I never planted anything in there. It had never been professionally landscaped. So everything in Easement Area 2 was native to Georgia. It was, and I believe Miss Nykirk described it as wild. It was wild, and it was wild to Georgia. So asking for $87,000 worth of landscaped plants that just happened to be in the David's backyard is completely and totally unreasonable. That's not a replacement cost. And to that point, since the secret garden was such a drawing, exciting thing for Mrs. David, it's interesting that there's such an issue with clearing out an area that was full of weeds, trash, rotten wood, poison ivy, plastic bottles, venomous snakes. Seems like you'd be happy that that's gone now. Another thing about the clearing, and we heard testimony from Mr. David at some point in time, I believe the exact date was August 12th, 2021. He did some clearing for himself an easement too for his path. Seems like that was okay. He needs to clear something. No problem. I asked, did you talk about the Andersons with that? No. Okay. So I guess if they want to clear something, that's okay. I don't know. And one last thing, they talked about a driveway. And Mr. David said, well, we've never, we've talked about it, but we never put any real plans together for the driveway. So that's not really something that we've seriously talked about doing. And Mrs. David said that it was enticing for her. So it was enticing for her. So if the driveway was ever going to go there, probably have to clear easement too, especially of all that trash and stuff. So the big one, interference with easement too. And of course, and Ms. Sturm told you when she was talking about conversion, which was, the vegetation and everything, she kind of said, well, even if you don't find that, that could go to interference. And one reason about that is when you hear the law on conversion, part of that is because you have to own the property that you're claiming was converted. Well, we know from evidence in this case that the people who own easement two, that's the Andersons. They're paying taxes on it. They own it. They're the property owners. So they own that property. So that's a difficult road on conversion. So let's talk about some other interferences. Again, I can't say enough. Communication is really key. If you don't want someone to interfere with what you're doing, you got to tell them what you want to do. It doesn't have to be a long conversation, just to check in. Hey, here's what we're planning on doing. Please, now you know. So that's what we're going to do. But that communication never happened. Let's go ahead and discuss their main allegation with interference on easement area 2. The things that they're claiming Mr. Anderson has said and done. One of them we know is true. Mr. Anderson got up on the stand and said on February 24th or February 21st, 2020, or February 24th, I'm sorry, 2021, there was an unfortunate exchange with Mrs. David. Now, you heard some differing testimony about that. Mr. Anderson gave you some context as to what was going on that day. The guys were laying down some sod on the Andersons' portion of the property, and Mrs. David told him to stop. Don't you lay that sod down, that's easement area 2. It wasn't. And she claims that was a nice conversation. I don't know. But that got back to Mr. Anderson. He found out. And then at some point in time, she came back, and that's when the exchange happened. Now, Mr. Anderson has admitted, she got under my skin. She told my workers to stop doing the work I'm paying them for. And then she called me a bad person. And then she started talking about my marriage. And that just kind of pushed his buttons. And he said, I shouldn't have said it. I've apologized. I regret it. I shouldn't have said it. He admitted that he was wrong for saying that. According to Mrs. David, she said nothing at all. That's totally unprovoked. That's a credibility issue. You're going to have to decide where you think the truth on that, if that portion of this matters to you. But here's what we know happened next, what I think is very telling for the rest of what we're going to talk about. After that exchange, the February 24th, 2021 incident, the Andersons got a cease and desist letter, which was when they first found out that there was really an issue with anything, as far as like the clearing of the weeds and stuff and all of that. That's when they first found out. And the letter stop everything on easement area 2, or we're gonna put a lien on your property. It's pretty threatening. So they got that letter. Also, Mrs. David called the police on Mr. Anderson that day. So she called the police on February 24th, 2021. On February 26th, 2021, they get the cease and desist letter. And then 2 weeks later, she files a temporary protective order on him. And this is all related to that interaction between Mr. Anderson and Mrs. David on February 24th, 2021. That's how all of that was addressed. So let's go to there was an allegation that Mr. Anderson had a gun in front of Hopkins David. Well, now we know through testimony, Mr. Anderson told you, and Hopkins David took the stand and told you the gun was in a case. It was in a sealed case. He wasn't pointing a gun at a kid. That simply didn't happen. And Mr. Anderson said, well, there was, one day where I can remember that I had gone to the shooting range. I had the gun in a sealed case. I took it from the car. I put it in the gun safe. I didn't know he was out there. And, Hopkins David said, well, it was in a case. So we know it was in a case. We know it's not this man waving a gun at a kid. And you know what didn't happen? Police weren't called. Temporary protective order wasn't filed. That's going to go to credibility, and that's going to be something for y'all to think about. Another allegation was the surveillance camera to the David's daughter's room. Well, I mean, of course, Mr. Anderson testified what the surveillance cameras are, where they're pointed, at entryways in their house, but they're not surveilling the Davids. And what didn't happen when Mrs. David believes that a camera was pointed at the window? No calling the police, no temporary protective order. And certainly for these last two involving your kids, I would imagine if this is what you really believed, if this was serious, you would handle them accordingly. But none of that happened. And then the racial slur allegation, which happened, they say, twice. Also, no call to the police, no temporary protective order. This is all going to go to credibility because how they acted on February 24th, 2021, you could certainly draw the conclusion that they would have acted exactly the same for all of these other incidents if they did in fact happen. And of course, as it relates to this case, because one of the things that you should ask yourself as you're going through the evidence is, why did I hear this? What does this mean for this case? Because remember what you're deciding. Was there a material interference with easement rights? Did any of this stop them from using the easement? No. In fact, I actually asked Mr. David on Wednesday. He's named all the stuff that they did on easement area 2. They walk on it, he sits on it, there's someplace they cross on it. I said, have you done those things? Yes. Have you continued to do those things? Yes. Well, it doesn't sound like there's any interference with what they did. And of course, with Hopkins David, he said he's practiced lacrosse on easement area 2 hundreds of times. So he certainly still does. And again, that's going to go to credibility and something that y'all need to consider. If the Davids are truly so frightened of Mr. Anderson, don't you think they would have told their kid, it's not worth it. Don't go out there. We have a whole backyard with a net up. I mean, there's a net up in their backyard. You saw it in the pictures. practice back here. It's not worth it. But they didn't. So Hopkins David still practices on easement area 2 whenever he wants. He had a fire pit party with his friends over the holiday break, like 8 friends. If the Davids were so afraid of Mr. Anderson, would eight sets of parents say, your kids are totally fine? I mean, that's something that you're going to have to think about. That goes to credibility. Do you find that testimony credible? You're going to let 8 kids that aren't yours go have a fire pit party and at the same time claim that you're terrified of somebody? That matters. Another allegation that they made, Mr. Anderson moving nets and or turning over nets and denting a solo stove and doing something with a chair. Well, we don't have any pictures of that. And I think it's safe to say, and I think y'all know by now, we got a lot of pictures of everything. We have a lot of pictures of things. When something happens, people are taking pictures. And I can't think of something easier than taking a picture of something that isn't moving. There's a net toppled over, take a picture of it. There's a stove with a dent in it, take a picture of it. We didn't see any of that. And in fact, nobody saw Mr. Anderson do that. They just said that it happened and that it had to be him. So, you know, that's testimony that you're going to have to decide if you believe is credible. You got a lot of pictures of other stuff. Why don't we have a picture of that? That also actually brings me back to, I apologize, I forgot to mention this at the time, but the racial slur. Nobody saw Mr. Anderson said it. The testimony was basically, we heard a voice, and Mrs. David claims that she can recognize Mr. Anderson's voice from the one time that they've spoken. You may question whether or not that even happened at all. But considering the level of detail that we have about that February 24th, 2021 incident, I mean, we know everything everybody was doing on that day. We heard about it for a long time, and we know everything. And for these other incidents, can't really remember a whole lot about the exact day, the time, what was going on. So again, that'll go to credibility. And then the last allegation, the trespass on the dumpster. And I talked about that a little bit, and I'll wrap this point up pretty quickly. Again, Mr. Anderson's son-in-law put that in there. I already told y'all about that. And I asked, I said, do you have any, did it cost you extra? Do you have any receipts about that? I mean, you don't have that evidence in front of you. There's no monetary damage related to that. It was, there's also a dispute as to where that dumpster really was. So you heard from Mr. Anderson that it was on easement area 1. Well, if it was on easement area 1, they can't really trespass there. If it wasn't, I mean, that'll be for you to decide. And I think you also heard during this case that wasn't really that big of a deal, but it's here. So it, certainly if it's on easement area 1, it's not a trespass. If it's on their driveway, you make that call. You consider the credibility. And also with credibility, something that was very different. I had the opportunity to ask Mr. David questions on both Wednesday and Thursday. On Wednesday, he talked about the conversation with Mr. Anderson about the dumpster. It went well, it was fine, everything was resolved. On Thursday, after he heard his wife and son testify, well, I felt pretty uncomfortable about that testimony. So when there's a total shift in how somebody is talking about the exact same situation, that's going to go to credibility, and that's going to be something that you're going to have to decide. So again, what you're really being asked to consider if there was material interference on easement area 2, and I think the evidence is overwhelming that there wasn't. The Davids have never been stopped from using the easement area 2, and the Andersons haven't tried to stop them. They've stayed away from easement area 2. Certainly since this lawsuit was filed, they haven't had anything to do with it. And you have plenty of evidence that every single member of the David family has used easement area 2 in any way they wanted, as often as they wanted. So to claim interference seems a bit confusing. And it seems like the Davids don't want the Andersons to have anything to do with easement area 2, and that's not really fair, and that's not what the law says. And the judge is going to give you some legal charges before you go back, and I want you to listen to that. But the Andersons have all the responsibility of ownership. They're paying taxes on the easements, and they're not using it all at all. But the Davids are, as much as they want. As far as attorney or punitive damages are concerned, there are several instances, and I've gone through them with you, where you may truly come to the conclusion that they just didn't happen. We know how the Davids act when something actually happens. Calling the police, filing a temporary protective order, doing those types of things. And certainly those other allegations were not less than the one we know about. And the photographs, the videos, Mr. Anderson addressed why there was a video of Hopkins David. He said, I was taking pictures and videos to send to my legal team for any uses on easement area 2. And that was his purpose. He's not trying to be, taking videos of a little kid. We're in the middle of a lawsuit. He was trying to show his legal team, this is how they're using easement area 2. I have a picture of it. I have a video of it. And there was that one video of Hopkins David. We saw it, one video. If there were more, you would have seen more. And in that one video, you can decide for yourself. You saw the way that Hopkins was interacting with Mr. Anderson and his body language, and you can decide if it looked like he was afraid. And that'll go to credibility. I told you in the opening, and this is still true. Use your common sense on all of this. It's your guide. That's part of the reason that you're here. And as you're going through these, consider the evidence. And the evidence clearly shows that the Davids just simply haven't met their burden on any of this, because actions do, in fact, speak louder than words. They've been using that easement as often and in any way they want. I can't get up after this, and I'm sure you're happy about that, and that's fine. I've tried to keep everything I've done short, but honestly, even if I could, I wouldn't, because I think the evidence speaks for itself and it's very clear, and the Davids just simply haven't met their burden on anything in this case. Thank you so much for your time.
Thank you, Ms. Medwick. Ms. Sturm, it looks like you're ready to say some things. Give me a ballpark duration, because we're going to talk about a break before Mr. Edwards starts.
Real brief, 15 minutes.
Okay, we got 15 minutes of gas left in the tank before we break? Yes? Yeah. Great. I had a big clock, I'd have it do a countdown.
Do it, do it. Let's put me on the timer.
In federal court, they do that, and it's a beautiful thing, unless you're the lawyer. That was a bad.
You start talking real fast at the end.
Yeah.
I'm only here because I said it in the beginning, didn't I? Don't get distracted. That's what they want you to do. That is what they want you to do. Let's talk about just a couple of things, because timeline, you heard Ms. Medwick say that's important. First time we heard Mr. Anderson say he started clearing in 2019, right there.
And you recall, how did I start that testimony with him? Reminded him that I took his deposition. And then asked him to read his deposition to me after I asked him the question twice. Are you sure it was 2019? Because when I took your deposition, you told me I didn't make any use of easement area 2 before the Davids moved in. We don't even have to sit there because we know that's also true. Who else told us that easement 2 was wooded when that Davids purchased their property? Mrs. Darby. Mrs. Darby told us easement 2 was wooded. So don't get distracted. Don't bite. Let's talk about the statement Ms. Medwick made. Every time we did something and they asked us not to do it, we stopped. That is a very generous way to characterize that. We cleared, we didn't ask permission, we didn't notify. It's already done. Sure, we didn't do any more, but we did it. The fence. Put it up, we were gonna go further. Mr. David had to talk to the worker, hey, we've got an easement, please don't do that. And what they're telling you is, oh, we stopped. That's not what happened. The trash, they say, we didn't do it again. We stopped. Told us we didn't like it, we stopped. What they're doing here is they're saying to you, we didn't notify you about any of these, we didn't ask permission to do any of these, and now we're coming to you and saying it was fine for us to do it, and we are now seeking your forgiveness for what we did. There are no pictures of these snakes, of this trash heap, but also if it is such a mess that they complain about. This is Buckhead. Somebody in this neighborhood would have called City of Atlanta and said, we need somebody out here to tell us that we've got a health hazard here. There is no evidence of that. None. Certainly in Buckhead, if there was a problem, there would have been some action. There would have been that notice. We don't have that. So these aren't, we did these things and we stopped every time they asked us to. Make no mistake about that. That is very much, we did them, we're now seeking your forgiveness. But don't forget what happened after that, right? So now we're just gonna start filming you constantly. And we're not just filming you, but we're intimidating you while we're doing it. And we're yelling at you while you're doing it. The racial slurs that we talked about. Yeah, we're not going to say them again. They're morally reprehensible. 2 times. Mrs. David, Hopkins, both testified that this happened. The second time that it happened, there's testimony that both the Anderson's son-in-law, who they tossed under the bus on the trash, and the daughter were there. Why were they not called? There's no rebuttal. They know these things were said. They're trying to distract. They want to say, why didn't you call the police? They criticize them when they do call the police, and they criticize them when they don't call the police. There's a lawsuit. They're in the midst of a lawsuit right now. Mr. Shostak. Mr. Shostak didn't just testify. You remember, he's got the blue area, he's got the green area that is comparable, and the red area that's clear. He didn't just testify that, oh, this is just what the back of the David property looks like because somebody planted it. He said, yes, I did look at other areas. Yes, it's consistent with the pattern in these other areas. So it's not just like, oh, somebody created a secret garden that stayed just on the David property. No, it's consistent with other areas. And you can look too, his green box that he has, you can see it kind of tips over the property line. So it's on both the David and the Anderson property. And again, you heard him say that some of the vegetation had started to grow back in that area that was cleared. So it's not just some plantings that were done on somebody's property for a particular reason. This is what the woods look like in that area. You had testimony about the equipment and the stoves and whatnot. They want to now make a big deal that there were no pictures. They didn't refute when Hopkins testified to those. They did not rebut that. He told you what happened. There's no need for pictures. So I just want to remind you, and I don't get the last word, and you heard Miss Medwick, what she was telling you is, Casey, don't get up, right? Don't get up. But I want to remind you is that this isn't about the last word. I do agree with her on, this is common sense. You've heard the testimony. Why is she saying actions speak louder than words right now? Is because we know the words that have been used in this case. And we know the impact of those words. And we know what it was intended and designed to do. And we know that it did in fact do that. And she says, well, they still use the easement area. No, there has been evidence that yes, people are still going out there. What did they all tell you? Mr. David, I would use it more, but I don't like it. It's uncomfortable. Even Hopkins, who goes out there the most, said about the way it makes him feel when he's out there. It's uncomfortable. It's always lingering in my mind. I've got to be on guard. Is that how you should act when you're using what is rightfully yours to use? So that is a clear material interference with easement rights. So again, just in closing, it's not about the last word. Use your common sense. You have heard all the evidence in this case. And I trust that you can do it. Thank you for your time.
All right, that will be our plan. When you are ready, Mr. Edwards, please begin.
All right. Thank you, Judge. Thank you, ladies and gentlemen. I know y'all want to get out of here desperately. We want this case over. Believe me, we all want this case over. And the way to do that, I'm going to walk through the jury charges, not in great detail. I'm going to show you what to do on the verdict form to bring closure to this dispute. And the number one way to bring closure is to find in our favor and extinguish this easement. Because if this easement continues to exist, we're going to be here again and again and again. We all know this. We all know it. I want to respond to a few things that Ms. Sturm said. And one thing that the first thing she said was, case involves an easement, but the one piece of evidence they didn't introduce was the easement. Well, the reason for that is simple. As Judge McBurney will tell you, construction of this easement is an issue of law for him. It's not your job to read that easement, try to figure out what it means. It's his job. He's going to tell you what the easement means. And Ms. Sturm also said this, and I don't know if it was an intentional pause or just a pause. But she told you the judge is going to charge you, and she paused. There is no adverse possession. That's not what he's going to charge you. He's going to charge you that whether there was adverse possession for 20 years is for you to decide. Not Casey Sturm, not the judge, not me. That's an issue of fact for the jury. Y'all get to make that decision. He's also going to charge you this on the issue of abandonment. Ms. Sturm said something along the lines of, there's no such thing as abandonment by mere non-use, no matter how long it is. But what Judge McBurney is going to tell you the law is that for adverse possession, there is a, for abandonment, there is a presumption of abandonment based on non-use for 20 years. It can be rebutted, but there is a presumption. And by my math, 1996 to 2020 is more than 20 years. So we have those few things. I also want to kind of respond to one theme that has been stated in response to, our joke around the office. What do you call people who threaten a lawsuit? You call them a defendant. Well, what Ms. Sturm wants you to think is that I'm the reason we're here. She wants you to think that they were just trying to get along. And then all of a sudden, the Andersons lawyered up. She refers to an email that he sent in October. Talking about Andersons are lawyering up. You're going to get all these exhibits, including my attorney's fees. And you're going to see my very first entry, March 26, 2021, after the TPO had been served on Tracy Anderson. That's my first entry. You're also going to get their attorney's fees. That big old, it's this one right here, this big old thick thing, right here, Defendant's Exhibit 35. You're going to get to look through those and do all sorts of ciphering. The very first entry by Ms. Sturm is January 4th, 2021. January 4th, 2021. And then this is very interesting. Sometimes, most of the time, we've done all this discovery, depositions and documents, and we know all the facts. Sometimes lawyers get surprised during a trial. I got surprised because I got that exhibit as Mr. Showstack was taking the stand. And I was going through it with my highlighter and my little sticky flag. This is interesting. If I'd have known this on Monday, it would have been in my timeline, believe me. February 22nd, 2021. Receive, review, and respond to email communications from JND, Jean-Noel David. Something's going on here. Something's going on. Something is going on that makes the Davids want to reach out to Casey 2 days before this incident. Now, we don't know what was said, but y'all can use your common sense. And that's one area where I actually agree with Ms. Sturm. You do not check your common sense at the door. Use your common sense. Activities going on. They're probably talking about the activity and talking about how the Davids respond to that activity. Like maybe if you see workers out there, go up there and tell them to stay off of your property. Stay off your property. Which we've got different stories as to what happened. We've got Tracy Anderson says, I was in my basement office. I heard her yelling at my workers, heard her threaten to call the cops. Mrs. David says, oh, it was a very pleasant conversation. Pleasant conversation with this man who does not speak English. I got his card, called his boss, very pleasant. Nothing really. Claire Anderson testified, and the one person who has taken this stand, who has absolutely not been impeached or attacked for anything she said or has done in this case, is Claire Anderson. What did Claire say? She didn't hear everything, but she saw this landscaper, this Mexican guy come up and he was just frantic. He was scared to death. Does a landscaper appear scared to death if he's had a very pleasant conversation with Stacy David and given her his boss's business? No, that does not make sense. And then Tracy gets this phone call. He's very mad. When he sees her, he goes out there to talk to her. And he tells her, don't yell at my workers. Don't tell them not to do my work. And then we have a dispute. According to Tracy, she says, you're a horrible man. You've had multiple wives. According to her, she was very peaceful, didn't say anything, waited until he called her a fat so-and-so and told her she was going to die and all these other horrible things. And then her reaction was, well, you're certainly a gentleman. No, that didn't happen. And then also, when you look at Miss Sturm's billing records, there's a whole lot of communications on that day. But then you look at her billing records for March 8th, travel to and from site inspection. Why does she need to go out to look at easement 2 if all they're working on is this horrible, vicious verbal assault by Mr. Anderson for which they're working on the TPO? No, that doesn't add up. Don't check your common sense. They are building their counterclaims, which they didn't intend to be counterclaims. They intended to be the plaintiff and going first. And then March 11th, Casey Sturm, identify appraisal expert, Mr. Showstack. They're wasting no time whatsoever building this lawsuit. So any of these suggestions that I'm to blame for being here, no. And then you continue on. You get into April 1st. This is page 6 of Exhibit 30, Defense Exhibit 35. April 1, receive, review email communications from Randy Edwards. Talk to Randy Edwards. So she and I are talking for the better part of a week. She's building a lot of time for talking to me. Can't tell you what was said, but I think you get the gist. Those communications are why we filed the lawsuit, because we knew that we'd be here. So yeah, we filed suit first. We beat him to the courthouse. But make no mistake, if it wasn't, and if y'all, hopefully not you, y'all, if it wasn't Anderson versus David, it would be David versus Anderson. Plain and simple. That's the truth. No question about it. And let's talk about the nuisance. The nuisance is, so we're clear, the nuisance that we are complaining about are those nets, those big, ugly, bold ribbons, all that stuff. And this isn't a case, Ms. Sturm tried to tell you that what they're arguing is if your kids go out in your backyard and play volleyball, it's a nuisance. No. We're not saying that. We're saying if your kids have a big old huge backyard, but instead they come over to my property, that's a nuisance. That's a nuisance. And that didn't start until August 12th. And you'll see Ms. Sturm's email communication. You remember Mr. David was sitting right here. I asked him if he was aware of these email communications between Ms. Sturm and I, where our side was trying to de-escalate antagonism between the parties. No, don't know anything about it. Didn't know anything about it. Well, when you look at her records, there's multiple emails to and from Jean-Noel David and Stacy David on August 12th. Everybody's in the loop. Everybody's in the loop. The last entry on page 17, a call from Stacy David. Wonder what they're talking about. Maybe these nets. Top of the next page, call and discussion, name redacted. Also, by the way, they objected to my attorney's fees being redacted. You know, goose gander, ladies and gentlemen, look at theirs. There's a redacted. So, make no mistake. We beat them to the courthouse and they're mad about it. They're not mad about being sued. They're mad that we beat them to the courthouse. So the judge is going to charge you that abandonment is non-use plus evidence of intent to abandon. The non-use, and you're talking about use. This occurred to me last night because I was driving home at 10 o'clock at night, pulling in my garage, and I thought, you know, my next door neighbor's got a beautiful backyard. Got a swimming pool, a fire pit. Do I use that by looking at it? No. When he has me over for drinks or burgers, yeah, I use it. But just looking at his beautiful backyard from my deck or my upstairs window, that's not using his backyard. That's what they want you to think. Using is to actually do something with it actively, active use. You can't sit there and think, oh, that's beautiful and peaceful. That's not use. That's not use. But that's for y'all to decide. That's for y'all to decide. So in the verdict form, the first thing is verdict. We find that easement 2 was or was not abandoned. Heck yes, obviously. We find that easement 2 was adversely possessed. Adverse possession means that it was enclosed and used adversely to the owner. So when we talk about the adverse possession or the enclosure, here's an exhibit that you're going to take back with you. This is exhibit 22. These are these Google Earth Street View images. And the great thing about this is you have the dates. The picture was taken up here in the left-hand corner. And the first one, first page, was August of 2012. You see easement 2, it's completely overgrown, impassable. You can't use it for ingress or egress. The second page is from August of 2014. It's a more direct front view. Completely impassable, overgrown. You can't use it for ingress or egress. Third page. This is, let me get my readers. This is October of 2018, a couple of months after the Andersons bought the property. And you can see easement 2 is completely overgrown. And you can see this, the grass and the ivy kind of come up here to the front step in the walkway where these railroad cross-tie walkways are. That's November of 18. This is very interesting. The next image, page 4 of this, is from November of 19, roughly the same angle. Anderson's been there for a year. You'll be able to take these back with you and look at them up close, but when you do, you'll see, if you compare them side by side, the grass has been extended considerably farther than it was. The ivy's been picked up. It's been cleared. So for Ms. Sturm to say the first time they've heard any evidence that the clearing occurred before the Davids bought the property, she must not have seen this exhibit that was used in depositions. Because this is objective photographic proof that the easement had been cleared to some degree long before the Davids ever bought the property. And then the final page of this exhibit, this is a more direct shot from the street. And again, it's completely overgrown the easement frontage. So when we get to the questions of adverse possession and abandonment, you need to check yes on both. On the issue of nuisance, let me tell you what the law is, what Judge McBurney is going to tell you about nuisance. He's going to read the actual law, and I've got it here. Nuisance. A nuisance is anything that causes hurt, inconvenience, or damage to another. The fact that the act complained of may be lawful does not keep it from being a nuisance. So you heard Mr. David say, it's our lawful right to use this trail. Well, true, but that does not mean it's not a nuisance. If you go out, like I said, first line and open, if you go out of your way to intentionally annoy and harass your neighbors, that's a nuisance. These big bold ribbons, these nets are there for one reason and one reason only. It's not because Hopkins loves it. It's not because Hopkins thought of it. It's a big double middle finger salute to Tracy Anderson. Why? Because he got mad, got provoked, and made a mistake and did something that he regrets to this day. That's why we're here. And when we're trying to de-escalate tensions, they're saying, no, sir, turn it up, turn it up. And I'm not going to talk about their claims much other than credibility of the witnesses, because Judge McBurney is also going to charge you that the credibility of the witnesses is for you to determine. You may consider all of the facts of the case, the witness's manner of testifying, the probability of their testimony, their interest or lack of interest in the outcome. In considering credibility, you may consider evidence offered to attack the witness's credibility. This can include evidence of prior inconsistent statement and/or bias. May also be attacked by disproving facts to which a witness testified. So in terms of credibility, I'm a father. If a crazy man is waving a gun near my daughter and I'm not there, she calls me, I'm gonna tell her, Mary, get the H out there. Mary, I'm on my way. I gotta hang up because I'm calling the cops. That's what a parent does. If it happened and if you're really scared. That's what people do. What they did, according to them, is they didn't tell him to leave. They didn't call the cops. They called their lawyers. That's what the Davids do because, as Kristen said, Mr. David says that's why we have lawyers. No, if your kid's in danger, you call the cops. And this racial slur that now Ms. Sturm is just calling a racial slur, she didn't hesitate to use it in opening. Mrs. David didn't hesitate to use it on the witness stand. She claims to be just horribly humiliated and terrified from that. But if she's so humiliated and harassed, why was she so comfortable sitting here in this chair and using that term loud and proud? Not once, not twice, not 3 times. I was keeping score of them. She used that term 4 times in a minute or two. Why? Why? Because they know that is such an explosive term that they hope you will hold it against the Andersons. Well, again, if that really happened, there'd be a lot more evidence. There'd be a call to the cops, because that is a crime. That's disorderly conduct, making racial slurs to 2 or more people. That's a crime. They'd have called the cops. They'd have filed another temporary protective order. They'd have done all sorts of things. What they do? Call the lawyers. Call the lawyers. And Tracy Anderson pointed out, Tracy, when's the first time you heard about this? 2 days after the Georgia Supreme Court ruled against me. What a coincidence. What a coincidence. I'm being facetious, of course. Don't check your common sense at the door. That is a false made up 100% reprehensible claim that they would come in here. They know they can't win this case on the facts or the law. So what they have done from day one is a total character assassination of this man, because he made a mistake that he admits and he regrets and he's apologized for over and over and over again. But that's not good enough. That's not good enough. So at the end of this case, ladies and gentlemen, the judge is going to instruct you, you're going to get this verdict form. We want you to check yes to extinguishment on both abandonment and adverse possession. We want you to check yes on the compensatory damages for nuisance. The measure of damages is your enlightened conscience. Is that 5,000, 10,000, 50, 100? It's whatever y'all agree to. And the judge is also going to get in dry mouth. The judge is also going to instruct you on what we call a quotient verdict. That's where y'all decide, everybody write down a number. We're going to add it up and divide it by 10. That's our number. If you agree ahead of time, you can't do that. But if you agree, we'll do that and use it as a starting point, and then you'll say, well, that number's too high, that number's too low, let's adjust it. That's fair. You can do that. So we want you to use your enlightened conscience and come up with a verdict in our favor for compensatory damages. And remember, it's been going on for 2.5 years, since August of 12. 2.5 years of this constant double finger salute of we're going to do whatever we want because we have the legal right to do so. And then on the trespass for the workers, I guarantee you we would not be here if that was the only claim. If you want to give us a little bit more money on that, that's fine. If you don't, that's fine too. Again, we've proven it. Measure of damages is up to you. Whatever you think on that is fine. But also the punitive damages, check the box yes on that, and the attorney's fees. Because the judge is going to instruct you on attorney's fees. If a party acts in bad faith in the underlying transaction, you can award attorney's fees incurred as a result. The bad faith in the underlying transaction is us trying to say, time out, time out, time out. Stop these nets, stop these clearings, stop this, stop that, and basically build 5.3 hours on that day. 5.3 hours. Mr. David said whatever the advice was, he followed it. That is bad faith in the underlying transaction. And let me talk about Hopkins. Good kid, plays. My daughter went to Lovett. I know that Lovett's got an outstanding lacrosse program. The coach is a friend of mine. He's a freshman, made the varsity. That's pretty dang good at Lovett. That kid didn't want to be here. He didn't want to be here. Y'all saw that. He didn't want to be here. At least he didn't repeat the slur they made up. He knew better than to do that. But seriously, again, check your common sense at the door. Is he really afraid of Tracy Anderson? Is he afraid of Tracy Anderson? No. No, absolutely not. Because even the incident with the gun, he said he went back out there immediately. Seriously? Again, there's no way I'm letting my daughter anywhere near that property ever until this is resolved. But hey, it's Christmas. Everybody's out of school. It's 11 o'clock at night. Hey, let's take this fire pit over there and have a little cookout. Is that what you do when you're Hopkins David? Is that what you do if you're really afraid of this man? No. No, it's not. And the parents of the other 8 kids, can you imagine how furious they would be at the Davids if anything bad happened to their kids? And they said, well, yeah, we knew he was crazy. It didn't happen. They're not afraid of it. This is made up. This is made up, ladies and gentlemen. So let me just wrap up and say this, kind of to echo what Kristen said at opening. She said, actions speak louder than words. You know, in my younger days, I played football. I always quote my coaches. One of my coaches used to say that what you do speak so well, I don't need to hear what you have to say. That's exactly the same thing. What they do speaks so loud, we can't reconcile it with what they say. Because you're going to see pictures of little trivial things that supposedly bother them. The picture of the fence going up, the picture of the worker on this side of the fence, the picture of the trash in the dumpster. Those are trivial matters. What you're not going to see is a picture of this beautiful, lush landscaped easement when we bought it or when we walked in. What you're not going to see are pictures of the surveillance camera pointing at my daughter's window. You don't see that. And most importantly, you heard Mrs. David say, talking about her surveillance system. They've got a Ring camera system around their house. They have a Ring camera above their carport, which faces easement area 1, the parking pad, which is where she and Hopkins were allegedly standing when all this slur took place. Why didn't they go in there and check the video and the audio and say, say this? Because it didn't happen. It did not happen. And just finally, another thing that popped up, why didn't we hear from the witnesses? We explained, you heard testimony that it was the Anderson's daughter and son-in-law who were witnesses to this. Why didn't we hear from them? Well, the reason we didn't hear from them is simple. We never heard this story until y'all did. We never heard who the alleged witnesses were. We didn't know it was Holly and Will until it came out of Mrs. David's mouth. And Claire told you they've moved to Washington, D.C. So what are the odds that when the time that we heard that come from Mrs. David, I don't know, 12 o'clock yesterday, we're going to say, get on the phone, hey, Holly, Will, get on the plane, be down here in the next 30 minutes. Crazy. So ladies and gentlemen, at the end of the day, which is very simple, y'all need to stop this. You need to stop this. Find the easement extinguished. Find in our favor on the nuisance claim. Award some measure of damages and award attorney's fees. And if you think that, well, Mr. Edwards, we shouldn't give you fees from March and April and May, fine, you got my statements. Cut out everything from March 26th to August 12th or August 11th. That's when that's when they hatched the idea of this nuisance. So that's fine. Ladies and gentlemen, I apologize for being here. We shouldn't be here. I recognize that. We should not be here. But we're here for one reason and one reason only. As I said at the end of my opening, it's that incident on February 24th, 2021. That is not a captive crime. Was it rude? Yes. We need to stop this. Thank you.
Thank you, Mr. Edwards. So, ladies and gentlemen, my thought is I just give you charge now and then you go ahead and order. This went a little faster than I anticipated. But if you want to revert to what we had discussed, let's do this. Deputy Gordon, do you mind playing the role of moving that screen? So the jury charge that I'm going to give you is the law that you must apply to the case. I'll tell you a couple of things about it. It's this document. You will have this with you during your deliberation, so you should feel free to take notes. There are some legal concepts in Georgia that I am required by the law to describe in a way that when you hear it, you're going to say, why are you talking this way? That's not how people talk to each other. It's very legalistic, but there are higher courts that have said, here's how you must define X. And so I'm bound to use those words. But when I am able, I try to make the jury charge accessible to me and to you, because you need to understand it, because you have to apply it. To aid in that, I will be reading it to you out loud as I must. What I'm reading to you will also be on that screen there. I have put it in a PowerPoint. I'm just sort of clicking along as I read this to you. Feel free, like I said, to take notes, but this document will be with you word for word. So you will absorb it as you see fit. Let me put it. All right, so to say jury charge, big letters, and you just move new words.
Yes.
Excellent. All right. So without further ado. Ladies and gentlemen, you have been considering the case of Tracy Anderson and Claire Anderson versus Stacy David and Jean-Noel David. The plaintiffs filed this suit for trespass, nuisance, adverse possession, and attorney's fees. The defendants have answered these charges by denying liability and bringing their own counterclaims for interference with easement rights, trespass, conversion, and attorney's fees. As you know, this case is about an easement, easement 2, that burdens the Andersons' property and benefits the Davids. The meaning of the terms of the easement is a legal question for me to answer. What follows is my direction to you about the meaning of the language of easement 2. Easement 2 allows the Davids to use the easement area for any legal purpose whatsoever. They may use or build on it in any manner they wish, consistent with local and state law. The Andersons may not materially interfere with the Davids' use or enjoyment of their easement. However, the Andersons, as owners of the land burdened by the easement, are free to be on and use the easement land, so long as that use does not interfere with the David's use or enjoyment of the easement. I'm going to give you an example. This didn't happen in this case, so this is purely hypothetical. The Davids could build a koi pond on easement 2. That is something that's allowed by the law. I'm telling you it's okay to build a koi pond. They stock it with koi. They love their fish. They like the pond. When they're not on the easement 2, admiring the koi, the Andersons are free to go on to easement 2 and similarly admire the koi or ignore the koi, but not disturb the koi. What would be inappropriate would be for the Andersons to fish the koi and grill the koi on the grill we heard about and eat them and take away all the koi. That would be something that materially interferes with the Davids' use and enjoyment of their easement. They decided to put in a koi pond, which they can do, and they stocked it. The Andersons can come enjoy it as long as there's not interference. But if their way of enjoying it was spearfishing the koi and eliminating all the koi, that's something that you could find would be materially interfering with the David's use or enjoyment of their easement rights. Hypothetical, not this case, not suggesting there's any evidence of any koi or pond in this case. The plaintiffs must prove their claims by what is known as the preponderance of the evidence. That is, evidence that is sufficient to incline, think of those scales, a reasonable and impartial mind to one side of the issue rather than the other. Now, as I've mentioned, the defendants have filed what we call counterclaims. The defendants claim that the plaintiffs owe them instead of the defendants owing the plaintiffs. The defendants must prove their counterclaims, if they are able to, by the same preponderance of the evidence. If neither side proves their case by a preponderance of the evidence, your verdict would be in favor of the defendants without any monetary recovery. Evidence is how facts are established or proved. Evidence includes all of the witness testimony you've heard think there were one or two pieces where I said disregard that, continue to disregard it, but 99.9% of the testimonial evidence is for you to consider, along with the exhibits that have been admitted. And Mr. Edwards is holding some up. Those will go back with you to look at pictures, videos, etc. For the videos, we don't actually hand you the videos, but if there are videos you want to watch again, you just send me a note saying we want to watch that video that showed Hopkins playing lacrosse and interacting with Mr. Anderson. We'll press play and you'll get to watch it again. You'll just come out here to do that. Everything else will be back there with you. Evidence does not include opening statements, or closing arguments, any questions asked, or anything else the attorneys or I have said. Now, during trial, you were permitted to submit questions. The answers to those questions are evidence. You should draw no conclusions or inferences from the fact that some of your questions were not asked. Questions are not evidence, only answers are. And importantly, in considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. Now, evidence may be direct, circumstantial, or both. An example of direct evidence is the testimony of a person who asserts that she has actual knowledge of a fact, like an eyewitness. I saw the car run a red light and collide with the other car. I saw it. Circumstantial evidence is proof of one or more facts that tend to prove some other fact by inference. I saw all these people walking in this courtroom, they had umbrellas, they were wet, but we can't tell that it's raining here, there are no windows. You could infer circumstantially that it's raining out because everyone's coming in with umbrellas and they're wet. There's no legal difference in the weight you may give to either direct or circumstantial evidence. And you should not be concerned about whether the evidence you're considering is direct or circumstantial. Testimony has been given by a witness who was designated as an expert. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not familiar to the average person. Expert witnesses may give their opinions based upon that training and experience. Testimony of an expert, like that of all witnesses, is to be given only the weight and credit you think it should receive. You must determine the credibility or believability of all the witnesses who appeared before you. In doing so, you may consider all the facts of the case, and you've got all of them now, the witness's manner of testifying, the probability of their testimony, and their interest or lack of interest in the outcome of this case. In determining credibility, you may consider evidence offered to attack a witness's credibility. This can include evidence of a prior inconsistent statement, something in a deposition, and or bias for or against a party to this lawsuit. Credibility may also be attacked by disproving facts to which a witness testified. Easements. An easement is a property right. It allows someone who does not own property to access or use that property. An easement holder cannot be deprived of his right to use the easement so long as he is using it consistent with the terms of the easement. Reasonable enjoyment of an easement means enjoyment of the easement as the easement is defined. The owner of the property burdened by the easement may not interfere with the easement holder's reasonable enjoyment of the easement. An easement is not extinguished merely by non-use. There must be clear, unequivocal, and decisive evidence of an intent to abandon an easement. Where an easement is acquired by grant or deed, that's what happened in this case, there is no duty on the easement holder to make use of the easement in order to retain the easement. Mere non-use of the easement, no matter how long, will amount to abandonment. The fact that an easement holder does not immediately begin to use the easement, or that he delays for several years, does not result in loss of the easement. However, non-use of an easement for over 20 years, should say at least 20 years, may give rise to a presumption of abandonment, although that presumption can be rebutted. The owner of the land burdened by an easement may not materially interfere with the easement holder's right to use or enjoy that easement. Such interference, if proven, is an intentional tort. Trespass. A trespasser is one who goes upon another's land without permission. A party can be liable for trespass if he has requested or directed that another commit the trespass. A trespass is also, so this is a different definition of trespass, is also any wrongful interference with someone's right to the use of property, such as an easement holder's right to enjoy use of property. No proof of actual injury to the land or diminution in the property's value is required to maintain an action for trespass. And trespass is an intentional tort. Nuisance. A nuisance is anything that causes hurt, inconvenience, or damage to another. The fact that the act complained of may be lawful does not keep it from being a nuisance. But this inconvenience or hurt that's complained of cannot be fanciful or something that would affect only someone of extraordinary or demanding taste. It must be something that would affect an ordinary, reasonable person. To constitute a nuisance, the act complained of must produce actual, tangible, and substantial injury to neighboring property, or interfere with the property's use and enjoyment by persons of ordinary sensibilities. Nuisance is also an intentional tort. Adverse possession. Adverse possession is the right to property that a possessor acquires by way of continuously possessing the property or property right for 20 years. In order for someone to claim adverse possession, that possession must A, be made by the possessor, the person claiming it, not by some third party. B, not have originated from any fraud or trickery. B, that possession must be public, continuous, exclusive, uninterrupted, and peaceable. And finally, D, that possession must be accompanied by a claim of right. Actual possession of land may be evidenced by enclosure, cultivation, or any use and occupation of the land that is so notorious as to attract the attention of every adverse claimant, and so exclusive as to prevent actual occupation by another. This is your shortest slide. Conversion. When someone wrongfully asserts control over another's personal property and deprives that person of possession of the property, it is a conversion. Agency. The relation of principal and agent arises whenever someone authorizes another to act for him, or later approves the acts of another taken on the principal's behalf. The principal is bound and responsible for all the acts of his agent, taken within the scope of that agent's authority. However, if the agent acts outside the authority given by the principal is not responsible. Before one can be bound by the acts of another who assumes to represent him, some proof of agency must be shown. You must determine the issue of agency in light of all the facts and circumstances of this case. The next few slides are about damages. Damages are given as compensation for injury. When one party is required to pay damages to another, the law seeks to ensure that the damages awarded are fair to both parties. If you believe that the Andersons or the Davids are entitled to recover, you should award them only the amount you believe is reasonable and just. A party seeking damages bears the burden of proving those damages. Damages must be proven with reasonable certainty. You may not award any damages which are speculative or based upon guesswork. Damages for a continuing nuisance or trespass are not limited to those that have occurred prior to filing this suit, but may also be awarded for damages incurred during the pendency of this case. In a nuisance and in nuisance and trespass actions, there may also be recovery for damages to the person. The determination of damages for discomfort, the loss of peace of mind, unhappiness, and annoyance caused by trespass or nuisance is for the enlightened mind of the jury to decide. That would be one of those legal phrases I'm required to say. I think your minds are very enlightened, but I wouldn't normally say that. But the cases say it's your enlightened mind that must decide. So don't be unenlightened in the jury room. You get stuck. Nominal damages. If the injury is small or mitigating circumstances are strong, only nominal damages are given. The proper amount of nominal damages is for you to decide. Punitive damages. In some cases, there may be aggravating circumstances that warrant the awarding of punitive damages. Before you may award punitive damages, a party must prove that the other party's actions showed willful misconduct, malice, or that lack of care that would raise the presumption of conscious indifference to consequences. And this must be proven by a higher standards, clear and convincing evidence. So I want to say that this is a different and higher burden of proof than a mere preponderance. What that means is evidence that causes you to firmly believe each essential element of the claim to a high degree of probability. This isn't the scales tilting just a little bit. You're going to decide how much the scales tilt, but it's as far as it takes for you to believe in the allegations to a high degree of probability. Punitive damages, when authorized, are awarded not as compensation, but solely to punish, penalize, or deter. The expenses of litigation are generally not allowed as a part of damages. However, if you find that a party has acted in bad faith, or has been stubbornly litigious, or has caused the opposing party unnecessary trouble and expense, you may award attorney's fees. This bad faith concept that must be proven is bad faith relating to the underlying transaction, i.e. the alleged trespass, nuisance, etc., and not bad faith during this litigation. An award of attorney's fees and expenses of litigation is authorized even when only nominal damages are recovered. Ladies and gentlemen, by no ruling or comment that I have made during the course of this trial have I intended to express any opinion about the credibility of the witnesses, the strength of the evidence, or which party should prevail in this case. My only interest in this case is to see that it is fairly presented according to the law, and that you, as honest, conscientious, and impartial jurors, consider the case as instructed and return a verdict that speaks the truth. One of your first jobs will be to select a foreperson who will preside over your deliberations and who will sign the verdict to which you must all freely and voluntarily agree. You should start your deliberations with an open mind. Consult with one another and consider each other's views. Each of you must decide this case for yourself, but you should do so only after a discussion of the case with the group. Whatever your verdict is in this case, it must be unanimous, in writing, dated, and signed by the foreperson. And we do have a verdict form, so you'll have something to fill out. It poses the questions you need to answer, and your foreperson in the end will sign it saying, we all agree to this. Your verdict should be based upon your opinion of the evidence according to the law that I have been giving you in this charge. You must consider the evidence objectively, without favor, affection, or sympathy to either party. Now, if you find that, this slide should be entitled quotient verdict. It says that on the charge if you get. If you find that a party is entitled to damages, you must determine an amount to be awarded. It is improper to agree in advance to be bound by the figure that is calculated by each of you before you've deliberated it all, writing down a number, adding it together, and dividing by 10, averaging out the damages. That it'd be an improper calculation of damages. However, if you wish to use this method to arrive at an amount for discussion without binding yourself to accept that result, you may do so. You are not prohibited from accepting that result and adopting it as your verdict if you believe, from a preponderance of the evidence, that the figure arrived at by this method represents just and adequate damages. However, you must first have found that the party is entitled to damages, and you must all agree that that amount represents your verdict after the amount has been determined. During your deliberations, you must not communicate with anyone outside your group. This is nothing new. It's how you've been rolling so far. Nor may you conduct any outside research. You have all the evidence in this case. If you feel like something is missing, that's what you're doing, this whole weighing the evidence on the scale. If you wish there was something more, maybe someone hasn't met their burden of proof. Don't supplement the evidence by consulting an electronic device. In fact, I'm going to help you with this because Deputy Gordon will be collecting all your electronic devices, and we will hold on to them, including Apple Watches or equivalent, while you are deliberating. I promise you get them back, but we keep them while you're in there deliberating. Ladies and gentlemen, last slide. During your deliberations, should you need to communicate with me for any reason, question, concern, it's not the pizza we ordered, it has to be in writing. Write it down. You can put it on one of your pieces from your notepad. You can take some of those cards back with you. Deputy Gordon will bring me that question, concern, note, whatever it is. I'll share it with the lawyers, and I will answer as I am legally allowed. And I add that last bit because sometimes you will have a great question and I have to write back, you're going to need to sort that out yourselves because the law doesn't let me answer that one for you. That's what you're supposed to do. If your question was, well, hey, who should win this case? Hey, come on, you figure that out. It's usually not that, but it's sometimes, well, we don't understand. What does trespass mean? And I'm going to say, read this because I've told you what trespass means. And if this didn't work, shame on the judges, but this is how we define trespass. I'm not trying to dissuade you from asking a question. Go ahead and ask, but just don't get frustrated and throw something at us when you come back in. If the answer is you'll have to rely on your collective recollection, or this is something for you to work out. Plenty of times I can say, great question, here's your answer, and I'll put something in writing. Or if it's sufficiently complicated, the lawyers may say, bring them back out here, and I want you to recharge them, read this again, or supplement the charge in a way that we all agree. That's it. Thank you for listening. I need to talk with the lawyers about a few things to make sure we get all the evidence together to push back to you all. Don't begin your deliberations until you get that stuff. So put in your lunch order now. I'll take logistical questions in just a second, but go back there while you still have your electronic devices, put in your lunch order and get that going. Deputy Gordon will bring you the evidence. It'll have this jury charge, it'll have this verdict form and everything that is for your consideration back there. That's when you start your deliberations. Right now, you should deliberate on what you want on your pizza, whatever it is you're going to order. Did you have a logistical question?
Well, I just had a question about evidence. Would we get a copy of the the transcript or no?
No, you may recall, I said several times about note taking, no transcripts of testimony, which is why we give you the notepads. But we don't have transcripts of witness testimony. That's where you get the note. You'll have to rely on your collective recollection. Hey, what did that arborist guy say about Richmond Fuzzy something? There was that plant with that funny name. You're going to have to remember, or maybe it's in a report that you have and you'll find it in exhibit, but no transcripts. The videos that were played can be played again because those videos are exhibits. We'd like to see exhibit 12, or if you don't remember the number, don't fret. Just that video that had X in it. And if that's something you need to see again, we will make it happen. Okay. Other logistical questions? All right.
The jury only deliberated for a short time after lunch that day, and then they came back with a verdict. However, the only information we got at the time was that the Davids won. It wasn't until about a week or two later that we actually received the breakdown on the jury verdict form, and this is what they found. On count 1, Easement 2 was not considered abandoned by the Davids. Easement 2 was not adversely possessed by the Davids. The Davids did not trespass against the Andersons. The Davids' use of the land on Easement 2 did not constitute a nuisance. The Andersons, as a result, were awarded $0 in compensatory damages. The Andersons were awarded $0 in attorney's fees and expenses. The Andersons are not entitled to punitive damages. The Andersons did interfere with the easement rights of the Davids. The Andersons did not trespass against the Davids. but the Andersons are liable for conversion. As such, the Andersons were awarded $43,665.75 in compensatory damages, and they were awarded $296,685.05 in attorney's fees and expenses. The Davids were not entitled to punitive damages. And can't we all just get along? A decision had already been made by the appeals court in this case, and the reason why it was confusing is why did the appeals court make a decision if we're watching the case right now? And the reason why is it was a motion for partial summary judgment. The trial court found on the behalf of the Davids and granted them the summary judgment. The Andersons appealed to the appeals court, who found on behalf of the Andersons, sent it back to the trial court so that it can go to the jury for decision. The appeals court issued a written decision which said, the trial court said that construction of the easements in this case is a question for the court, meaning the lower court, the jury, which is why it was denied and was sent back to the jury. And in this case, they actually went back and they considered the issue de novo instead of reviewing what the trial court's findings were and what the reasoning for their findings were. And in this, they actually looked at the text of the easement agreement itself, saying that they found it to be valid and stood on its face, and that the fact that it was to be exclusive and perpetuity meant that it carried over to the Andersons after the sale of the property, especially since it was mentioned in both of their deeds. So the trial court denied the Andersons' motion for partial summary judgment and granted the Davids' motion. The Andersons appealed to the appeals court, who reversed that decision. The Davids then appealed to the Georgia Supreme Court, who declined to hear the case, which happened during the course of our trial. Now, since the trial, the Andersons have filed a motion in Judge Burney's court for a new trial. However, I'm unable to show you the exact documents other than this first page right here because the Fulton County system was hacked. The hack occurred in January of 2024, and the hackers posted a ransom notice that indicated explicitly that the county had been hacked, critical systems were down, but the Trump case and elections computers were safe. There was a second message that said they would release a large amount of information if their demands were not met. Fulton County said the group called Lockbit 3.0 began shutting down its computers, and everything got screwed. Payments, HR systems, even phones. Over a month later, the county only had about a third of its phone system back up and running. However, they said they were not going to bow to the hackers. While the county assured that everything would be fine, people who actually saw the page on the Onion page said that the amount of information was pretty bad. The hackers posted 25 documents to show a sample of what they were able to download in the days and weeks before crashing the computers. Those screenshots included the county's VMware access pages, along with the identities of users with access credentials, a complete file folder list for the county, a random file list from within the folders showing insurance and risk management files, a judicial order sealing a medical record, purchase orders for Apple equipment and files on some Apple iPads, apparently, and backup files on Apple Computer, a sealed record related to a child abuse case, a sealed motion on the murder trial of Juwan Gaston demanding the state turn over confidential information, informant identities, an evidence list from the Atlanta Police Department showing a list of guns and drugs, the first page of an investigator's report given to the grand jury on the jail death of Monte Stinson. Stinson's family had repeatedly complained about being unable to obtain information from the county about his death. There was records showing the county's investments in its pension fund, a file list from the district attorney's office showing case files in murder and gang cases. Wonder if Fulton County has any, ongoing gang cases. An Excel spreadsheet showing configuration data for the county's servers, and an APD, Atlanta Police Department incident report, as a PDF, which indicates that the hackers have access to individual files attached to cases in the county's Odyssey system. That's the system that you log onto to access the dockets, the case history for every case that includes every case file, every filing in every case in the county. This hacking group is quite prolific. They are responsible for more than a dozen recent attacks as far away as an Indian brokerage firm and as close as Bank of America's partner info system, McCamish Systems. The confidential material also includes the identities of jurors serving on the racketeering trial for Young Thug in the YSL case. A fun fact to top this off is that the county spent over $425,000 on an account management software, $190,000 on antivirus software, and $15,000 for encryption software. Oh, and another $300,000 on the consultant who recommended all that. They went on to brag about how safe their cybersecurity was. This is all over the past 2 years. So, yeah, that's great. Stay out of Fulton County, folks. Now, if the Andersons' motion for a new trial is denied, then they will likely appeal the ruling to the appeals court. They'll have to appeal on a specific issue, some error of law or multiple errors of law to take it to the appeals court. That will be a very lengthy process, probably over a year. However, the Davids have already replied to the Andersons' motion for a new trial. I am not able to pull that up. I can't even get the first page of that one. Fulton County is a hot mess. I'll keep trying. Hopefully they'll have the system back up and running. They do at least have the documents back on their own website at this point in time. So I will let you know as soon as I hear anything and I can get these actual documents for you and I will post them somewhere. I'm sorry this isn't a glamorous, exciting update, but some of them are small, some of them are big. We'll take them as we get them. Until the next one. See ya.